And Mr. Nyengenye is in issue. Otherwise, our quorum is as before.
My Lord, I don't understand the basis for the direction being sought from you, because you already gave the direction when we were before you that any
as to the participation of other petitioners insofar as the affidavit by Mr. Kindeki and Mr. Nyengenye is in issue. Otherwise, our quorum is as before.
My Lord, I don't understand the basis for the direction being sought from you, because you already gave the direction when we were before you that any party who desires to cross-examine the witness now on the dock would do two things. First, they would file a reply to that affidavit. And number two, in that reply, they would intimate whether they wished to cross-examine the witness now on the dock. Mr. Ndegwa Njiru cannot now purport to be ignorant of those directions, having not done what you directed should be done by anyone desiring to cross-examine this witness. Then he can't come here and just tell you we seek direction on what other petitioners should do.
Something could be a day, hearted, Thank you for that. The direction which Mr. Raymond has sought. I think directions which were to be given last time are very clear. For you to find or found that this is for explanation, you must have responded one way or another. So if you are final, you can go back.
I'm waiting.
The evidence has been discussed. Passing the matter in question. Nothing but the truth. My name is Dr. Dan Gachaguas. I'm a medical doctor, qualified from the University of Nairobi in 1975. I took a master's degree in internal medicine in the same university. I'm a fellow of the American College of Cardiology that course in the This is a hearing evidence report. So we want to hear what you're saying and record it.
Speak loudly, Dr. Viconyo, so that their lordships can hear you easily. Oh, I see. Can the court? Okay, the court assistant can adjust the microphone.
With the permission of the court, perhaps you could place something under the microphone to just lift it up.
Is that better?
Yes.
Your Honor, again, my name is Dr. Dan Gachaguas. I am a medical doctor, a graduate of the University of Nairobi, 1975. It's 20 years last August. Postgraduate internal medicine, the same university, 1980. Thereafter, fellow of cardiology, and now a member of a fellow of the American College of Cardiologists, trained in Minneapolis, the Mayo Clinic in the U.S. at 1985. Now practicing at the current hospital, previously a lecturer at the University of Nairobi.
Thank you. You have a document titled Affidavit, sworn on 28th April 2026, consisting of 12 numbered paragraphs. Do you recognize this document? Whose affidavit is it?
Your Honor, is mine.
Whose deponent's signature is on page 3 or 5 of that affidavit?
That's Your Honor, mine.
Do you wish to adopt the contents therein as your evidence in this matter?
Your Honor, I do.
Please tell the court whether you are acquainted with any party before these proceedings in a professional capacity. Okay.
Whom I have taken care of. From my records, Your Honor, my hospital records that I do have with me, I have been a doctor to the same Honorable Gachaguas since, if I could, 5:10 p.m. on the 10th of July, 2006.
Okay. When and under what circumstances did you meet the first petitioner, if at all, during the period in issue and relevant to these proceedings?
I believe for the purpose of this issue, you are referring to his hospitalization at the current hospital, which again, from my record, Paddington notes, happened at 3:25 p.m. on the 17th of October, 2024.
And what happened when you met him? What happened next?
Your Honor, the reason for his coming to hospital, the court said he's on the way with chest pain, and we received him and acted accordingly.
From your experience and expertise as a cardiologist, what significance do such symptoms have?
Your Honor, you know, chest pain has two categorizations. There's chest pain that can occur if you have to have a heart attack, medical term called a hyperinfarction. That, when you say you have chest pain in that category, we look at the possibilities of that being real. That's what we call the risk factors. This is a man, his age.
My Lord, with a very kind permission. With a very kind permission.
Katika wakati ambao ni mgumu sana, na tena umekata tamaa kwa maisha haya, changamoto zimezidi, moyoni Mungu kakuacha, usilie, tumaini liko tena. Upo katika wakati ambao ni mgumu sana,
To where the evidence, my Lord, is headed, and in my very humble view, we appear to be expanding the scope of the petition and the affidavit that is before you, Lord. My Lord, it is important that we stick to what is in the affidavit. For purposes of that is why we are here today. If we attempt to then expand it beyond what we agree, then we'll be prejudiced. We'll have to find further affidavits, etc., to be able to respond to the questions that are being raised. We must, I submit, stick to the...
Your final affidavit.
My Lord, if I may respond, I would refer the court to paragraph 5 of the affidavit. Basically, the questions are formulated based on what the witness deponed to. Unless they specifically state exactly what is new, my Lord, we request that you do allow the witness to proceed with his testimony.
Laying a questions does not presume introducing new issues by way of evidence issue. It doesn't mean you then introduce new technical issues that we need to deal with. We will have to respond to.
I think the way forward is you will refer the witness to particular paragraphs.
Okay. You do have the affidavit with you? Okay. Please clarify what you meant under paragraph 5 of your affidavit. And based on paragraph 6 of your affidavit, what role or steps did you take with respect to the first petitioner having been presented before you?
Your Honor, if a man or that lady, this person presents, there are standard protocols that we follow in medicine. We run with that person. In this particular person, my mother again, there was additional risk factors of stress. And stress has brought its own problems of affecting the heart in a condition that we call hypertension.
I refer you to paragraph 7 of your affidavit. Please clarify what you meant in that affidavit on paragraph 7.
Somebody presents his chest pain and has mental disturbance, we are then hospitalized for evaluation to see the extent of the danger that he is.
What examinations did you conduct, if any?
Again, Your Honor, after the apart from the physical examination, the proper history of the circumstances, then we proceed to specific tests. It include what we call a tracing of the heartbeat, or after this called for an ECG, an ultrasound of the heart, for this purpose of layman scan, an image of the heart, and blood tests to check for the heart matter damage. Again, Your Honor, it's all studied.
Madam, very kindly, as my Lord did direct, could we be pointed to specific parts of both the affidavit and the attachments that then align with what the good doctor said, my Lord? My concern is what, my Lord? We, by seeking clarification, we are then proceeding or extending beyond what is contained in the document. It then leaves us in a very precarious position in terms of this.
The doctor is here to give us experts. And we must be able to do that.
Yes, my Lord. Can we clarify, my Lord, beyond that contained in the affidavit?
My Lord, if I may assist the court, the issue being raised is we have a written affidavit, which is sworn testimony. Ordinarily, that would be the evidence in chief. The second issue is that it is trite that where a thing has been reduced to a document, in this case, the affidavit, and the annexures thereto, you cannot, under the guise of examination in chief, purport to add to subtract from, to contradict, or vary. Even if this witness were to spend 2 days here, offering these things now being called clarification, it's just a waste of your time. Section 99 to 101 of the Evidence Act says that evidence is inadmissible.
I've been submitted to make a very brief reply. The rule of objections, as I know them, is that you object to something, objection irrelevant, objection something. There's no specific objection. You're being told that the objections, without a proper basis, we kindly request you to order that the examination in chief proceeds and concludes very shortly. Then my learned friends would have their time to impeach and to do anything lawful with the witness and the stand. Thank you, my Lord.
And so when we proceed with the latitude that those paragraphs in the affidavit gives you, and I think we must understand that we have an expert witness. That's also why we called in an expert. He has come to tell us something we may not know. Therefore, with that latitude, please proceed.
Thank you, my Lord. So what you are referring to was in paragraph 6 of the affidavit?
Your Honor, exactly. That's the premise of the things I've mentioned are in that affidavit. The ECG, for example, the Dr. Junior, the blood test,
Thank you. Please refer to paragraph 4 of your affidavit and annexure marked DKG 3. Annexure marked DKG 3. Can you explain the timings reflected in those documents? Paragraph 4 of the affidavit met the first petitioner, DKG.
That was on the day of admission, which we just clarified just now from my handwritten note of the hospital notes, which was on the 17th of October 2024 at 55.
No, my lord, now the witness is confirming why you're hearing objections. The witness is referring to his handwritten notes, which are not attached to the affidavit.
My apologies, Your Honor. I will not refer them again.
Okay, please refer to paragraph 4 of your affidavit and annexure DKG 3. That annexure is titled Discharge Summary.
I think you should have somebody consistent with that.
Yeah.
But we know exactly what point we are on.
Yes. And there are timings mentioned in paragraph 4 of your affidavit, and there are timings indicated in the discharge summary. Could you explain those timings?
The date of admission, the date of discharge, that is the issue.
Yes.
Your Honor, this is the day of discharge, the day of admission is the time that the patient was having the hospital. As I mentioned earlier, it's written here at 4:18 p.m.
As far as the affidavit by Mr. Kindeki and Mr. Nyengenye is in issue. Otherwise, our quorum is as before.
My lord, I don't understand the basis for the direction being sought from you, because you already gave the direction when we were before you that any party who desires to cross-examine the witness now on the dock would want do two things. First, they would file a reply to that affidavit. And number two, in that reply, they would intimate whether they wished to cross-examine the witness now on the dock. Mr. Ndego Njiru cannot now purport to be ignorant of those directions, having not done what you directed should be done by anyone desiring to cross-examine this witness. Then he can't come here and just tell you we seek direction on what other petitioners should do.
Thank you for that. The direction which Mr. Raymond has sought. I think directions which were we gave last time are very clear. For you to found a basis for explanation must have responded one way or another. So if you have filed an affidavit, I'll allow you to participate. If you have not filed, unfortunately, you cannot go back.
I'm well getting money.
Thank you, my lord. We may proceed. Please state your full name, profession, and your professional qualifications.
My name is Dr. I'm a medical doctor, qualified in the University of Nairobi in 1975. I got a master's degree in internal medicine in the same university. I'm a fellow of the American College of Cardiology.
This attorney is giving evidence report. So we want to hear what they're saying and the court.
Speak loudly, Dr. Likonyo, so that their lordships can hear you easily. Quasi. Okay, the court. Okay, the court has adjust the microphone.
With the permission of the court, perhaps you could place something under the microphone to just lift it up. Yes.
Your Honor, again, my name is Dr. I am a medical doctor, a graduate of the University of Nairobi in 1975. It's 50 years last August. Postgraduate in internal medicine, the same university, 1980. Thereafter, fellow of cardiology, and now a member of a fellow of the American College of Cardiologists, trained in Minneapolis, the Mayo Clinic in the U.S. at 1985. Now practicing at the current hospital, previously a lecturer at the University of Nairobi.
Thank you. You have a document titled Affidavit, sworn on 28 April 2026, consisting of 12 numbered paragraphs. Do you recognize this document? Whose affidavit is it? Whose deponent's signature is on page 3 or 5 of that affidavit? Do you wish to adopt the contents therein as your evidence in this matter? Please tell the court whether you are acquainted with any party before these proceedings in a professional capacity.
I believe that the party means the respondent. Yes, I'm acquainted with my patient, Honorable Gachaguas,
Okay.
whom I have taken care of. From my records, Your Honor, my hospital records that I do have with me, I have been a doctor in the same Honorable Gachaguas since, if I could, 5:10 p.m. on the 10th of July 2006.
Okay. When and under what circumstances did you meet the first petitioner, if at all, during the period in issue and relevant to these proceedings?
I believe for the purpose of this issue, you are referring to his hospitalization at the current hospital, which again, from my record, hadn't a note, happened at 3:25 p.m. on the 17th of October 2024.
And what happened when you met him? What happened next?
Your Honor, the reason for his coming to hospital, the court said he's on the way with chest pain, and we received him and acted accordingly.
From your experience and expertise as a cardiologist, what significance do such symptoms have?
Your Honor, you know, chest pain has two categorizations. There's chest pain that can occur if you have a heart attack, medical term called a cardiac infarction. That, when you say you have chest pain in that category, we look at the possibilities of that being real. That's what we call the risk factors. Here's the man, his age.
My Lord, with a very kind permission. With a very kind permission. I have listened to where the evidence, my Lord, is headed. And in my very humble view, we appear to be expanding the scope of the petition and the affidavit that is before you, Lordship. My Lord, it is important that we stick to what is in the affidavit. For purposes of that is why we are here today. If we attempt to then expand it beyond what we agreed, then we'll be prejudiced. We'll have to file further affidavits, etc., to be able to respond to the questions that are being raised. We must, I submit, stick to that.
Your file an affidavit.
My Lord, if I may respond, I would refer the court to paragraph 5 of the affidavit. Basically, the questions are formulated based on what the witness did point to. Unless they specifically state exactly what is new, my Lord, we request that you do allow the witness to proceed with his testimony.
Laying a basis does not presume introducing new issues by way of evidence issue. It doesn't mean you then introduce new technical issues that we need to deal with. We would have to respond to.
I think the way forward is you will refer the witness to particular paragraphs of the evidence.
Okay. You do have the affidavit with you?
I do have it, Your Honor.
Okay. Please clarify what you meant under paragraph 5 of your affidavit.
Your Honor, paragraph 5 asks, based on my professional expertise, what will this sentence mean? That the law is my answer to that is that based on my experience, both types of symptoms, depending on the probability of the injury, it depends on the risk factors. It would imply that you will be having a heart attack. That is my simple answer.
And based on paragraph 6 of your affidavit, what role or steps did you take with respect to the first petitioner having been presented before you?
Your Honor, if a man of that age and risk factors presents, there are standard protocols that we follow in medicine. We run with that person. In this particular person, my mother again, there was additional problems of affecting the heart in a condition that we call a catastrophe.
I refer you to paragraph 7 of your affidavit. Please clarify what you meant in that affidavit on paragraph 7.
Somebody presents with chest pain and has mental risk factors, you are then hospitalized for evaluation to see the extent of the danger at which this person.
What examinations did you conduct, if any?
Again, Your Honor, after apart from the physical examination, the history of the circumstances, let me proceed with specific tests. It include what we call a tracing of the heartbeat, or after this called for an ECG, an ultrasound of the heart, for this part of the layman's term, an image of the heart, and blood tests to check for any heart matter damage. Again, the honor.
Very kindly. As my Lord did direct, could we be pointed to specific parts of both the affidavit and the attachments but then align with what the good doctor said, my Lord. My concern is what, my Lord? We, by seeking clarification, we are then proceeding or extending beyond what is contained in this document. It then leaves us in a very precarious position in terms of this.
The doctor is here to give us expert evidence. Yes. We must be able to do that.
Yes. Yes, my Lord. Can you clarify, my Lord, beyond that contained is the affidavit?
My Lord, if I may assist the court, the issue being raised is we have a written affidavit, which is sworn testimony. Ordinarily, that would be the evidence in chief. The second issue is that it is trite that where a thing has been reduced to a document, in this case, the affidavit, and the annexures thereto, you cannot, under the guise of examination in chief, purport to add to subtract from, to contradict, or vary. Even if this witness were to spend 2 days here, offering these things now being called clarification, it's just a waste of your time. Section 99(1) of the Evidence Act says that evidence is inadmissible.
I've been submitted a very brief reply. The rule of objections, as I know them, is that you object to something, objection irrelevant, objection something. There's no specific objection. You're being told that the objections, without a proper basis, we kindly request you to order that the examination in chief proceeds and concludes very shortly. Then my learned friends would have their time to impeach and to do anything lawful with the witness on the stand. Thank you, my Lord.
And so when we proceed with the latitude that those paragraphs in the affidavit gives you, and I think we have to understand that we have an expert witness. That's why we put in an expert has come to tell us something we may not know. Therefore, within that latitude, please proceed.
Thank you, my Lord. So, what you are referring to was in paragraph 6 of the affidavit.
Your Honor, exactly. That's the principle that the things I've mentioned are in that affidavit, the ECG, for the I've not gone outside of that context.
Thank you. Please refer to paragraph 4 of your affidavit and annexure marked DKG 3. Annexure marked DKG 3. Can you explain the timings reflected in those documents? Paragraph 4 of the affidavit, which talks on when you approximately met the first petitioner, DKG.
That was on the day of admission, which we just clarified just now from my handwritten note of the hospital, which was on the 17th of October 2024.
Now, my Lord, now the witness is confirming why you are hearing objections. The witness is referring to his handwritten notes, which are not attached to the affidavit.
My apologies, Your Honor.
Okay, please refer to paragraph 4 of your affidavit and annexure DKG 3. That annexure is titled Discharge Summary.
I think you should have something to
Yeah.
But you know exactly what point you are on.
Yes. And there are timings mentioned in paragraph 4 of your affidavit, and there are timings indicated in the discharge summary. Could you explain those timings?
The date of admission and the date of discharge, would that be the issue?
Yes.
Your Honor, this is the date of discharge, the date of admission is the time that the patient was admitted to hospital. As I mentioned earlier, it's written here at 4:18 p.m. I would qualify that, Your Honor, that you not understand what admission is.
No, my Lord, that's exactly what the law says the witness can.
What you should try to avoid is any interpretation or outside the document.
No problem. Admission time 4:18 p.m. 17th of 2024. Discharge 20th November 2024, 1:06 p.m.
Okay, under paragraph 4, there is a timing of 3 p.m. What transpired at that time?
3 p.m. is the time of admission that the patient arrived in the hospital and was given a
Just a clarification. 3 p.m. and there is the 4:18 p.m.
That's what I was going to, I was stopped from saying.
Please clarify those. What happened at 3 p.m.? What happened at 4:18 p.m.?
My Lord, we still retain the objection. It is in black and white in the Evidence Act. If it is in the document, no amount of oral evidence from this witness can be admitted for purposes of adding to, subtracting from, clarifying, or all these things is now purporting to do.
Let me rephrase that, Your Honor, and because the times you've read them out, when did you see the patient? What time did you see the patient?
3:25.
As per paragraph 4 of your affidavit, what time did you see the patient?
3 p.m.
Okay. What time was the patient admitted to hospital?
At that time that I talked about.
Which was?
3 p.m. But on the paper here, and you must allow me to clarify because you have to understand why that date is there. Why that time is there. That's why we are here, to explain to you the discrepancy between 3 and 4. Your Honor, if you allow me, and an answer to that.
Yeah. Answer. Proceed.
The discrepancy is because as one comes to hospital, that is not admission. Admission is when the technical details are entered in the admission papers after all other factors have been taken care of. Who is your insurance, who is paying, and then the account department will put that time after admission time.
Okay, thank you very much.
If there's no cover for that, you will not be admitted. You will be seen.
Thank you. Thank you, Dr. Now, refer to paragraph 8. Paragraph 8 of your affidavit and the annexure again marked DKG3, which is the discharge.
On the past expenses to make, on the other day, we say he was discharged on the 20th of October 2024.
Okay.
On this other day, it says discharged 20th November. There's no error in that. If your Honor allows me, I can explain why that is so.
Please explain.
The answer is again, discharge process in hospitals involve accounting. You must pay before you are discharged. And then if you have been discharged by the doctor, and you've been gone home and you're not paying your bill, you're technically not discharged. We call it an open bill. If the person come and clear all your bills and everything else, that's not technically financially discharged.
Thank you. Refer to DKG3, the annexure, which is a discharge summary, at page 4 of 4. Who wrote the discharge summary? Who wrote the discharge summary? It's at page 4 of 4.
done by the medical officer, or the extra, or the intern. In this one, it was done by Dr. Sarin. But the consultant operates what has been typed in there and signs that is correct. So it was prepared by Sarita and signed by me, Dr. Anderson.
Okay, thank you very much. Still on page 4 of 4 of DKG3, an extra, which is the discharge summary. What did you mean by the follow-up, that ongoing review, follow-up?
I believe if the medical council need a follow-up in the discharge hospital, they have already been treated. There are issues that need to be followed up. How are you faring? We actually, at the current hospital, actually call patients at home and ask them, you are discharged last week, madam, how are you faring? But more than that, we give you a training to come back. Just to make sure what we did was correct, and you're getting better, and easily needs to be done. And then most of the time, we have to look at the lifetime follow-up.
Okay. Is an extra marked DKG3 to your affidavit true and accurate copy of the original discharge summary?
Your Honor,
I'll go to the last bit. During the period the first petitioner was under your care, what communication, if any, did you receive regarding his condition from anywhere?
oh, Your Honor, they always follow-up calls, relatives, and friends. And in this particular case, Your Honor, I must be honest enough to specify that I did receive a call from the President asking about the status of the patient and responded accordingly.
What did you communicate in response to that inquiry?
For the first one, Your Honor, I just say that we are in the process of doing various tests, and as soon as we have a conclusion, we shall let it know.
Okay.
But Your Honor, you must allow me to say this, that when I say that I had to seek clearance from the patient that was okay so to do medical information.
Okay, very well. On my second last question, please refer to paragraph 10 of your affidavit. Paragraph 10 of your affidavit. And annexure DKG4.
Yes, Your Honor.
And tell this honorable court the relevance, if any, of the annexures in relation to your testimony.
Your Honor, dealing with hospitalization, this hospitalization for reasons that happened that time in a public issue, and there were public notices in newspapers and television services covering the issue.
Okay. Lastly, please refer to paragraph 11 of your affidavit, and in summary, what you'd like this honorable court to understand regarding the first petitioner's admission and treatment.
Your Honor, I've only one statement to make, and that the Honorable Gachaguas was admitted to hospital on the day so specified and discharged on the day so specified and treated according to established medical practices.
Thank you very much. That is all, my lord.
Good morning, Dr. My name is Mudhomi. I think we know each other. Yes. I will ask you a few questions on behalf of the respondents and the second interested party, who is the party I represent in this case. For the record, please confirm that your affidavit is dated 28th of April, the year 2026. You will agree with me, sir. This affidavit has been made 1.5 years after the events described in it. Correct or incorrect? It's correct. Was this affidavit placed before the Senate?
I think we are aware because this request has come now.
The request has come now. You don't believe, sir, it is bizarre that a request of this nature in a case of this nature will be made 1.5 years down the line? Would you agree with me? That's bizarre. It's not natural.
Sir, I don't know the proceedings.
Okay. Fair enough. This is bit 3. Correct or incorrect?
Correct.
That exhibit, was it placed before the Senate?
I won't be aware, sir.
You are not aware. But you will confirm whichever date we take from the multiple dates on it. These are again events that this document was available about 1.5 years ago by the date given there of 17th October, isn't it? You have to agree this document was available. You also have to agree that with due diligence, this document would have been placed before this honorable court about 1.5 years ago. True or untrue?
No opinion, sir.
No opinion? Fair enough. You have now attempted to explain a discrepancy between paragraph 3 of paragraph 4 of your affidavit. It talks of 3 p.m. But exhibit 3 at the top right talks of 4:18 p.m. You agree that's a discrepancy on its face? On its face, without more looking at it, is there or is there no discrepancy?
None whatsoever, sir.
Are you saying 4:18 p.m. is the same time as 3 p.m.?
There are different times for different.
They are different times. Therefore, you agree with me, sir.
My Lord, could the witness be given the opportunity to complete answers to his questions without being cut short?
Dr. Gikonyo, is it your testimony that the time 3 p.m. given at paragraph 4 of your affidavit is the same time given as 4:18 p.m. in the medical record?
They are different
Good. They are different times.
occurrences. They are not the same thing they are describing.
Okay. This explanation you are now offering on the witness doc, is it given anywhere in your affidavit? The explanation for the discrepancy, is it set out anywhere in your affidavit?
It should be understood.
No, the question is it set out anywhere in your affidavit? That explanation you are now offering in court.
Not there because
It is not there. Good.
never raised. Otherwise, I would have given an answer.
We are here to raise it, unfortunately. Let's stick to that page 1 of 4. Dr. Gikonyo, you have to agree with me that we identify individuals in Kenya by reference to their national identity card or passport number. Correct or incorrect?
Depending on the purpose, sir. In my class, they call me DK.
Does this document indicate the identity card of the patient being attended to? Does it indicate the identity card number? national identity card number. Either it does or it does not.
We have the client ID number.
That's not my question, sir. My question is, on its face, does this document disclose the national identity card of the patient it describes?
Deliberately not.
Good. Does it indicate the travel passport number of the patient?
Deliberately not.
Good. Deliberately not. Very good answer. Does it give the patient's name?
Deliberately not.
Therefore, you have to agree with me, sir. A document that does not contain the patient's name, does not contain the patient's national identity card number, does not indicate the passport number, we have no way, based on the document, of ascertaining who is the patient described in that document.
We do ask the person prepared it.
No, the person on the doc is you. Does this document on its face, sir, disclose the identity of the patient described there?
Only by initials, RG.
RG, which could mean anything, isn't it?
To other people, but not to me.
Okay. Fair enough. I put it to you, sir, that you having brought this document to court, you cannot run away from the fact that it doesn't disclose the identity of your patient. Okay. RG could as well be Rob Gitau, right?
Could be, but it's not.
It could be Rose Gitanga. I put it to you, sir, it can be anyone and anything.
In this category, no.
Okay, fair enough.
You can ask me who is RG, and I tell you who is RG.
The problem, doctor, is we don't believe you. That's why these questions are being asked.
You ask me why did you write RG, and I can't explain.
It is me who chooses, unfortunately, the questions to ask. So, let's go to that. The title of the document is a medical summary.
Correct?
You have to agree there is a difference between the summary and the primary document.
That's true.
So, has the primary document been placed before this court? Can you see it anywhere in your affidavit? You can take time to flip through. It is not in your affidavit. You have to agree with me, therefore, in the absence of the primary document, an independent reader has no way of confirming whether this summary agrees with the primary document. No, on the documents, we are dealing with the document. In the absence of the primary document, would the third party have a way of confirming whether the summary is accurate?
If that document was adequate in itself, I would not be here. I am here to answer questions of that document to say if it is correct. If it was adequate of itself, we would call it here.
We actually called you, Dr. Ikonyo, because the document has just too many gaps. Let's go to the paragraph of your affidavit that talks of the 48 hours to 72 hours. That's paragraph 7 of your affidavit. If that were true, it would mean this patient, and we mean patient RG, whose identity we don't know, it would mean that this patient would have been discharged on or before 20th October 2024. Correct or incorrect? We are following the document, sir. Your paragraph says he was admitted for how long? 48 to 72? Your paragraph 7.
Sir, please read correctly. Be completed.
And when does it say he was discharged?
On the 20th
Of which month?
of October.
Of October. Good. And what is the discharge date given in the medical summary? November. That's actually 34 days later.
Correct.
Correct?
Yes.
You have now attempted in your exam in chief to explain the discrepancy.
Not attempting. I give the space.
Okay. Let's take it you have explained. You have explained while on the witness doc the discrepancy of 34 days, right?
Yes, no.
Is that explanation set out anywhere in your affidavit? The explanation you gave this court for that discrepancy?
Yes. This is understood.
No, my question is the explanation you are now offering 1.5 years later, is it, show me the paragraph of your affidavit that explains the discrepancy.
It was not required.
It was not required. But for the record, is it given in your affidavit, that explanation?
Not given because not
Good.
required.
It's not given. This summary gives the consultants who are attending to the patient. Can you see that part of Exhibit 3?
I do, yes.
It begins with yourself. Who are the other doctors?
Your Honor, if you allow me to explain,
You can look at it.
I will.
I haven't asked the question for you to explain. You can only answer questions I ask.
I know the names on the list.
The names given there,
Yes, I can look at them, but I know them.
you know them. Good. Is the maker of this document one of the doctors who are indicated as attending to this patient? No. So we don't have the primary document, and we have a summary made by a person who did not attend to the patient.
Not correct.
Not correct. Is Dr. Sarita, just for the record, indicated as one of the doctors in this summary who are attending to this patient?
She is not a consultant.
My question is she indicated as one of the doctors who are attending to the patient? From the list given at the top, is Dr. Sarita one of them?
Your Honor, I must explain what this list of consultants mean in the audience here.
We are not interested in that. The question is she indicated? Either she is, and Doctor will add quickly if you answer the question. The more we kick about the bush, unfortunately, the longer time it will take.
But I can't allow you, sir, to proceed on a misunderstanding.
My Lord, the witness has no...
Excuse me, Dr. Rulling. You can give evidence that you answer questions as put to you by counsel without any
But Your Honor,
evaluation. Just answer the questions as put to you. If you don't know, you say you don't know. Then you proceed.
And that's how the law works, Dr. Gikonyo, just for the record.
thank you. I understand now.
So is Dr. Sarita indicated in this document?
Should you find that there's a need for clarification, then you ask me to clarify. All right. Yes. Go on.
So, Dr. Gikonyo, is Dr. Sarita, the maker of this summary, indicated as one of the physicians that were attending to the patient, known as RG? On the face of it, is she indicated in the list of those doctors?
Not as a consultant.
Is she indicated in any other way?
As a preparing, as the one preparing.
No, that's not my question. Just wait. Is she indicated as attending to the patient in any medical capacity? The maker of this document.
Taking care of the patient are not listed.
I thought they are listed here, sir, about 6 of them.
These are the consultants. There are other doctors in the system. Medical officers, intensive care doctors, and other people. And as I mentioned earlier, we are a teaching hospital.
Is there any material you have placed in your affidavit to show those other doctors and the fact that they were attending to the patient?
No.
Good. In fact, on the document before the court, we have no way of knowing who else other than the 6 given that are attendant to the patient.
Only by asking the person of the doctor.
No, we are talking on the document, sir.
Not on the document.
Good. Let's go to the bottom of that document. Bottom left. That document has a computer timestamp at the bottom left, correct? Bottom left, below prepared by Dr. Sarita.
2011, 24, 12:40.
12:40 p.m. So what is the date and time of this document's preparation as per that time stamp? It is prepared on the 20th of November 2024 at 12:40 p.m. Correct or incorrect?
Right, that's correct.
Now let's go to the opposite side of the page, bottom right. What is the date and time given? The date you confirm,
20 November 24, 12:30, 119.
12:35. You have to agree those are 2 different timestamps. Correct or incorrect?
That's correct.
You must agree, sir, that it is not possible for this document to have been prepared at 2 different times as it purports to say.
I wouldn't understand what the computer would do. Not sure about that.
Unfortunately, sir, you have to agree with me that on the face of it, this is a discrepancy as to the time when this document was prepared. It has 2 timelines. Which one do we take?
I do not know.
Good. You don't know.
I won't ask that.
You have testified that this patient had a prior history. We go to page 204.
Yes, Your Honor.
And you have summarized it there.
Yes, Your Honor.
Have you placed before this court any primary documents to prove this alleged prior past medical history?
Where is available?
No. My question, sir. Have you placed before court any material to show that this patient had prior history of the conditions described there?
None at all.
None at all. Good.
Where, Your Honor?
None at all.
It's available. I have it on me here today.
Unfortunately, it's you who testified on affidavit on oath, sir, that he has past history. So you have to agree with me then, in the absence of that material on the record, this is just an allegation. We have no way, based on your affidavit, to confirm that the patient described there had this prior history.
You have no way, but if you are interested in knowing, it can be provided.
Doctor, you say you did a number of tests on this patient,
Yes, Your Honor.
including an echocardiogram,
Yes, Your Honor.
2D, one is called 12 LED and the other one 2D, right? You must agree with me that that machine for echocardiogram generates a report and a graph. Correct or incorrect?
Of course. Yes, it does.
Yes, it does. Have you in this affidavit attached that graph that the machine generates to show that the patient has the conditions described in the summary?
No, it's not. Available is required.
No. My question is, have you attached to the affidavit the report that the echocardiogram machine generates?
Definitely not.
Good. Have you attached the report that the other machine automatically generates?
Not attached, but exists.
Fine. Have you attached the images that were supposedly taken of this patient?
If I thought they would be useful for this court, I would have attached them.
Fair enough.
They are available if required.
But you would agree with me that the images and the graphs and the reports would be the primary document evidencing the illness, correct or incorrect?
Correct.
Therefore, if that is correct, you must agree with me that this summary, in the absence of those images and those graphs and those reports, cannot be the evidence that patient RG and the conditions described in your affidavit.
Unfortunately, I would not agree with you.
Fair enough. You say you also took some blood tests.
Yes, Your Honor.
Have you attached the laboratory report of those blood tests to this affidavit? No, doctor, my question is,
They are not attached.
have you attached the laboratory report of the alleged blood tests?
Deliberately not. Available if required.
So again, based on your affidavit, you have to agree. We have no way of knowing whether there were blood tests or what were the results of any such blood tests.
I disagree. We have a way of knowing. Ask me to introduce it.
Page 3 or 4 talks of hemoglobin, platelets, and blood chemistry and other things. Correct or incorrect? Either it does or it doesn't, Dr. Reed.
It does.
Do we have in your affidavit the primary document, that is the laboratory report for all these tests?
Available if required.
No, my question is, do we have it in your affidavit?
No, cannot.
Definitely not.
Yes.
In page 404, there is some information there about follow-ups. Have you produced before this court any document on that follow-up?
Has not been requested.
The question is, have you annexed it, sir?
No.
You have not annexed it. So again, I put it to you, there is no material before this court to confirm there was any follow-up. Dr. Gikonyo, in summary, you have admitted you have no material before court to show the prior history of the patient. You have confirmed there is no material before the court to evidence his medical condition when you supposedly attended to him. And there is also now no material of the follow-up. Is it not because this gentleman was in your hospital to hide away from the Senate? He was not sick. I put it to you.
Let me laugh a little bit.
Trust me, I too have been laughing about
But honestly, sir,
Yes.
the question arises as to the those documents that have been raised, if they are available, and they are looking for justice and honesty, you can ask me, provide them. And it takes 2 seconds. They are here.
Yes, you may have them, but they are not on the record, sir.
You can have them.
Unfortunately, the law does not permit you, Dr. at this belated stage to even refer to them, because they should have been put on the affidavit. But to my summing up questions, your affidavit alludes to some media coverage of his alleged illness. Did you give yourself a press conference on this illness?
Yes, Your Honor, on demand from the press.
On demand from the press.
Yes.
Dr. Gikonyo, is it standard medical practice for doctors to give press conferences as to their patient's illness?
Depends on the sensitivity of the
No,
issue.
the question, sir, is it standard medical practice for doctors
Yes,
to call press conferences?
No, sir. We don't call for press conferences.
Okay.
Press comes to us.
When you are giving this press conference, the case before the Senate was proceeding, correct or incorrect?
Most likely so.
You found time to give a press conference, but you didn't find time to go and tell the Senate. Okay.
In what capacity would I go to the Senate?
Good. Wouldn't the Senate, where the proceedings were going on, sir, have been the natural forum for you or any of your colleagues to go and tell Senate that the witness cannot come because he has been admitted in hospital?
I'm not sure if access to the Senate is available to get the common person like that.
That's all from me. I'll yield the floor to Mr. Mukele Melod to wrap up the cross-exam.
Well, there is a serious allegation in the form of a question raised by Dr. Thionkulu that Dr. Gikonyo was hiding the first petitioner. That was posed, and I'm not sure that Dr. Gikonyo was given the opportunity to respond.
Just for the record, the witness answered and he said his answer was to laugh.
We'll deal with it. We'll deal with it, yes. Thank you.
My Lord, leadership.
My Lord's leadership, Senior Counsel Dr. Thionkulu has covered quite a bit of ground. I will only have about 3 or 4 questions for this witness. I don't think I have much to add. Good morning, Dr. Gikonyo. My name is Edwin Mukele. I represent the 3rd and 4th respondents. I've been permitted by Senior Counsel Professor Ojenda to ask 1 or 2 questions on behalf of the Senate and the Speaker. Now, I had your last comment to be that you are not sure, and this goes to Dr. Thionkulu's very last statement, you're not sure whether you have access to the Senate. That's what I heard you say, correct?
Yes, I said so, sir.
Now, Dr. Gikonyo, The affidavit that you've presented before court is sworn on the 28th of April 2026.
That's correct.
That's correct. Do you recall when the first petitioner was impeached?
Not the exact date, but I believe the same day that he went to hospital.
The same day that he came into hospital. Would that be the 17th of October 2024?
Most likely, so, sir.
Most likely. This is about, we then receive your affidavit in court about 1.5 years after he has been impeached.
That's correct.
Now, going back to your evidence, and I'll be very brief, my lord. When asked a question on whether the documents you presented would have been presented to the Senate, your answer was, the request has come now. That is what I had you to answer to one of Dr. Kiankolo's questions, yes? The request has come now. So the request, Dr. Gikonyo, to file the affidavit and the attached documents has come now. That is what you said, yes?
Yes, I mean that, yes.
From whom did you receive the request?
From the petitioner.
You received the request from the petitioner.
Yes.
Do you recall, do you know when the petitioner first filed the petition? Might you know?
No, I don't.
You're giving evidence and you're not interested in the context of a petition in which you have no interest. Is that what you're telling the court?
Yes, that I'm here purely on a medical issue, not a court issue.
That is startling, actually, I must say. It means, in my view, you probably don't understand the reason you're here. But I will go on. You have also, and this is my last question, mine are very brief. You have also confirmed that you do not know whether the affidavit and the documents attached were before the Senate. Do you have any information on that? You don't have any information on that?
And I agree with you, in fact, I really don't know where I'm at. My understanding is I'm here to answer medical questions about the petitioner.
So,
about law things and forth and things.
so,
I am ignorant.
so Dr. Gikonyo, you cannot tell the court, from what I understood, whether the affidavit and the documents presented today, sorry, the affidavit sworn by yourself on the 28th of April, were before the Senate at the time of the impeachment proceedings. You can. You only know. That's okay. Doctor,
I have no interest in those matters.
that's okay. That's okay. We understand that you do not know why you're here. My Lord, those are my very brief questions on behalf of the Senate. I beg to. Thank you.
Dr. Gikonyo.
My Lord, we had Dr. Kamoto to ask just 2 questions, then the witness can be re-examined. If you permit him, please.
My Lord, there was no affidavit filed by Dr. Kamoto, and you have given directions before the commencement of these proceedings.
Yes, my lord, my lady. We have put our responses. We are doing a joint approach to this matter. We have a joint approach to this matter, and that's why you'll find, my lord, that not every one of us makes submissions or presentations on every occasion. Otherwise,
if I allow you, then there's no business why I don't allow it aside, because it also just hangs on that point. I think for clarity or purpose, I don't think it's fair to allow it.
It's okay. Very well. We are most obliged.
My Lord, I'll proceed with the re-examination of Dr. Gikonyo. Very quickly, Dr. Gikonyo, I'll refer you to paragraph 11 of your affidavit on the reason why you filed the affidavit. Could you come clear or clarify why you swore this affidavit, referring to paragraph 11?
Senate and other court matters. Because as far as I'm concerned, Your Honor, that paragraph summarizes why that I made this affidavit in my capacity as a medical expert, not a legal expert, in adult cardiology, to assist this honorable court in establishing that the first petition was duly admitted to hospital on the date in question, and I went to treatment. That is what I understand.
And you had earlier confirmed that the contents of your affidavit were true, to the best of your knowledge. Thank you. Just to clarify a few issues that have propped up during this examination, and I will go back to paragraph 4. Paragraph 4 of your affidavit, and I'll be direct this time round because it cropped up. Is there any admission issues in paragraph 4?
None at all.
Thank you. So at 3 p.m. on 17th of October 2024, what exactly happened?
At around 3 p.m. is the word. Approximately is the word.
Yes.
You want to know the exact time we have treated the time.
What happened?
About that time is when the patient arrived in hospital.
Thank you.
We took him in. We started the normal thing that we do for treatment taking. It is very bad and such. At that time, we were on press meeting. At the time of we start now the admission process.
Thank you.
Admission is a process, not an instant.
And
as we are doing those things, there are accountants asking who's going to pay for this, blah, blah. And when they are ready, then they fix on the computer, this man is now ready.
so when was he admitted?
According to our document here, 4:18 p.m. That is when the actual documentation of admission were completed. These are technical details of timing and writing. Before that time, we are still seeing the client. We are doing the necessary things. But it's technical, not admitted, because the accountants are not allowed us to do that.
Thank you. I'll refer you to page 1 of 4 of the discharge summary. And on the top, the patient name is Mr. RG. Who is RG?
Uko hewani.
And my good colleague here knows that question is also impermissible.
The question was actually raised in cross-examination, and what we are seeking is a
Again, kutupia nafasi unaona kama umekuwa mkali. Anaongea tu bwana. Kama ni mwazungumzia kwenda hivi. Battery yangu inashika mbio. Acha niweke ndogo, niweke kubwa kwa moto. Nataka kumecheza. But yangu ikifika 4,000 yako leo. Natumia data za simu. Sisi kipindi naandika wahuni kazi. So nafikiria nikuwekee music. Sasa wacha niendelee. Inafaa ikuwe mnakuja music sasa, ndio? Asante kwa hedi.
Willie Zecheza, Faith Waihua, John Jomo, and Faith Waihua is holding brief for Ochiel Dudley. Those are the counsel appearing for the first petitioner for the purposes of taking judgment this afternoon. I thank you.
May it please the court, I'm Tess Wanjiru Kimoto Makazi from Tess Kimoto and Company Advocates, Kerugoya, Kirinyaga County, and I'm for the second petitioner.
May it please you, my lords, my lady, Njeri Maina for the third petitioner. I appear with Andrew Muge and Christopher Wainaina.
Your Lordship, Your Ladyship, my name is Ogada. I appear alongside my brother, Mr. Sakimpa. We appear for the 4th to the 8th. We've been asked to hold brief for the Law Society of Kenya, which is represented by the following councils: Mr. Kevin Mishuki, Mr. Wycliffe Oyo, Ms. Wangari Kagai. They appear online.
My Lord, the presiding judge, my Lord and my lady, if it pleases you, my name is Wamboi, Shadrach Wamboi. I appear for the 9th, my learned sister, Miss Wanjiko Waithera, and my learned friend and colleague, Mr. Jeff Kangeve. Thank you. For the 9th petitioner.
And your Lordship, the presiding judge, and your Lordship, and your Lordship, Justice Mrima. My name is Kirago Wadhuta. Together with my learned senior, Mr. Kibe Mungai, and Mr. Peter Koira, for the 10th to 41st petitioners.
If it may please you, my lords and my lady, I'm Omanyi. I do appear for the 58th petitioner, together with Mr. Bernard Nderito.
May it please you, my ladies, my lord. My name is Ndegwa Njiru. Alongside Mr. Boniface Nyamu, we appear for the 44th to the 49th petitioners. We are ready to take the judgment.
May it please you, my lords and my lady, Phyllis Wangoi, appearing for the 43rd petitioner, together with my fellow councils, Omoke Murara and Sasha Wamai.
May it please your Lordship and your Ladyship. My name is Mos. Songo. I appeal.
My learned senior, my learned sister, Miss Wanjiko Waithera, and my learned friend and colleague, Mr. Jeff Kangeve. Thank you. For the 9th petitioner.
And your Lordship, the presiding judge, and your Lordship, and your Lordship, Justice Mrima. My name is Kirago Wadhuta. Together with my learned senior, Mr. Mungai, and Mr.
The 49th petitioners, we are ready to take the judgment.
The direction being sought from you, because you already gave the direction when we were before you, that any party who desires to cross-examine the witness now on the dock would do two things. First, they would file a reply to that affidavit. And number two, in that reply, they would intimate whether they wish
Well, it is our hope that those families will get justice. Now, tonight, President William Ruto is on the spot once again over his continued display of opulence at a time when Kenyans are suffering with rising cost of living. As the two-day strike literally made Kenya a walking nation, President Ruto was flying from one country to another on an expensive charter luxury private jet. Even as Kenyans remained stranded at the bus terminus or walking to work, the chartered jet costs 3.2 million per hour, translating to more than $500 million shillings for the entire trip. Costs to be footed by the taxpayers, as Daniel Kariuki now reports.
Nothing can come between President William Ruto's appetite for his fine taste for aviation refinement. Not even the crisis affecting his country, such as the fuel protest that has brought the country to a standstill. As Kenyans trekked to their workplaces for 2 days, President Ruto has been enjoying the skies and the comfort that accompany executive travel. President Ruto left the country on Saturday last week to Azerbaijan at a time when transport stakeholders had announced plans to paralyze public transport following the historic fuel hikes. The irony, however, is that when the players in the transport sector were protesting the increased fuel prices, the president was enjoying recreative services of a jet that would cost the taxpayers $500 million shillings for 1 week. The jet, registered T7BBJ2, arrived in Nairobi from London on May 14th at 6:04 p.m. after flying 8 hours 57 minutes from London's Luton Airport to airlift President Ruto to Baku to attend the World Urban Forum. On May 16th, the jet took off from JKIA, spending 7 hours 47 minutes airborne, and landed at exactly 6:06 p.m. in Haida International Airport in Baku. According to Flight Radar 24, The bird left Baku at 11:30 a.m. destined to Kazakhstan, capital of Astana, scheduled to land at some minutes after 3 p.m. The jet, that is registered as a private plane, cost between $18,000 to $25,000.
The Court of Appeal, as a matter of judicial notice, a lot of friends will be aware.
For argument, I've asked, do you have an order from the Court of Appeal stopping or arresting this judgment?
As we speak right now, no, because the order of business,
you have answered me. You have answered me.
May I finish,
Judge? You have answered me. I have accepted that answer. I will now ask some of the parties here to respond to that.
May I finish before they respond, just for good order? My lords and my lady, we do not in the list, I do not in the list want to bring any theatrics or sabotage the administration of justice before you. What has provoked this particular move to the Court of Appeal is the aborting of the hearing on the 4th of June 2026. And so that Malana friends can respond. On the 7th of May, before you, Lawrence Senior Counsel Professor Agithu Mugai gave me the podium so that then you could address everybody in E586. On that day, you gave, in the presence of everybody here, the 4th of June as the hearing date. So that as they address that, it is the common ground that that petition was to be heard before the Lordships. And thank you for giving me this opportunity.
The subject matter raised by Mr. Kinyanjui relates to a file which is not before us here. And we have not taken any record in this particular file. But for the purpose of transparency, I will ask the parties who are expecting a judgment from us for their comment.
My lords, my ladies, I have the instructions from the team of the first petitioner, His Excellency Rigathi Gachagua, to make representations on his behalf. We have come here to pick the judgment in the petition before you. We have not received any order from the Court of Appeal stopping today's proceedings. We actually, as a matter of fact, not participating in that matter at the Court of Appeal, and therefore it will be very curious for us to have our legitimate expectations to get a judgment today interfere with a matter in which we are not participating. In the absence of a formal directive from a court higher than this, the Court of Appeal stopping this judgment, we ask you to deliver our judgment as scheduled today. That's all.
Thank you.
Of the 44th petitioners, my lord, I associate myself made by sin.
Thank you.
In the interest of time, I will speak for all my colleagues, for the respondents, and we associate ourselves with the submission of the learned senior counsel, Mr. Mboya. Yes.
Thank you. My Lord, on behalf of the third interested party, we associate ourselves with the submissions of the lawyers for the petitioner, first petitioner, and and I wish that, my Lord, you could deliver judgment as it has been agreed before. I thank you, my Lord.
Thank you.
Your Honor, on behalf of the second petitioner, we associate ourselves with the submissions of the other petitioners, and we say in the absence of a court order for stay, then we see no need of stopping judgment. That's all.
My lords and my ladyship, appearing for the 43rd petitioner, we also associate ourselves with the submissions of Senior Counsel Longoya, and in the absence of a clear order and in respect of our legitimate expectations to deliver the judgment, we then oppose the application. Thank you.
Having not done what you directed should be done by anyone desiring to cross-examine this witness, then he can't come here and just tell you we seek direction on what other petitioners should do.
Thank you for that. The direction which Mr. Raymond has sought. I think directions which what we gave last time are very clear. For you to find or found that this is for explanation, you must have responded one way or another. So if you have filed an affidavit, I'll allow you to participate. If you have not filed, unfortunately, you cannot go back.
I'm well getting my.
Thank you, my lord. We may proceed.
Nothing but the
Please state your full name, profession, and your professional qualifications.
My name is Dr. Dan Punish. I'm a medical doctor. Qualified in the University of Nairobi in 1975. I hold a master's degree in internal medicine in the same university. I'm a fellow of the American College of Cardiology.
This, Daktari, giving evidence in court.
25 deconsolidated these E586 of 2024 from the consolidated petitions. That is a decision of the court, not my decision. Shouldn't the petitioner have abided by that decision? Yes, he did, and yes, he has. The 7th of May, everybody here was present when that decision was made to hear that petition. I'm answering, my lord, I'm answering because they say that this is something that I've just come up with to scuttle the hearing. It's my rejoinder, with tremendous respect, my lord, and I'm not going to take too long. I'm alive to the fact that this court is on a constitutional duty. My lord, the date for hearing was... I served that application from the Court of Appeals, deference to the Court of Appeals directions. And we cannot sit here and pretend as legal practitioners we do not know the practice of the Court of Appeal. The Court of Appeal is seized of these proceedings. And this court is subordinate to the Court of Appeal. And I'm answering that issue as to no reason has been preferred to defer this judgment. The Court of Appeal being seized of those proceedings, which everybody here is fully aware. My friend has said, yes, he has been served. Everybody has been served. So we ought to give deference to that constitutional issue. The other issue raised is that, Your Lordship, there's nothing peculiar, there's nothing out of the ordinary from these consolidated petitions. Lanark Council, really, having looked at my petition, never having answered in that petition. Mutomi Thiankolu never filed a single sheet of paper in that petition, and he's appearing for the 10th respondent. Your Lordship, he cannot be heard to say that he has absolutely no reason to see what is peculiar. Your Lordships, you saw the peculiarity of that petition. I'm not going to go. So that Your Lordship, the petitioner wants to be heard on merit because Article 25C says he should be heard and given that right to a fair trial. As I close, none of my learned friends here, when that petition comes up for hearing, should ever remove from their pocket the res judicata card. None of you. My lord, I say so because they are happy to have the judgment today. And I'm going to demonstrate there was no lawful impeachment. Constitutional threshold was never met, and I'm not delving into that. So none of them, my lords, none of them, no, Prof, please don't point a finger at me. None of them should be heard to say that my client's petition is res judicata. So that Your Lordship,
Mr. Pinanjay, yes, we have given you enough time.
Yes, this is my last remark. This is my last remark. Since the Honorable the DR received this formal communication and was brought to the attention of this Honorable Court, I very believe this Honorable Court should have deferred to the Court of Appeal. And I said, we're not adjourning indefinitely. It's not open-ended. Even give me this afternoon, we'll be heard, and then you can render your judgment tomorrow. Thank you for hearing me.
Excuse me. Mr. Kinyanjui, this is the brief ruling on that matter. First of all, we want to note for record that the matter you are referring to is not before this court, either by way of a mention or a hearing or a judgment. Indeed, it is not before us, and we are not able to take notes on that matter. Secondly, because many people here may not know where you are coming from, You yourself sought to be deconsolidated in that matter. And we gave you the orders the way you wanted them. You took yourself away from these petitions. We have made a decision on that. You will not misrepresent facts. Listen, I'm making a ruling on this matter. The matter is not before us. The Court of Appeal has had or has cited that matter. If they wanted to stop us, we will drop our pens. Give us a court order from the Court of Appeal, then we'll drop our pen. We don't have anything like that. Lastly, we gave directions the last time we were having this matter. We said that your matter will be mentioned after today's ruling. And for record, and this is the last comment we are making on this issue, your matter is coming for a mention on 18th of June, 2026. Parties before the court, are you ready to proceed?
Thank you very much, Your Lordship.
I take it that parties are now ready to take judgment in the constitutional petition number E65 of 2024, consolidated with Nairobi petition number E550 of 2024, Nairobi petition number 570 of 2024, number E572 of 2024, Gachaguas petition number E013 of 2024, Gachaguas petition number E014 of 2024, Gachaguas petition number E015 of 2024, Nairobi petition number E522 of 2024, Nairobi petition E506 of 2024, Nairobi petition E509 of 2024, Nairobi petition number E525 of 2024, Nairobi petition number E528 of 2024, Nairobi petition number E537 of 2024, Nairobi petition number E541 of 2024, E567 of 2024, E576 of 2024, E586 of 2024, and E598 of 2024 between Honorable His Excellency Rigathi Gachaguas.
Second last. It's not part of
Yeah. Petitioners Rigathi Gachaguas, Thomas Kimotho Maingi, John Jerry Maina, David Munyi Madenge, Peter Gichobi Kamotho, Grace Mudomi Mwangi, Clement Mchiri Murioki, Edwin Munene Karioki, Sharia Mtani, na Shadrack Wambui, Father Eddie Waiguru, Anthony Mwithaga, Victor Gatia, Asunta Wangui Mwiruri, Christine Mukami Njuguna, Peter Kimani Kioira, Alice Wamuhu Mbugwa, Mwangi Anyeki Mbugwa Wamumbi, Kigo Kahari, Priscilla Wambui Gitari, Muchiri Ngatia, Maria Njeri, Eric Warui Mwaniki, Brian Hunja, Sarah Hubi, Margaret Wanjira, Samuel Njenga, Hebron Gakuru, Samuel Ngari, I accept, Council, that the parties are known. We can move ahead, and others versus the respondents. Speaker of National Assembly of Kenya, Speaker Senate, Senate of Kenya, Honorable Attorney General, and several others. This is the judgment.
For the sake of clarity, I believe the lead file in terms of the directions that this Honorable Court gave is E565.
Yes.
That is not quite what I heard.
Yeah, that is the lead file.
That is the position.
Yes.
Thank you.
This is the judgment. We have a 350 page judgment, and we'll try as much as possible to read it. Introduction and background. In the general election of 9th of August 2022, the first petitioner, hereinafter referred to as His Excellency Gachaguas, was elected as the Deputy President of the Republic of Kenya alongside His Excellency William Ruto, whom we refer to as President. Their election was upheld by the Supreme Court, paving the way for their swearing in on 13th of September 2022, beginning what was expected to be a full constitutional term under Article 145 sub-Article 1 and Article 148 sub-Article 6. That expectation, however, was cut short following the successful impeachment proceedings against His Excellency Gachaguas. The process leading to his removal commenced on 1st of October 2024, when Honorable Mwengi Mutuse, the 9th respondent and Member of Parliament for Kibwezi West constituency, we shall refer to him as Hon Mutuse, introduced an impeachment motion pursuant to Article 145 and Article 150 of the Constitution. The motion hereafter refers. The motion referred to as impeachment motion cited multiple grounds, including allegations of gross violation of the Constitution, incitement, and undermining government policy. The 11 grounds were as follows. Ground 1, gross violation of Article 10, sub-Article 2A, B, and C, Article 27, sub-Article 4, Article 73, sub-Article 1A, and 2B, Article 75, sub-Article 1C, and Article 129, sub-Article 2 of the Constitution, and Article 147, sub-Article 1, as read with Article 131, sub-Article 2, C, and D of the Constitution. Ground 2, gross violation of Article 147, sub-Article 1, and 152, sub-Article 1 of the Constitution by undermining and the Cabinet and effective discharge of the national government's executive mandate. Ground 3, gross violation of Article 6, sub-Article 2, Article 10, sub-Article 2A, Article 174, Article 186, sub-Article 1, Article 189, sub-Article 1, and the 4th schedule to the Constitution by undermining devolution. 4, gross violation of Article 160, sub-Article 1 of the Constitution on the institutional and decisional independence of judges. Article 5, Ground 5, gross violation of Article 3, sub-Article 1 and Article 148, sub-Article 5A of the Constitution, and fidelity to the oath of office and allegiance. Ground 6, serious reasons to believe that Rigathi Gachaguas had committed crimes under Sections 13, subsection 1A and Section 62 of the National Cohesion and Integration Act. Ground 7, serious reasons to believe that Rigathi Gachaguas has committed crimes under Section 45, 46, 47, and 48 of the Anti-Corruption and Economic Crimes Act and Section 2, 3, 4, and 7 of the Proceeds of Crime and Money and Anti-Money Laundering Act. Ground 8, serious reasons to believe that Rigathi Gachagua has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Ground 9, gross misconduct under Article 150, Sub-Article 1B of the Constitution by publicly attacking and undermining the work of the National Security Intelligence Service and its officers. Ground 10, gross misconduct or insubordination by openly or publicly insubordinating the President, who is the head of state and government. Ground 11, gross misconduct by persistently bullying state and public officers. The impeachment motion was formally initiated before the second respondent, that is the National Assembly. In response, several constitutional petitions were filed in the High Court, challenging both the legality and constitutionality of the National Assembly's proceedings. These petitions, consolidated with Nairobi petitions, which I had mentioned earlier, were consolidated and are collectively referred to as the Cohort 1 petitions, with petition number E522 of 2024 designated as the lead file. 56, that was Cohort 1 petitions. Cohort 2 petitions, where these petitions belong, the lead file is 565 of 2024. On 8th of October 2024, the National Assembly passed the impeachment motion. Subsequently, the resolution was transmitted to the Senate. As the impeachment process unfolded, further applications were seeking conservatory release were filed in the High Court to restrain the Senate from proceeding with impeachment hearings. The Senate thereafter conducted its hearings and upheld 5 of the 11 charges against His Excellency Gachagua, as a result of which he effectively ceased to hold office as Deputy President of the Republic of Kenya. The Senate's decision was communicated to the public through a Gazette notice issued on 17th of October 2024. Following the impeachment, His Excellency President Ruto nominated Professor Kithure Kindiki, the second interested party, whom we shall refer to His Excellency Kindiki, to fill the vacancy in the office of the Deputy President. The National Assembly voted in favor of the nomination, and His Excellency Kindiki was sworn into the office on 1st of November 2024. As the Senate proceedings that culminated in the impeachment of His Excellency Gachagua were underway, and while the National Assembly was concurrently addressing the vacancy created in the office of the Deputy President, further petitions were filed in the High Court at Nairobi and Keregoya, including petition number 565 and several other petitions, being designated with petition number 565 of 2024 being designated as the lead file. Conservatory orders were initially issued restraining the swearing in of His Excellency Kindiki as Deputy President, but those orders were later lifted by this court in its ruling of 31st of October 2024, paving way for the swearing in as earlier stated. Thereafter, the pleadings were amended and Cohort 2 petitions proceeded for hearing, culminating in the present judgment. We will now proceed to summarize the parties' pleadings and submissions in the Cohort 2 petitions. Summary of pleadings and submissions. His Excellency Gachagua is the first petitioner. His case is as follows. He anchored his case on the further amended petition dated 13th of August 2025, supported by his affidavits deposed to on 18th of October 2024 and 27th of October 2024. Speaking to the deficiencies in the process before the National Assembly, His Excellency Gachagua deposed that the impeachment motion lacked the particularization and specificity required under Article 145, Sub-Article 1 and Standing Order number 64, 1A. He took issue with the lack of credibility in respect of the charges against him in the National Assembly and the Senate. As regards the constitutional imperative of public participation, His Excellency contended that the National Assembly's process was deficient in that the notice was unreasonably short and that it lacked adequate designated venues. It was his case that the exercise was biased, with organizers framing it as meant for invited members of specific parties. He stated that the process utilized unverified feedback forms that resulted in fictitious data. In alleging bias exhibited by the Speaker and Deputy Speaker of the National Assembly, His Excellency deposed that they made partisan statements and also failed to recuse themselves despite having conflict of interest, as they were signatories to the coalition agreement that formed a substantial part of the evidence. It was his case that the Senate violated Articles 145, Sub-Article 3 to Sub-Article 6 by skipping the appointment of a special committee to investigate the charges against him, thereby denying him a crucial layer of fair hearing. He stated that Senate imposed an unconstitutional 10-day deadline on the plenary proceedings and unlawfully permitted the National Assembly to introduce new evidence by ambush. He was emphatic that the Senate violated his right to a fair hearing and dignity guaranteed under Article 50 and Article 28, respectively, when he was denied an adjournment. In further support of this position, Dr. Daniel Kibuka Gikonyo, a consultant cardiologist and founder of the Karen Hospital, saw an affidavit on 28th of April 2026 to confirm the medical status of His Excellency Gachagua on the day he was scheduled to defend himself before the Senate. Speaking to the key medical events, it was his evidence that on 17th of October 2024, at approximately 3 p.m., His Excellency Gachagua arrived at Karen Hospital with severe chest pain. He deposed that given his age and underlying risk factors including hypertension, history of diabetes, stress, he conducted ECGs and blood tests and recommended a 48 to 72-hour admission to enable close monitoring, further evaluation, and appropriate medical management. It was his evidence that he supervised His Excellency Gachagua's care until discharge on 20th of October 2024. Far from the impeachment process, His Excellency Gachagua impugned the subsequent nomination and approval of His Excellency Kindiki. He asserted that the process was rushed and there was no public participation despite the dictates of Articles 10 and 118 of the Constitution. It was his case that the clearance from the Independent Electoral Boundaries Commission, or IEBC, was null and void since the commission lacked commissioners, and as such, the Secretariat was legally incompetent to clear the nominee. Further to the foregoing, it was His Excellency Gachagua's position that His Excellency Kindiki was disqualified under Chapter 6 due to gross human rights violation, including abductions, extrajudicial killings during the Finance Bill protest when he served as Interior Cabinet Secretary. Finally, His Excellency Gachagua averred that His Excellency Kindiki was not a member of the UDA party for the requisite 3 months preceding his nomination, and it was his case that the National Assembly unconstitutionally metamorphosed the process into an election rather than an approval under Article 149, Sub-Article 1. For these reasons, His Excellency Gachagua sought the following reliefs: a declaration that the respondents have contravened the provisions of Articles 10 and 18, Sub-Article 1, Articles 10 and Article 118, Sub-Article 1 of the Constitution, by initiating a process leading to the removal from office by impeachment against the petitioner without first putting in place adequate legislative and procedural measures for effective public participation. In particular, the Senate's decision was not informed by any input from public engagement. 2, a declaration do issue that the impeachment motion lacks the particularization and specificity required under Articles 145, Sub-Article 1 of the Constitution and Standing Order 64(1)A of the Standing Orders of the National Assembly, and is thus incapable of invoking the jurisdiction of both the National Assembly and the Senate under Articles 145 and Article 150. 3, a declaration that the resolution passed on 18th of October 2024 by the National Assembly purporting to impeach the petitioner pursuant to the provisions of Articles 145 and 150 and the communication dated 8th of October 2024 by the Clerk of the National Assembly to the Clerk of the Senate, titled, in quote, Resolution of the National Assembly on a special motion on the removal from office by impeachment of His Excellency Gachaguas, Deputy President of the Republic of Kenya, close quote, are both founded on a process that is inconsistent and in violation of the Constitution of Kenya, and are thus both void and invalid. 4, a declaration that for the purposes of impeachment of the President or Deputy President of the Republic of Kenya, adequate public participation must be undertaken in all the 290 electoral constituencies in Kenya, the diaspora constituency, and the 1,450 electoral wards where the presidential election takes place. 5th, he sought a declaration that the period of 12 days provided under Standing Orders number 64, sub order 2 and 6 of the Standing Orders of the National Assembly is grossly insufficient time for the National Assembly to facilitate any meaningful and reasonable public participation during the process of impeachment of the President or Deputy President of the Republic of Kenya. Thus, the standing order is unconstitutional insofar as it has the effect of abridging the time for public participation. 6, he sought a declaration that the proceedings before whole house plenary of the Senate of Kenya under Article 145 of the Constitution of Kenya are not limited or time-bound to 10 days, as would be if a special committee is appointed under Article 145, sub-Article 4A. He also sought in 7th prayer a declaration that the petitioner's right to fair administrative action under Article 47, right to fair hearing under Article 50, sub-Article 1 of the Constitution were violated on account of the petitioner being denied an adjournment occasioned by illness, thus violating his right to appear in person before the Senate of Kenya to be heard and present his case. He also sought a declaration that the National Assembly and the Senate, in their evaluation of the impeachment proceedings before them, failed to properly assess each of the specified grounds and determine if they collectively or individually constitute a gross violation of the Constitution, warranting voting to uphold the impeachment charges against the petitioner. Hence, the resolution of 8th of October 2024 in the National Assembly and the vote upholding the impeachment charges that of the Senate passed on 17th of October 2024 do not meet the threshold for impeachment set out under Article 150 as read with Article 145 of the Constitution. Hence, the same be and are hereby set aside. An order of certiorari to remove into this Honorable Court and quash the decision and the resolution of the National Assembly and the Senate made on 8th of October 2024 and 17th of October 2024 respectively, resolving to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, Deputy President, Republic of Kenya. At the 9th prayer, the petitioner sought an order of certiorari to bring up into this court to be quashed the resolution of the Senate of Kenya made on 17th of October 2024 to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, Deputy President, Republic of Kenya, on the grounds expressed in Gazette Notice number 13/400. He also sought at prayer number 11 a declaration does issue that the IEBC could not clear Kithure Kindiki without the involvement or approval of commissioners under Article 88 and Article 250 sub-Article 1 of the Constitution as read with Section 4 and Section 11A of the IEBC Act. The purported clearance was therefore null and void. Further, the overnight clearance violated Article 10 of the Constitution on openness and transparency. At prayer number 12, His Excellency sought a declaration does issue that Kithure Kindiki is disqualified under Article 10 and 72 of the Constitution due to unresolved concerns from his tenure as Cabinet Secretary for the Interior and National Administration, during which Kenya endured gross violation of human rights. He also sought a declaration does issue that the National Assembly violated Articles 124 sub-article 4 and Article 149 sub-article 1, Section 6 of the Public Appointments Parliamentary Approval Act, Cap 7F, and Standing Order 45 in the method it adopted to approve Kithure Kindiki's nomination as Deputy President. He also sought a declaration that Kithure Kindiki was illegally appointed and procedurally cleared and unlawfully approved as nominee for Deputy President in violation of Articles 1, Article 10, Article 8, Article 118, Article 124, Article 137, Article 148, Article 149, and Article 250 of the Constitution, so that his appointment, clearance, and approval for that position is null and void. At prayer 15, he sought a declaration that the petitioner suffered harm and is therefore entitled to constitutional damages as compensation for the violations against him in terms of general damages, punitive and aggravated damages, security to be specified at the hearing, special damages under Gazette Notice number 10346 of 2023 for loss of 1, salary, 2, official transport, and other prevailing transport policy for 35 months, medical cover and benefits detailed to be supplied, airtime, gratuity, and annual salary for 5 years. He calculated those sums and gave the figures. At prayer number 16, His Excellency sought pension and other benefits under the Retired Benefits Deputy President and Designated State Officers Act, Chapter 197B of the Laws of Kenya, being a monthly pension equal to 80% of the first petitioner's last monthly salary while in office. 2, a lump sum payment on retirement calculated as a sum equal to 1 year's salary paid for each term served in office. 3, 2 saloon vehicles of an engine capacity not exceeding 2,000 cc, which shall be replaceable once every 4 years. 4, 1 4-wheel drive vehicle of an engine capacity not exceeding 3,000 cc, which shall be replaceable once every 4 years. 5, a fuel allowance equal to 15% of the current monthly salary of the office holder. 6, full medical and hospital cover, providing for local and overseas treatment with a reputable insurance company for the first petitioner, the first petitioner's spouse, and the first petitioner's child who is below 18 years or is under 25 years of age and is undergoing a course of full-time education, and in the case of a female child, is not married or is not cohabiting with any person. 7, 2 drivers. 8, 1 personal assistant. 9, 1 accountant. 10, 1 secretary. 11, 2 housekeepers. 12, 2 senior support staff. 13, 2 cooks. 14, 2 gardeners. 15, 2 cleaners. 16, armed security guards, who shall be provided on the request of the first petitioner. 17, diplomatic passport for the first petitioner and his spouse. And 18, office and office equipment. 19, maintenance expense for the vehicles provided. 20, access to the VIP lounge 2 at all airports within Kenya. He also prayed for cost of this petition and such other reliefs as this court may deem just. In support of his claim, His Excellency Gachaguas submitted, or rather in his submissions, he advanced his case further through written submissions dated 7th of October 2025, which were orally highlighted in court by his counsel, Paul Mute Senior Counsel, Elisha Ongoya Senior Counsel, and Mr. Ochiel Dudley, among others. The unifying premise of their submissions was that the impeachment proceedings were not purely political processes insulated from judicial scrutiny. Instead, they constituted constitutionally regulated proceedings subject to the supremacy of the Constitution, the doctrine of legality, and the supervisory jurisdiction of this court under Articles 23, 47, 50, and 165. Overall, they came up with the following issues for court's determination. 1, whether National Assembly motion met the constitutional threshold under Article 145. 2, whether the Senate violated Articles 145 sub-Article 3 to 6 by failing to appoint a special committee to investigate the charges. 3, whether the Senate, misled by its misinterpretation of Article 145, rushed the process and denied the petitioner a fair hearing. D, whether there was adequate public participation at both the National Assembly and the Senate. E, whether the speakers of the National Assembly and Senate were biased in reality or in perception. F, whether the overnight clearance and approval of a replacement of Deputy President evidenced a predetermined process. G, whether Standing Order number 62 sub order 2 of the National Assembly is valid. And then lastly, what are the available reliefs? Collectively, the lawyers for His Excellency, the petitioner, Rigathi Gachagua, collectively submitted that while Parliament undeniably possesses the authority to undertake impeachment, such authority is neither absolute nor immune from judicial review when allegations of constitutional violations, irrationality, or procedural impropriety arise. They characterize the proceedings as a politically engineered process disguised as constitutional compliance, submitting that Parliament specifically observed procedural forms while deliberately undermining constitutional substance, thereby necessitating judicial intervention to preserve the rule of law. Leading the charge on the constitutional standards of the process, learned Senior Counsel Elisha Ongoya anchored his arguments on constitutionalism and legitimacy within Kenya's presidential order. He submitted that the Constitution transformed governance from unrestrained political discretion to a system founded on constitutional limitation and accountability, which rendered all exercise of public power, including parliamentary impeachment, subordinate to the Constitution and amenable to judicial scrutiny. Describing the proceedings as an exercise in malicious compliance, he drew parallels to the historical trials of Socrates, Sir Thomas More, and Jesus Christ to demonstrate how processes can appear outwardly lawful while being fundamentally unjust and predetermined. He maintained that constitutional democracy depends on good faith, adherence to fairness, and constitutional morality, not merely technical compliance. In analyzing the text of Article 145 and Article 150, Counsel noted that the threshold language, gross violation, gross misconduct, and serious reasons prove impeachment is a mechanism reserved strictly for the gravest constitutional transgressions. To that end, Counsel drew the support from the cases of Mike Sonko, which we have, particulars we have given, Muya and versus Tribunal appointed to investigate the conduct of Justice Martin Muya. We have given citation. He used these cases to argue that grounds must be substantiated by cogent evidence to an intermediate standard higher than a balance of probabilities. Senior Counsel Ongoya further submitted that since impeachment directly interferes with the sovereign will of the electorate expressed through universal suffrage, courts could not abdicate their responsibility by treating it as a purely political immune process. It was his case that the grave consequences of removal brought the matter squarely within the High Court's supervisory jurisdiction, requiring it to interrogate whether Parliament met the heightened constitutional standards. Senior Counsel Paul Mute submitted on the democratic mandate and the political question doctrine. He was emphatic that impeachment in Kenya's presidential system is an extraordinary constitutional remedy of last resort. He distinguished Kenya's architecture from parliamentary systems where executive tenure relies on legislative confidence. It was his case that the deputy president derives direct democratic legitimacy from the electorate through universal suffrage and cannot be removed due to transient political dissatisfaction or partisan convenience. In view of the fact that impeachment effectively overturns the democratic will, it was Senior Council's position that the Constitution deliberately imposed strict procedures and substantive safeguards that courts are duty-bound to enforce. Learned Council drew support from the decision in Mike Sonko-Mbuvi, which we have stated, to restate that the threshold for removal could not be reduced to political expediency. He further called to his aid the Court of Appeal decision in Martin Nyaga Wambora, we have given citation, to argue that judicial review of the proceedings affirmed constitutional supremacy rather than offend the concept of separation of powers. He firmly rejected the respondents' invocation of the political question doctrine, asserting that the Constitution creates no autonomous islands immune from accountability, and he maintained that all constitutional power remains subordinate to the judiciary's review. Learned Counsel Mr. Chiang Dudley submitted on jurisdiction and the mandatory duty to adjudicate. At the outset, he pointed out an alleged internal contradiction in the respondent's case, simultaneously conceding the court's jurisdiction while urging it to abstain from exercising it. He submitted that constitutional adjudication could not be avoided simply because a dispute implicated political institutions or carried political consequences. He took the position that once allegations of procedural impropriety or rights infringements arose, the process ceased to be purely political. Drawing on the United States Supreme Court decision in Cohens versus Virginia, we've given citation, he argued that a court acts just as improperly when it declines constitutionally vested jurisdiction as when it arrogates jurisdiction it does not possess. It was his case that Article 165 imposes a mandatory obligation on the High Court to determine disputes whose constitutional violations are alleged as such. The judiciary would itself violate the Constitution by declining to hear politically sensitive questions. Mr. Ochieng submitted further that separation of powers does not establish institutional immunity and that judicial review ensures Parliament acts within its boundaries. Citing the Supreme Court advisory opinion in the matter of Kenya National Commission on Human Rights, Council concluded that constitutional interpretation in such disputes must be transformative, holistic, and purposive rather than mechanical. In the written submissions, His Excellency Gachaguas specifically impugned ground 8 of the charges, noting that it relied on Section 132 of the Penal Code, a provision already declared unconstitutional in Robert Alai versus the Attorney General matter. On the right to a fair hearing, he maintained that the Senate violated his inalienable right by proceeding in his absence due to illness, contrary to Article 50 sub-Article 2F and Article 25C. He drew support from Karaoke versus Attorney General, where it was argued that denying an adjournment impacting a citizen's constitutional rights warrants careful circumspection. He further submitted that the rushed manner of the proceedings mirrored the predetermined and unjust actions condemned in Olo versus Kisumu County Assembly Service Board and another, rendering the resulting decisions absolute nullities. Submitting on public participation and institutional incapacity, it was His Excellency Gachagua's case that both houses entirely failed the threshold. He referred to the decisions in Mohammed and 6 others versus County Assembly of Wajir and other cases which we have stated. To reinstate that engagement must be substantive, one that allows reasonable time and utilizes satisfactory mechanisms. In addition to the foregoing, His Excellency Gachagua, while drawing support from the decision Independent Electoral and Boundaries Commission vs. Attorney General 2025, discredited the involvement of the IEBC, arguing that constitutional functions requiring commission approval could not be lawfully discharged by the Secretariat without a properly constituted commission. In their rejoinder submissions, the legal team also spoke to procedural illegality in plenary investigation. It was His Excellency Gachaguas' submission that the Senate lacked a lawful resolution to appoint a plenary investigation. They submitted that the word may in Article 145, sub-Article 3b, regarding the appointment of a special committee is a mandatory obligation, relying on a set of authorities including Sony Holdings versus Registrar of Trademarks and another. They submitted that courts routinely interpret may as mandatory to effect legislative intent, to effectuate legislative intent. Tracing the constitutional drafting history from the Guy and Bomas drafts to the WACO and Harmonized drafts, it was their case that it proved the framers consistently intended for a special committee to investigate charges prior to any plenary vote. In conclusion, His Excellency Gachaguas drew inspiration from the Filipino Supreme Court in Sara Duterte versus House of Representatives. We have given a citation to reiterate that impeachment processes remain strictly subject to the Bill of Rights to check grave abuses of discretion. Consequently, they urge the court to utilize its discretion as established in Imanyara and two others versus Attorney General to award damages for the constitutional violations to vindicate His Excellency Gachaguas' right and deter future legislative infringements.
I will proceed from the second petitioner's case, that is Thomas Kimoto Maingi. Thomas Kimoto Maingi, the second petitioner in the consolidated petitions, filed a petition dated 25th September 2024 before the High Court at Kerugoya. The petitioner described himself as a former member of the National Intelligence Service, NIS, and contended that his constitutional rights had been violated by statements allegedly made by His Excellency Gachaguas on 26th of June 2024 concerning the conduct of NIS during the Finance Bill 2024 protests. He averred that, having served in the NIS for over 20 years before retiring in May 2022, he was publicly associated with the intelligence service within his community, and that the remarks by His Excellency Gachaguas portrayed NIS officers as incompetent and responsible for the unrest and loss of life witnessed during the protest. He asserted that the remarks exposed him to ridicule, hostility, threats, and psychological distress, forcing him to temporarily leave his home in Kirinyaga County and seek refuge in Embu County out of fear for his safety. Mr. Maingi further contended that the Attorney General, AG, failed in his constitutional duty as the principal legal advisor to government by failing to advise His Excellency Gachaguas appropriately regarding the provisions of sections 24, 25, and 26 of the National Security Intelligence Service Act relating to complaints against the NIS. The petitioner alleged violations of Articles 10, 27, 28, 29, and 47 of the Constitution, claiming that the impugned statements amounted to discrimination, infringement of human dignity, psychological torture, and unfair administrative conduct. Consequently, the petitioner sought the following reliefs: that there be a declaration that the constitutional rights of the applicant as provided for under Articles 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. B, that the first respondent be ordered to issue an apology to the NIS members and staff for the utterances and or speech made on the 26th of June 2024. C, cost of the petition, and D, any other relief the court may deem. The second petitioner did not, however, file any written submissions. The third petitioner's case. Honorable Njeri Maina, the third petitioner in the consolidated petitions, filed the petition dated 2nd of October 2024. That was later amended on the 9th of October 2024 before the High Court at Kerugoya. She is the current woman representative in the National Assembly for Kirinyaga County. She stated that she brought the petition on her own behalf and on behalf of the residents of Kirinyaga County, and in public discretion and in public interest, her petition also principally challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings commenced against His Excellency Gachaguas. She contended that the public participation process undertaken by the National Assembly in relation to the impeachment motion was ineffective, inadequate, and constitutional owing to the short notice periods and inaccessible venues. She took issue with the insufficient dissemination of information, defective response templates, lack of proper facilitation of members of the public, and the alleged failure by Parliament to comply with court orders directing constituency-level public participation. She further asserted that the impeachment process violated Articles 10, 47, 48, 145, and 150 of the Constitution, and challenged the constitutionality of Standing Order number 64-2 of the National Assembly Standing Orders on the basis that it imposed an unconstitutional 7-day timeline for disposal of impeachment proceedings, thereby undermining meaningful public participation. Honorable Maina also questioned the legality of the Senate's decision to conduct the impeachment proceedings in plenary instead of through a special committee under Article 145, Subarticle 3B of the Constitution, urging that investigation of impeachment charges could only lawfully be undertaken by a select committee of the Senate. In addition, she challenged the legality of the National Assembly as constituted, contending that it failed to comply with the constitutional 2/3 gender principle under Articles 27, 81B, 100 and 261 of the Constitution, and was therefore incapable of lawfully entertaining an impeachment motion. As such, Honorable Maina sought for the following reliefs. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th October 2024 regarding the special motion fell below the threshold of proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the modalities put in place by the first respondent in respect of the public participation forums held on 4th and 5th of October 2024 as ordered by this honorable court regarding the special motion were in disregard of the court's orders and fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. C, a declaration that the impeachment process as against the first interested party undertaken by the first and the second respondents in view of modalities of public participation forums held on the 4th and 5th October 2024, failing well below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution, were unconstitutional and therefore void. D, a declaration that the appointment of a select committee by the Senate under Article 145(3)(b) of the Constitution is not discretionary in the impeachment of a president or deputy president in light of Article 259 of the Constitution. A declaration that any proceedings in regard to impeachment of the first interested party taken by the second and fourth petitioner respondents outside the select committee of Senate under Article 145, Subarticle 3B of the Constitution are unconstitutional and void. F, a declaration that the first respondent is not legally constituted in light of the mandatory provisions of Article 27, 81B, 102, 61 of the Constitution on the 2/3 gender requirement. G, a declaration that the first respondent as currently constituted cannot entertain and deliberate the special motion for the removal of the first stated party by respondents. H, cost of the suit, and I, any other order or orders that this court may deem just. The third petitioner's submissions. Honorable Maina supplemented her positions by filing written submissions dated 9th of January 2026, and which she further orally highlighted in court. She identified the following issues for determination. 1, whether the public participation exercise conducted by the National Assembly on the 4th of October 2024 met the constitutional threshold under Article 118 of the Constitution. B, whether the yes-no templates deployed by the National Assembly violated constitutional requirements for meaningful public participation. 3, whether the Senate violated Article 118 by not conducting public participation at the Senate stage. 4, whether the Senate violated Article 145(3)(b) by failing to appoint a special committee of 11 members. 5, whether Standing Order 64(2) prescribing a 12-day impeachment timeline is constitutional. 6, whether the impeachment process violated Article 50 on fair hearing protections. And 7, whether the impeachment proceedings were conducted by impartial officers as required by Article 50, sub-Article 1 of the Constitution. Honorable Maina submitted that on the 3rd of October 2024. Honorable Justice Mongo, a judge of the High Court sitting at Kariguya, ordered inter alia that public participation be undertaken at the constituency levels so as to accord the public an opportunity to engage and offer their representations. That these orders were duly served and were never appealed, stayed, varied or reviewed, and as such, they remain binding on the respondents absolutely. Speaking to the obligation to obey court orders, Honorable Maina submitted that such obedience is foundational to the rule of law as was held in Law Society of Kenya and 3 others versus Inspector General of Police and 4 others reported in 2024 KEHC KLR. She submitted that this obligation extended even to cases where the person affected by an order believes it to be irregular or void, as was held in Refrigeration and Kitchen Utensils Limited versus Gulab Chand Popatlal Shah and others, the civil application number Nairobi 1339 of 1990. She further submitted that proper compliance required reasonable notice and not the same day or the next day notice. Physical accessibility at constituency level with open, identifiable venues in each of the 290 constituencies, facilitation of engagement, including civic sensitization, information, language diversity, disability access, and hearings as the primary mode, including oral and interactive engagement. Learned Counsel further submitted that the orders were not obeyed and only 200,000 participants countrywide who made up to 0.4% of the Kenyan population turned up for the exercise. Council declared the one-day notice published on a Saturday, whose contents were vague as they referred to constituency offices without addresses and times. She also pointed out that no hearings were ever organized, no facilitation was provided, and that CDF offices were closed and the MPs absent. Honorable Maina submitted that she became aware of the purported exercise only past midday and that none of her counterparts within the Kirinyaga County were aware of the exercise. She further submitted that even the citizens who visited the constituency venues found them locked and no officials or staff were inside. It was submitted that the National Assembly faced a binary choice of obeying the Constitution through the court order or preserve Standing Order 64(2), of which provided for 7 days deadline. They chose the latter, which Honorable Maina describes as contempt dressed as obedience. That a legislative outcome obtained in defiance of a binding court order cannot stand in a constitutional democracy governed by the rule of law as discussed by Lord Denning in McFoy versus United States Company Limited, United Africa Company Limited, reported in 1961, 3 All England Reports 1169, where the learned judge held that, I quote, if an act is void, then it is in law nullity. You cannot put something on it and expect it to stay there. It will collapse, end of quote. Honorable Maina also took issue with the yes and no template as constitutional fraud, as the National Assembly deployed a standardized template reducing 7 complex constitutional allegations into binary tick box questions. That citizens were asked whether they supported impeachment on each ground without being supplied with evidentiary material, explanatory memoranda, and His Excellency Gachaguas' response, relying on the Supreme Court and British American Tobacco BAT versus Cabinet Secretary for Health 2019, which we'll hereinafter be referring to as the BAT case. She articulated attributes of meaningful participation to include clarity of the subject matter for the public to understand, structures, processes that are clear and simple, opportunity for balanced influence from public, commitment to the process such that views can influence outcomes, and inclusive and effective representation. She also listed integrity and transparency of the process and capacity to engage on the part of public, including sensitization of the subject matter. Honorable Maina admitted that the digital-only, English-only mechanism systematically excluded rural residents, the elderly, persons with disabilities, the non-English speakers, and the non-English speakers. She stated that there were no physical venues for explaining the template or receiving oral views, that were only in 10, that there were only 10 pictures of people attached as evidence of attendance for the 5th October exercise, and that they were contained and that they were conflated responses from 4th and 5th October without distinction, obscuring the impact of the court's orders. She identified that the template was not a procedural imperfection, but an endorsement mechanism designed to manufacture numerical support for a predetermined outcome, and is therefore constitutionally void. It was her further submission that Article 118 imposes an independent obligation on each House of Parliament to facilitate public participation in its own business, that the Senate is not a subordinate appendage of the National Assembly, as was held in Speaker of Senate versus Attorney General, reported in 2013, where she stated that the Senate's role in impeachment is determinative under Article 145(7), as it performs a quasi-judicial function of the highest constitutional order. She held the position that the Senate could not constitutionally rely on the National Assembly's defective process, particularly where that process was conducted in defiance of court orders. That the Senate was aware of these defects as they were documented, litigated, and judicially acknowledged. Counsel submitted further that in Mwangaza versus Speaker of the Senate 2025, reported in 2025 Kinyalo reports, this court held that Senate must satisfy itself that public participation was adequate, and satisfaction requires inquiry, assessment, and independent judgment, but the Senate undertook none. That the Senate conducted no public participation whatsoever, as no notices were issued, no invitations were extended, no hearings were conducted, and no submissions were received, and that this is not a case of inadequate participation, but a case of none at all. It was also her submission that Article 145, Subarticle 3B of the Constitution provides that the Senate may appoint a special committee comprising 11 members of its members to investigate the matter. On that, it is submitted that the word may was a grant of power, not a license to bypass the Constitution, and that once the Senate had elected to proceed under Article 145, it must proceed within the architecture prescribed, which includes a special committee. She further stated that under Article 145, Subarticle 6, it provides that the Senate jurisdiction to vote is triggered only if a special committee reports that allegations have been substantiated, and absent a committee report, the gateway to plenary determination was not opened. She also stated that the constitutional function of the special committee was structured investigation, not political debate, receiving, interrogating, and testing evidence, producing a reasoned report, and insulating investigation from the volatility of plenary politics. That Article 145, Subarticle 5 of the Constitution, guaranteed the Deputy President the right to appear and be represented before the special committee, and by bypassing the committee, the Senate extinguished an entire constitutional hearing stage guaranteed to the Deputy President, thus violating the non-derogable right to a fair hearing. Learned Counsel submitted that standing orders confirmed this distinction as Standing Order 79 on the Deputy President impeachment provided for a special committee but no alternative. That Standing Order 80 of the Governor's impeachment procedure impeachment expressly provides two alternatives, that is a special committee or a plenary investigation. It was then posited that where the drafters intended to permit plenary investigation, they could have said so, and that the omission of the Deputy President must be respected. Learned Counsel drew parallels to Section 3B of the County Governments Act, which provides that the Senate may appoint a special committee in governor impeachments, and that the courts, including Wambura, have held that this confers discretion, and the Senate has lawfully proceeded in plenary. That those decisions underscore the opposite point, that where law expressly provides alternatives, discretion exists, but where the Constitution provides only one investigative pathway, the discretion does not extend to inventing another. She submitted that by proceeding to plenary determination without appointing a special committee, the Senate acted without jurisdiction, bypassed a constitutionally mandated investigative stage, and extinguished a guaranteed hearing rights. She also submitted that Senate had collapsed constitutionally distinct phases into a single political exercise, and the impeachment proceedings were therefore unconstitutional, null, and void ab initio. It was a further submission that Standing Order 64-2 lay at the heart of the constitutional infirmity, as it imposed unreasonable timelines that rendered compliance with the Constitution impossible. Council invoked Article 2.4 of the Constitution, which provides that any law that is inconsistent with the Constitution is void to the extent of the inconsistency. She placed reliance on Orange Democratic Movement Party versus Speaker of the National Assembly, reported in 2024, where this court affirmed that standing orders cannot override the Constitution nor substitute the constitutional requirements of public participation as expounded by the courts. In that light, Parliament's invocation of good faith was faulted, it being argued that Standing Order 64-2 structurally precluded constitutional compliance. She submitted that where standing order made adherence to constitutional obligations impossible, such a standing order is itself unconstitutional. It was further submitted that Standing Order 64-2 embodied a deliberate parliamentary choice to prioritize political expediency over constitutional safeguards. By prescribing rigid timelines, it ensured that once an impeachment motion gained initial traction, the process would be driven to conclusion before public sentiment could evolve, before courts could intervene meaningfully, or before the affected office holder could mount an effective defense. Counsel argued that this was precisely what the Constitution sought to prevent, since impeachment is not a mere vote of no confidence, but a quasi-judicial constitutional process carrying grave consequences. On that basis, it was argued that this court should declare Standing Order 64-2 unconstitutional, null and void to the extent that it prescribed timelines incompatible with constitutional requirements, and that any impeachment conducted under its terms is tainted with illegality from inception. On the question of whether His Excellency Gachaguas was accorded a fair hearing, Honorable Maina submitted that he was hospitalized with chest pains on the eve of the Senate proceedings. Despite medical evidence of incapacity, the Senate proceeded with the hearing and voted, thereby violating the most basic tenet of the fair hearing rule, audi alterem partem, meaning no person shall be condemned unheard. Counsel further argued that the 12 days between service of the motion and the National Assembly vote were constitutionally inadequate, given that Article 50, Subarticle 2B, guaranteed the right to have sufficient time and facilities to prepare defense. His Excellency Gachaguas, it was emphasized, faced 11 complex constitutional allegations, including gross violation of the Constitution, abuse of office, and corruption, for which 12 days was structurally insufficient. As the Supreme Court affirmed in Sonko case, which we referred above, impeachment proceedings attract the protections of Article 50, and where a fair hearing is denied, the process collapses. On the issue of bias and predetermination, Learned Counsel submitted that both Speakers of Parliament, as presiding officers over the impeachment motion, were constitutionally required to maintain impartiality, but acted contrary. It was argued that they assumed the role of initiators and proponents of the impeachment, thereby transforming into advocates for the motion rather than neutral arbiters. In particular, Speaker Moses Wetangula of the National Assembly was said to have participated in public statements endorsing the impeachment before presiding over the proceedings. Counsel emphasized that the test for bias is objective, where a reasonable, fair-minded observer would conclude that there exists a real possibility of bias, and submitted that the Speaker's public statements and advocacy for impeachment satisfied this threshold. Where the presiding officer is biased, she argued, the proceedings are fundamentally unfair, and the failure of the speakers to excuse themselves irredeemably tainted the process. For the above reasons, Honorable Maina urged the court to grant the relief sought in her petition. Next is the 4th to 8th petitioners' cases. The 4th to 8th petitioners in the consolidated petitions, that is Honorable David Munyi Madenge, Peter Gechobi Kamoto, Grace Modoni Mwangi, Clement Muchiri Muriuki, and Edwin Munene Kariuki, jointly filed a petition dated 18th of October 2024 before the High Court of Kenya at Kerugoya. They describe themselves as residents and leaders drawn from various constituencies within Kirinyaga County, and stated that they instituted the petition both in their personal capacities on behalf of their residents of their respective constituencies and in the wider public interest. The petitioners herein challenge the constitutionality, legality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachaguas, together with the subsequent nomination and approval process relating to Honorable Kindiki, relating to His Excellency Kindiki as Deputy President nominee nominee. They contended that the public participation process conducted by the National Assembly on the 4th and 5th October was illusory, inaccessible, and unconstitutional. In particular, they pointed to the issuance of short and ineffective notices, lack of sensitization, inaccessible venues, absence of parliamentary officials at designated constituency sites, closure of the Kirinyaga Central CDF Hall, and the overall failure by both the National Assembly and the Senate to facilitate meaningful participation as required under Articles 10 and 118 of the Constitution. The petitioners further asserted that Senate unlawfully conducted impeachment proceedings in plenary instead of through a special committee under Article 145(3)(b) of the Constitution, and that the rash timelines imposed under Standing Order 64(2) of the National Assembly standing orders were unconstitutional as they curtailed effective public participation and the hearing and the fair hearing rights. They also alleged that the Senate violated His Excellency Gachaguas' constitutional allegations. They also alleged that the Senate violated His Excellency Gachaguas' non-derogable rights under Article 25(c) and 50 of the Constitution by refusing to adjourn proceedings on the 17th of October 2024, despite his hospitalization and medical emergency, thereby denying him an adequate opportunity to be heard. In addition, the petitioners challenged the legality of the nomination and approval process of His Excellency Kindiki as Deputy President nominee, contending that the process contravened Sections 3 and 6 of the Public Appointments Parliamentary Approval Act, Chapter 7 of the Laws of Kenya, for want of adequate notice and public participation. The petitioners then sought the following prayers. A declaration that the appointment of Professor Kithure Kindiki, the second interested party herein, as Deputy President of the Republic of Kenya is invalid, null and void. B, a declaration that the National Assembly as a distinct organ is required to undertake its own distinct, proper, effective and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to the impeachment of a president or a deputy president. C, a declaration that the Senate as a distinct organ was required to undertake on its own distinct, proper, effective and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to a resolution from the National Assembly to impeach a president or a deputy president. D, a declaration that the public participation of as scheduled by the first and the second respondent on 4th of October regarding the special motion was not a proper and effective and meaningful public participation as envisaged in Articles 10 and 18 of the Constitution. E, a declaration that the extended public participation scheduled by the first and second respondents on 5th October 2024 was in disregard of the court orders issued by the High Court sitting at Kerugoya in constitutional petition number E014 of 2024, Honorable Jane Jerry Maina versus the National Assembly and 4 others, and was not a proper, effective and meaningful public participation as envisaged under Article 10 of the Constitution. F, a declaration that the impeachment process as against the first interested party was undertaken by the first and second respondents in view of the impugned, improper, ineffective and meaningful public participation held on the 4th and 5th October was unconstitutional and therefore void. G, a declaration that the failure by the third and the fourth respondents to undertake any public participation at all in regard to the impeachment proceedings in the Senate as against the first interested party renders the whole Senate impeachment process unlawful and void. H, an order of certiorari to bring up into this honorable court and quash the decision and or the resolution by the first and the third respondents made on the 8th of October 2024 and 17th of October 2024, respectively, resolving to remove the first interested party as Deputy President of Kenya by impeachment. I, a declaration that there exists no vacancy in the office of the Deputy President, allowing the fifth respondent to nominate anyone to fill such vacancy, and that any such nomination is unlawful and void. J, any other order or orders that this court shall deem just and expedient in the circumstances. K, cost of the suit. Next is the 4th to 8th petitioners' submissions. In their submissions led by counsel, Mr. Evans Ogada, together with Mr. George Sakimpa, the 4th to 8th petitioners identified the following issues for court's determination. A, whether the impeachment process complied with Articles 10, 118, 145, and 150 of the Constitution, whether the public participation conducted in the National Assembly and the Senate met the constitutional threshold of being meaningful, adequate, effective, and lawful. C, whether a standing order 64-2 of the National Assembly is unconstitutional for imposing rigid timelines that undermine constitutional safeguards. And D, whether Article 145 and applicable standing orders require that investigation into impeachment charges be conducted exclusively by a special committee of the Senate, not by the Senate sitting in plenary. They submitted that Article 10 binds all state organs, including Parliament, to the national values such as democracy, public participation, the rule of law, accountability, and good governance. That the impeachment process was conducted with severe haste and limited deliberation, undermining transparency, accountability, and public participation. They relied on the Supreme Court decision in Speak of the Senate versus AG and another reported in 2013, where it was held that Parliament was not exempt from constitutional discipline. They submitted further that Article 118 required Parliament to conduct business openly and facilitate public participation, and that this was not a formality, but a substantive constitutional obligation. They contended that the National Assembly gave the public less than 48 hours to consider complex, voluminous impeachment charges, which is a manifestly inadequate time frame, that no explanatory notes or responses from the Deputy President were provided, and that in some counties, like Kirinyaga, designated venues were inaccessible. They further asserted that the Senate conducted no independent public participation at all, as it relied on the National Assembly's deficient exercise, which cannot cure the constitutional breach. And they relied on authorities in Law Society of Kenya versus National Assembly of Kenya, 3 others, reported in 2025 KLR, National Assembly and another versus Okoit and 55 others, Civil Appeal number E003 of 2023, consolidated with others. This is the decision of the Court of Appeal. They also relied on the decision of Doctors for Life and and the decision in Legal Advice Center, and 2 others versus County Government of Mombasa. On the unconstitutionality of the National Assembly Standing Order 64-2, Learned Counsel argued that the provision imposes rigid and unreasonable timeline that make meaningful public participation impossible, and that while Article 124 empowered Parliament to make standing orders, such orders are subordinate to the Constitution and cannot defeat constitutional rights, and Article 2.4 voids any law inconsistent with the Constitution. The petitioners urge the court to declare Standing Order number 64-2 unconstitutional. As the matter in which the Senate proceedings were to be undertaken, counsel submitted that Article 145.3 provided that the Senate must appoint a special committee to investigate impeachment charges, and that the use of the conjunctive and between sub-articles A and B makes the special committee process constitutionally inseparable from the investigative phase. That Articles 145, Sub-Article 4, Sub-Article 5, and Sub-Article 6 refer exclusively to the special committee, and that there is no mention of plenary investigation or under expresso inius est exclusio ulterius, that excluded all other modes of investigation. The petitioners submitted Further, that the special committee ensued separation of investigations and adjudicative functions, preventing bias and predetermination, and the Senate's decision to bypass the special committee and proceed in plenary fused investigation, hearing, and the judgment into a single political process, violating the hierarchical and sequential structure of Article 145. Learned Counsel placed reliance on Martin Nyaga, Wambora, and 3 others was the Speaker of the Senate. This is the Court of Appeal decision, where the Court of Appeal held that the removal of a governor, which mirrors Article 145, is hierarchical and sequential in nature. Counsel argued that the Deputy President was denied a constitutionally prescribed procedural safeguard available to state officers facing removal, thereby violating Article 27 on equality and non-discrimination. They further submitted that Article 50 sub-article 1 guarantees the right to a fair hearing, which is expressly protected as non-derogable under Article 25C. Proceeding with impeachment proceedings while the Deputy President was hospitalized and rejecting a reasonable request for adjournment amounted to a gross violation of natural justice. Counsel emphasized that fairness was the unassailable foundation of any removal process. In support, they cited Gachaguas versus Speaker, National Assembly, and 3 others, High Court decision, where the High Court reaffirmed that the right to a fair hearing as non-derogable and that any violation renders the process null and void. Counsel concluded by submitting that the Constitution does not permit Parliament to sacrifice legality at the altar of expediency, and urged this court to reaffirm constitutional supremacy and protect the sovereignty of the people of Kenya. The petitioners prayed for declarations and that the impeachment process violated Article 10, 118, 145, and 150. A declaration that Standing Order 64-2 is unconstitutional, a declaration that the Senate unlawfully bypassed the special committee, and orders quashing the impeachment resolution. We'll now proceed to the 9th petitioner's case. Sheria Mtaani na Shadrack Wamboi, a public benefit organization, filed the petition dated 18th of October 2024, together with a supporting affidavit sworn by Dorcas Mwai, an advocate of the High Court of Kenya, and a director thereof. The petitioner stated that it is established to assist members of the public in assessing justice, protecting constitutional rights, and promoting the rule of law, constitutionalism, accountability, and good governance. The petition challenged the constitutional and the legal validity of the impeachment proceedings, leading to the removal of His Excellency Gachaguas from office as Deputy President, and further questioned the legality of the intended nomination and approval of His Excellency Kindiki as his replacement. It contended that the Senate proceedings conducted on the 17th of October 2024 violated His Excellency Gachaguas' constitutional rights under Article 25C, 47, 50, and 45, sub-article 5 of the Constitution. That the Senate unreasonably declined to adjourn the impeachment proceedings despite being informed that His Excellency Gachaguas had fallen ill and had been admitted at Karen Hospital, thereby denying him an opportunity to personally defend himself against impeachment charges. It was further alleged that the Senate acted in breach of the constitutional requirements of fair hearing, procedural fairness, and natural justice by proceeding with the impeachment in the absence of His Excellency Gachaguas, while allowing the proceedings to continue on the basis of strict constitutional timelines. It asserted that although the Constitution contemplated an expeditious impeachment process, the constitutional timelines could not override His Excellency Gachaguas' non-derogable right to a fair hearing and adequate opportunity to defend himself. Sheria Mtaani na Shadrack Wamboi further complained that the proceedings before Senate were rushed, insensitive, and conducted in a manner that prioritized speed over substantive justice and constitutional safeguards. Additionally, the 9th petitioner challenged the legality of the subsequent process initiated by His Excellency the President to nominate His Excellency Kindiki as Deputy President under Article 149 of the Constitution. It was contended that the nomination violated Articles 82, 88 and 137 of the Constitution because IIBC was allegedly not properly constituted and therefore incapable of lawful verifying the constitutional qualifications of any nominee to the office of the Deputy President. Sheria Mtani na Shadrack Wambui also argued that His Excellency Kindiki's nomination contravened Article 137 of the Constitution on the basis that he remained a serving Cabinet Secretary for Interior and National Administration at the time of his nomination. For these reasons, the organization sought the following prayers. A declaration be and is hereby issued that the rights and fundamental freedoms of the interested party herein to which his rights and fundamental freedoms under Articles 25, 50, 27, 47, 145 were grossly violated by the third respondent on the 17th of October 2024 for declining to grant him an adjournment on the Senate sitting deliberating on his removal from office by way of impeachment. B, a declaration does hereby issue that the decision by the third respondent to have the interested party removed from office by way of impeachment to the extent that it was done in gross violation of Articles 25, C, 50, 27, 47, and 145.5 of the Constitution was unconstitutional to the extent of its constitutionality and null and void ab initio. C, a declaration that any subsequent replacement of the interested party, if at all, to the office of the Deputy President of the Republic of Kenya was unconstitutional and therefore null and void ab initio. D, a judicial review order of certiorari does hereby issue to bring to its court to this court the decision of the third respondent as communicated via Gazette notice dated 17th of October 2024 communicating the removal from office of the Deputy President from the office by way of impeachment. E, a judicial review order of certiorari does hereby issue to bring to this court the decision of the President of the Republic of Kenya nominating His Excellency His Excellency Kindiki as the Deputy President of the Republic of Kenya for the purpose of quashing and the said appointment, and that the said appointment failed the qualification for the Deputy President as provided for under Article 137(2) B and 3 of the Constitution. F, alternatively, this court be pleased to make a declaration that the appointment of the Deputy President by the President to fill in the vacancy arising from the removal of the interested party from office pursuant to Article 149 of the Constitution must be read together with Article 82 and 88 of the Constitution to give the IBC its constitutional mandate to approve the name of the nominee as proposed under Article 149 of the Constitution. G, a declaration be made that the approval of Professor Kithure Kindiki or any other person as Deputy President of the Republic of Kenya is subject to Article 82 and 88 and 137 of the Constitution. Costs of the petition be provided, interest on one above at court rates till payment in full, and this court be pleased to make any further and other relief as it may deem fit in the circumstances. In respect of the 9th respondent submissions, led by Counsel Shadrack Wambui, the 9th respondent identified 3 principal issues for court's determination. A, whether the nomination of a Deputy President can be legally finalized or approved in the absence of a fully constituted commissioners of the IBC under Articles 82 and 88 of the Constitution. B, whether the Senate's refusal to grant His Excellency Gachaguas an adjournment due to documented illness during the impeachment proceedings constituted a breach of the rights to a fair hearing and natural justice under Articles 25C, 47 and 50 of the Constitution. And C, whether the nomination of Honorable Kindiki while serving as a Cabinet Secretary is constitutionally infirm for violating eligibility criteria under Article 148 as read with Article 137. A learned counsel submitted that His Excellency Gachagua fell suddenly ill on the afternoon of the 17th of October 2024 when he was scheduled to defend himself before the Senate, and that the Senate rushed the proceedings and unnecessarily and unreasonably declined to adjourn to allow him to recuperate. That the Senate proceeded with ex parte proceedings, leading to his removal from office in his absence, which violated Articles 25C, 51, 47, and 145.5. The organization relied on the Supreme Court decision in Kidero and 4 others versus Waititu and 4 others, reported in 2014, which affirmed that fair hearing incorporates the audi alteram partem principle, and also referred to the Court of Appeal in Judicial Service Commission versus Mutava and another, reported in 2015, KLR, which held that rules of natural justice apply to all bodies exercising judicial, quasi-judicial, or administrative duties. It submitted that Senate has no prescribed time limitation for completing impeachment proceedings, and the rushing was unjustified. It was the organization's submissions that Article 148.1 requires that a person nominated as deputy president must satisfy the requirements of Article 137 and 137.1b or 137, and that Article 137.1b provides that a person is not eligible for nomination as president and by extension deputy president if they hold any other state office, and that Article 260 defines state officer to include a cabinet secretary. It submitted that at the time of his nomination and parliamentary approval on 18th of October 2024, His Excellency Kindiki was serving as the cabinet secretary for Interior, and therefore he did not satisfy the constitutional eligibility criteria, rendering his nomination null and void ab initio. It was the organization's further submission that at the material time in October 2024, the IBC was not fully constituted and it lacked the requisite number of commissioners, as the previous commissioners had resigned or retired. Articles 82 and 88 establishes a constitutional architecture requiring a lawful and fully constituted IBC to oversee electoral and nomination processes, and that the Supreme Court in IBC versus AG Advisory Opinion number 4 of 2024, reported in 2025, held that a clear distinction must be drawn between administrative continuity by the Secretariat and the exercise of constitutional authority vested in the Commission as a collegial entity. It submitted that the exercise of constitutional functions reserved for the Commission under Article 88, Subarticle 4, cannot be lawfully discharged in the absence of a properly constituted Commission with the requisite quorum. It was further submitted that in the absence of commissioners, IBC was constitutionally incapable from undertaking its mandated electoral processes, and that the approval of a deputy president nominee, the second highest constitutional office, is no less a substantive constitutional responsibility than the limitation of boundaries, and the same principle applies with equal force. The organization urged this court to apply Article 10 on the national values and principle of governance that brings all state organs, Article 20, Subarticle 3b on in the Dubia Pro Libertate doctrine, that where in doubt, the court ought to adopt the interpretation that most favors enforcement of a right or freedom enunciated in Jacqueline Okuta and another versus AG, High Court, reported in 2017, and that it further submitted that the unconstitutional exercise of a legislative mandate cannot be shielded from judicial scrutiny, as was held in Commission for Implementation of Constitution versus National Assembly of Kenya and 2 others, 2013, KLR, reported. In the end, the petitioner prayed that the petition be accordingly allowed. I now proceed to the 10th to 41st petitioner's case. That's yours. That's yours. Proceed.
Let me take the 10th to 41st petitioner's case. The 10th to 41st petitioners are a group of Kenyan citizens and one registered association, primarily from Central Kenya region. They filed the petition dated the 17th of October 2024. That was amended on the 18th of June 2025 and re-amended on the 16th of December 2025. They challenged the constitutional validity of the impeachment process and subsequent removal of H.E. Gachaguas as Deputy President of Kenya, stating that the National Assembly and the Senate failed to comply with Article 152 of the Constitution, which requires them to modify the presidential impeachment procedure under Articles 144 and 145 for the Deputy President. They said that instead they applied the same rules under Standing Order 64 and 65 for the National Assembly and Standing Order 78 and 79 for the Senate without necessary modifications, ignoring that the Deputy President does not have the same powers, prestige, or legal immunities as the President. The petitioners aver that this failure rendered the entire impeachment process invalid, null and void ab initio, and violated the right to a fair hearing under Articles 25, 27, and 50. It was their further position that the impeachment was not a genuine parliamentary process but was engineered, sponsored, and bulldozed by political and financial inducements to capture parliament, turning it into a tool to remove the DP and settle political scores, thereby subverting the sovereign will of the people who elected the Deputy President in the August 2022 general election. They asserted that the President and the Deputy President were elected on a joint ticket and that the impeachment violated the rights of the petitioners and other voters from the Central Kenya region who voted for that joint mandate. The petitioners also highlighted and incorporated arguments from Nairobi High Court Constitutional Petition 356 of 2024. In that matter, it was alleged that both H.E. President Ruto and H.E. Gachagua had violated their oaths of office and the Constitution through various actions. Specifically, it was claimed that the President accepted foreign gifts valued at approximately Kenya shillings 240 million in the form of paid-for jet hire and fuel costs for a state visit to the United States, thereby exceeding the legal threshold permitted for such gifts. It was further alleged that the President entered into a secretive treaty with the United States to designate Kenya as a non-NATO ally without tabling the agreement before the National Assembly and Senate as required by constitutional oversight. Additional claims included intimidation and threats directed at members of parliament to bypass oversight, as well as inducement of political defections to artificially control the majority party coalition. The petitioners accused the President of using state violence to criminalize and suppress the Gen Z, otherwise read the Generation X good governance protests, as well as the July 2023 protests against oppressive taxation and the high cost of living, and that he distributed state appointments along acute ethnic lines. Additionally, H.E. Gachagua was faulted for publicly dividing Kenyan citizens into shareholders and non-shareholders in quotes based on political alignments, whereas H.E. President Ruto is accused of spending hundreds of millions of public funds to conduct avoidable by-elections caused by appointing sitting MPs and senators to the cabinet. The petitioners further argued that the Kenya Kwanza coalition agreement binds H.E. President Ruto to nominate a replacement deputy president from the Gikuyu, Embu, or Meru communities, which is the same region as the impeached deputy president. They sought a declaration that the President's power to nominate a new Deputy President was subject to certification by the IEBC, that the nominee meets qualifications under Articles 99 and 137, stating that the 14-day and 60-day timelines in Article 149 were meant to ensure public participation across all 90 constituencies. Consequently, the petitioners asked the court to declare the nomination and approval of H.E. Kindiki as the new deputy president as unlawful, null and void. The petitioners thus sought the following reliefs from this court. 1. A declaration be issued to declare that the first petitioner was impeached by the National Assembly and removed by the Senate under a procedure that violated Articles 27, 50, and 150 sub-article 2 of the Constitution. 2. A declaration be issued to declare that the first and second respondents have violated the rights of the petitioners and other voters and residents of Central Kenya region by failing to govern together in accordance with their joint mandate secured during the presidential election held on the 9th of August 2022. 3. A declaration be issued to declare that the first petitioner was impeached by the Parliament under the respective standing orders of the National Assembly and the Senate that offends Article 150 sub-article 2 of the Constitution. 4. A declaration be issued to declare that the impeachment of the first petitioner was null and void ab initio on account of the violation of Articles 25, 27, and 50 of the Constitution, read together with Articles 144, 145, and 150 of the Constitution. 5. A declaration be issued to declare that the second and third to 14th respondents have conspired and schemed to remove the second respondent from office through impeachment in violation of Articles 1, 27, and 38 of the Constitution. 6. A declaration be issued to declare that the second respondent violated Articles 110, 118 and 150 of the Constitution in passing a resolution on 8th October 2024 to remove the second respondent from office. 7. An order of certiorari be issued to quash the resolution of the second respondent passed on 8th October 2024 to approve the motion of impeachment of the first petitioner tabled on 1st October 2024 by the 9th respondent. 8. A declaration be issued to declare that the 6th respondent's power under Article 149 of the Constitution to nominate a person to occupy the office of the Deputy President is subject to certification by the Independent Electoral and Boundaries Commission under Articles 99 and 137 of the Constitution. 9. A declaration be issued to declare that the 14 days period prescribed under Article 149 for the President to nominate a person to occupy the office of Deputy President is to ensure compliance with Articles 10, 38, 99, and 137 of the Constitution. 10. A declaration be issued to declare that the 60 days period prescribed under Article 149(1) of the Constitution for the National Assembly to vote on the President's nomination to fill the vacancy in the office of the Deputy President is to ensure compliance with the requirement of public participation in all the 290 constituencies in accordance with Article 1, 10, 27, 38, 118, and 136 of the Constitution. 11. That by dint of Articles 1, 10, 27, and 38 of the Constitution, the first respondent is bound by the Kenya Kwanza Coalition Agreement dated the 5th of April 2022 to nominate a qualified person from either of the Gikuyu, Embu, and Meru communities to fill the vacancy in the office of the Deputy President occasioned by the impeachment of the second respondent. 12. A declaration be issued to declare that the sixth respondent's nomination and of approval, therefore, by the National Assembly of HE Honorable Kithure Kindiki, the second interested party herein, as Deputy President is unlawful, null and void ab initio. 13, the Honorable Court be pleased to issue an order of certiorari to quash the nomination by the National Assembly of Honorable Kithure Kindiki as a Deputy President via Gazette notice published in a special issue of the Kenya Gazette dated 18th October 2024. And 14, a declaration be issued to declare that by dint of Articles 1, 10, 27, 38, 91, and 132 of the Constitution, the citizens of Kenya from the Gikuyu, Embu, and Meru communities have a right secured by the results of the presidential election held on 9th August 2022 to have one of them to occupy the office of the Deputy President during the tenure of the first respondent as the President of Kenya. 15, a declaration be issued to declare that Standing Orders number 64 and 65 of the National Assembly Standing Orders violates Article 152 of the Constitution. 16, an order of certiorari be issued to quash Standing Orders 64 and 65 of the National Assembly Standing Orders to the extent that they apply to the Deputy President. 17, a declaration be issued to declare the Standing Orders number 78 and 79 of the Senate adopted on the 16th of June 2024 violates Article 152 of the Constitution. 18, an order of certiorari be issued to quash Standing Orders number 78 and 79 of the Senate as adopted on 16th June 2024 to the extent that they apply to the Deputy President. 19, an order of mandamus be issued to compel the National Assembly and the Senate, that is the second and fourth respondents herein, to promulgate a procedure for removal of the Deputy President by impeachment envisaged by Article 152 of the Constitution. 20, that a declaration be issued to declare that the first petitioner was impeached through a procedure that amounted to political persecution and vendetta prescribed by Articles 1, 3, 38, and 50 of the Constitution. 21, that a declaration be issued to declare that the sixth respondent engineered, sponsored, and bulldozed the impeachment of the first petitioners in a manner that amounts to abuse of power in violation of Articles 1, 3, 38, 50, and 131(2) of the Constitution. 22, cost of the petition be borne by the first and fifth respondents. The 10th and 41st petitioners' submissions. In these submissions, the petitioners reiterated that the impeachment proceedings did not stem from legitimate constitutional violations. Instead, they arose directly from a severe political fallout and a politics of betrayal, in quotes, between HE President Ruto and HE Gachagua. They submitted that the impeachment motion was originally assigned to Sirisia MP, Honorable John Waluke, but however, due to his tainted image from a high-profile corruption case, Honorable Mutuse was brought in as a substitute mover to table the motion on the 1st of October 2024. The petitioners listed the following issues for the court's determination. A, whether the impeachment of H.E. Gachagua was a political witch hunt or a genuine procedure. B, whether H.E. Gachagua was impeached by the National Assembly and the Senate under a procedure that violated Articles 27, 50, and 152 of the Constitution. C, whether H.E. Gachagua was lawfully found guilty of Ground 1 of the Articles of Impeachment. D, whether the Standing Orders number 64 and 65 of the National Assembly and Standing Orders number 78 and 79 of the Senate, under which H.E. Gachagua was impeached, violate Article 152 of the Constitution. E, whether the Senate's failure to establish a special committee under Article 145(6) of the Constitution rendered the removal of H.E. Gachagua as null and void ab initio. Issue F, whether H.E. Gachagua was subjected to a lawful and fair trial by the Senate. G, whether the 1st to 11th respondents conspired or schemed to remove H.E. Gachagua from office in violation of Articles 1, Article 27, and 38 of the Constitution. On the weaponization of impeachment for political settlements, the petitioners maintained that the impeachment was completely manufactured by a political fallout rather than the genuine existence of any lawful grounds under Article 151(b) of the Constitution. That it was fundamentally unconstitutional for the executive and parliament to use the sacred device of impeachment as an administrative tool to resolve purely political disputes and vendetta. They submitted that the impeachment proceedings inside both the National Assembly and the Senate were weaponized and conducted in absolute violation of substantive and procedural provisions guaranteed under the Constitution, as well as the standing orders of both chambers. They specifically maintained that the current rules governing the process, that is, Standing Orders 64 and 65 of the National Assembly and Standing Orders 78 and 79 of the Senate, violate Article 150 sub-Article 2 of the Constitution and must be quashed. The petitioners equally submitted that H.E. President Ruto's power to nominate a replacement under Article 149 was strictly subject to certification by IEBC under Articles 99 and 137, and because the 14-day and 16-day constitutional windows under Article 149 are designed to guarantee rigorous public participation across all 290 constituencies, the rushed nomination and approval of H.E. Kindiki was unlawful. It was null and void ab initio. That rushing this process directly violated the political rights of the petitioners under Article 38. A fortiori, the petitioners argued that this court has an obligation to step in and quash the impeachment to halt an ongoing executive scheme to re-establish an imperial presidency in Kenya, and they warned that Parliament has become subservient and sycophantic to the executive, acting like the single-party rubber stamp parliaments of the late 1980s, which present an existential threat, to Kenya's constitutional democracy. They restated the prayers that sought to declare the impeachment null, void, and an act of political persecution that violated Articles 25, 27, 50, and 150 of the Constitution, and orders of certiorari quashing the National Assembly's 8th October 2024 resolution approving the impeachment motion, and Gazette Notice 13401, which appointed H.E. Kindiki as Deputy President. They also sought to quash the National Assembly Standing Orders 64 and 65 and Senate Standing Orders 78 and 79 to the extent that they apply to the removal of a Deputy President and orders to compel both chambers of Parliament to promulgate a legally compliant, constitutionally envisaged procedure for removing a deputy president under Article 150 sub-Article 2. The petitioners relied on various local authorities, including the Sonko case earlier mentioned, as well as Jirongo versus Soy Developers Limited. They also relied on foreign authorities, including Kriegler versus the Law Society of Alberta, Republic R versus Budry, R versus Campbell, R versus Reagan, all of which citations you will find in the judgment, all from the Supreme Court of Canada. Further reliance was placed on books, articles, speeches, and reports, as well as interview statement by Senator Edwin Sifuna on the Senate floor as per the Hansard of 9th October 2024, and an interview statement by H.E. Gachagua on Inoro TV. In the end, the petitioners prayed that their petition be allowed as prayed. Moving on to the 43rd petitioner's case, Mr. Morara Omoke filed the petition dated 9th October 2024 before the High Court of Kenya at Eldoret, together with a supporting affidavit sworn on the same date in his capacity as a Kenyan citizen and patriot, acting in defense of constitutionalism, the rule of law, and democratic governance. The petition challenged the constitutionality and legality of the impeachment proceedings commenced against H.E. Gachagua by the National Assembly and Senate. He contended that the impeachment process was politically motivated, defective, unconstitutional, and undertaken in violation of the sovereign will of the people expressed during the 2022 general election. His case centered on the alleged violations of Article 1, 10, 38, 47, 48, 50, 73, 75, 94, 118, 145, and 150 of the Constitution, that the impeachment motion tabled by the Honorable Motuse had not been preceded by adequate public participation, and that the MPs who appended their signatures in support of the motion failed to consult their constituents before supporting the impeachment process. He further alleged that the process of collecting signatures in support of the impeachment motion was tainted by bribery, undue influence, intimidation, and forgery of signatures belonging to some MPs. He contended that the subsequent public participation exercise conducted on 4th and 5th October 2024 was merely cosmetic and incapable of constituted, inadequately publicized, and conducted through only one center per county and constituency. He also complained that the public participation forms contained only the allegations against H.E. Gachagua and omitted his responses, thereby condemning him unheard and violating the principles of fairness and natural justice. He also alleged bias and conflict of interest on the part of the Speaker and Deputy Speaker of the National Assembly. He contended that both office holders publicly supported the impeachment process before the motion was tabled and debated in Parliament, thereby compromising their constitutional obligation to act as neutral and impartial arbiters during the proceedings. He asserted that the impeachment motion was politically motivated and arose from internal disputes within the UDA party, yet the parties involved had failed to exhaust internal party dispute resolution mechanisms under the party constitution before initiating impeachment proceedings. He also argued that there existed no comprehensive statutory framework governing impeachment proceedings and the collection of signatures for impeachment motions, thereby rendering the process legally deficient and constitutionally uncertain. Mr. Omoke then sought the following orders. A declaration that the impeachment motion moved by the third respondent does not meet the threshold set out in Article 145 as read with Article 150 of the Constitution. B, a declaration that the impeachment of Geoffrey Rigathi Gachagua was unconstitutional. C, a declaration that the Speaker and Deputy Speaker of the National Assembly were biased and ought to have disqualified themselves from the impeachment process. D, a declaration that the impeachment motion violated the interested parties' rights under Article 32, 33, 38, 47, 48, 50, 73, and 75 of the Constitution of Kenya 2010. E, a declaration that the impeachment motion against the interested party was tabled in a manner that violates Article 110, 94, and 118 of the Constitution, as no public participation was conducted by Honorable Mutuse Ekomas Mwengi and by the members who appended their signatures prior to moving the impeachment motion in the National Assembly. F, a declaration that the impeachment motion, which was a result of a dispute in the United Democratic Alliance Party, was tabled before the National Assembly without exhaustion of internal remedies, contrary to the exhaustion doctrine and Article 159 of the Constitution of Kenya. G, a declaration that in the absence of an enabling legislation operationalizing the provisions of Article 150 of the Constitution of Kenya, there is no legislative and administrative framework within which the impeachment of the DP was anchored, and H, that each party bears its own costs. In his submissions, Mr. Omoke focused on two main issues, namely, whether the impeachment of H.E. Gachagua was unconstitutional and whether the lack of legislation to operationalize Article 150 of the Constitution vitiates the impeachment. He wholly adopted H.E. Gachagua's submissions dated 7th October 2025, submitting that the constitutionality of the impeachment transcends him and must be evaluated with a view to advancing constitutionalism and the rule of law. He maintained that public participation was inadequate and a sham, as the mover of the motion and the 291 MPs who appended their signatures in support of the impeachment motion did not conduct any public participation in their constituencies before signing, contrary to Articles 1, 10, 94, and 118 of the Constitution. That public participation was an afterthought, and when questions arose on 1st October 2024 about whether public participation should be conducted, the Speaker directed that it be held on 4th October 2024. The advertisement appeared on 2nd October 2024, which Mr. Omoke submitted was not a genuine intention to conduct any real public participation from the outset. That the public participation form provided by the National Assembly contained only the allegations against H.E. Gachagua and conveniently left out his response, denying the public the ability to effectively weigh the grossness of the alleged violations. He submitted that public hearings occurred for only 9 hours, from 8 a.m. to 5 p.m. on a normal workday, which was a Friday, meaning most Kenyans could not attend. That venues were changed on the eve of the exercise. For example, in Embu, it changed from IFAD Hall to Talent Academy, and in Nairobi, it changed from KICC to Bomas of Kenya. He submitted that in Kiambu constituency, only about 2,000 people attended in a county with over 1 million registered voters, that there was no proper coordination, and he described the situation as utter pandemonium akin to the Tower of Babel. He contended that in some areas, especially in Mount Kenya, public participation forms were faulty. There were incidents of pre-filled forms, and a vehicle ferrying pre-filled forms was torched in Nyeri County. That the National Assembly extended the exercise to the following day on the 5th of October 2024, but no proper notification was made and MPs kept away from the exercise. He added that in some constituencies like West Mugirango, the MP never opened the constituency office, and that the other the 1 center per county and 1 center per constituency is too deficient, as public participation should have been conducted at least at each polling station or at minimum each ward. Mr. Omoke submitted that the National Assembly neither processed nor considered the feedback collected, and the entire exercise was a mere sham to hoodwink innocent Kenyans. He accused Deputy Speaker Gladys Boss-Sholei of being biased in that on 23rd September 2024, while speaking at a function in Uasin Gishu County, she swore to spearhead the impeachment motion and put the Deputy President on notice, stating in quotes, "Mimi mwenyewe nitakupeleka nyumbani. In brackets, I will personally take you home." That she also hinted at some of the grounds of impeachment before the motion was even tabled. He further argued that Speaker Moses Masika Wetangula on 29 September 2024, while attending a church function at Wamonyo Catholic Church in Machakos County, publicly took a stand on the impeachment motion before it was tabled. Using the biblical description in Mark 9:38-50, he stated that H.E. Gachagua, being a part of the body that leads to sin, should be cut off. These utterances he submitted violated Articles 47, 50, and 150 of the Constitution, and that neither the Speaker nor the Deputy Speaker should have presided over the impeachment motion. Mr. Omoke submitted that the Constitution sets a high threshold for impeachment as a measure is a grossness of alleged violations, and that grudges and squabbles cannot be the basis for removal. He contended that extraneous grounds were introduced on the floor on 8 October 2024, as it was alleged that H.E. Gachagua had referred to Honorable Florence Jematea Sergon, the countrywoman rep of Baringo, as a harlot. That Honorable Karoli Omondi, MP Suba North, referred to conversations he had with H.E. Gachagua without providing any proof. Honorable Patrick Makau, MP Mavoko, also made references to conversations without providing any proof. On the vote that 281 MPs supported the motion, 44 opposed, and there was 1 absentee, Mr. Omoke submitted that MPs abdicated their obligation to weigh the grounds against the intermediate standard of proof set by the Supreme Court in Odinga and 5 others versus IEBC and 3 others. That the impeachment overturned the decision of 7,176,141 Kenyans who voted for the joint ticket on 9th August 2022, a decision upheld by the Supreme Court, and that the motion was an egregious overthrow of the decision of the majority with that of a few. It was Mr. Omoke's further submission that no statutory legislation exists on the process of impeachment of the President and Deputy President from start to completion, as no legal framework exists on the collection of signatures in support of an impeachment motion. Therefore, there is no framework upon which the impeachment of the Deputy President was anchored. He submitted that in D and others, that is the Attorney General, this court was persuaded by Mr. Omoke, who was a petitioner therein, that the lack of legislation on signature collection and verification and on the conduct of referenda initiated the BBI process. He submitted that the same principle applies here, and that legislation is so central to the fairness of the process that the court ought to, at minimum, issue a structural edict requiring enactment of this legislation. He submitted that areas requiring legislation include initiation of the impeachment process, how Parliament is to process impeachment, particularly public participation, and the actual impeachment trial, the replacement of an impeached deputy president, provision for judicial intervention before an impeached president or deputy president is replaced, including grant of conservatory orders to preserve the rights of the impeached official, and expeditious hearing of petitions arising from an impeachment. Mr. Omoke saw no reason why the court could not have maintained the conservatory orders in favor of H.E. Gachagua and had the petitions within a week or two. That the discharge of the orders, followed by an immediate declaration of a public holiday for the swearing in of a new deputy president, left a mind-boggling question on the efficacy of Article 50 of the Constitution. For these reasons, Mr. Omoke prayed for a declaration that the impeachment of H.E. Gachagua was unconstitutional, and that a declaration that the absence of legislation operationalizing Article 150 of the Constitution rendered the impeachment process of the deputy president flawed. We look at the 44th to 48th petitioner's case. Obuli Namenya, Kennedy Kareithi Gachege, Dennis Okumu, Simon Mushangi, and Peter Maina Kanene jointly filed the petition dated 30th September 2024 before the High Court of Kenya at Nairobi. They describe themselves as Kenyan citizens committed to constitutionalism, the rule of law, and defense of the Constitution, and that they also instituted the petition in the public interest to challenge the proposed impeachment of H.E. Gachagua as Deputy President of the Republic of Kenya. As per their petition and the supporting affidavit sworn by Obuli Namenya, the petitioners challenged the constitutionality of the impeachment process on the basis that Parliament had failed to establish a proper legal and procedural framework governing public participation in impeachment processes under Article 118 and 124 of the Constitution. The petitioners contended that neither the National Assembly standing orders nor the Senate standing orders provided mechanisms, procedures, threshold, timelines, verification methods, venues, or modalities for meaningful public participation in impeachment proceedings, thereby rendering contemplated impeachment process unconstitutional. They further argued that public participation was a mandatory constitutional prerequisite which ought to precede any impeachment process, and asserted that the 7-day timelines prescribed under Standing Orders 64 and 73 for disposal of impeachment proceedings were inadequate and unconstitutional, as they undermined effective public participation and violated the rights to fair administrative action and fair hearing under Articles 47 and 50 of the Constitution. The petitioners additionally alleged that the impeachment process was politically motivated and tainted by bias and lack of impartiality on the part of parliamentary leadership, citing public pronouncements by parliamentary leaders in support of the impeachment motion. They advanced a historical argument concerning the office of the Vice President and Deputy President in Kenya, contending that successive Deputy Presidents had historically been subjected to political hostility, dismissals, and frustration, which informed the constitutional design of 2010, requiring the President and Deputy President to be elected jointly. The petitioners then sought the following prayers: a declaration that the impeachment process of a deputy president is a sui generis in nature, and that public participation forms a fundamental background that plays a significant role in attaining the right to a fair trial enshrined under Article 50 of the Constitution. B, a declaration that public participation is the only avenue or means through which the people can exercise their sovereignty contemplated under Article 1 of the Constitution in determining whether an office created under the Constitution ought to be abolished or whether accountability mechanisms created under this Constitution ought to be put in motion or otherwise, and that the lack of elaborate procedure or certainty as to when the same should commence or conducted will ordinarily amount to usurpation of the people's power and subsequently amount to a violation of the Constitution. C, a declaration that the Article 118 sub-Article 2 that clearly provides for mandatory public participation and Article 124 creating the requisite parliamentary standing orders. Neither the National Assembly nor the Senate had enacted an Act of Parliament providing for the procedure on how the impeachment of either the President or Deputy President is to be undertaken, nor has the National Assembly Standing Order 64 or 65 or the Senate Standing Order number 74 provided for the procedure governing the crucial element of public participation relating to the impeachment of a deputy president. D, a declaration that the National Assembly Standing Order 64 and 65 or the Senate Standing Order number 74 are unconstitutional as they were never subjected to the mandatory public participation during their enactment. E, a declaration that the standing orders must with certainty and clarity provide that the public participation contemplated under Article 118 should be a conditional precedent that must precede all other processes relating, connected, or incidental to the impeachment of the Deputy President. A declaration that Article 27 requires that all Kenyans must be subjected to the principle of equality and equal protection of the law, while Article 47 requires that a person must be subjected to an administrative process that is procedurally fair, expedited, reasonable, and lawful, irrespective of one's status in society, and that the respondents herein have violated the same by commencing an impeachment process that is constitutionally tainted with illegalities. G, a declaration that public participation in an impeachment process is a fundamental infrastructure that facilitates the enjoyment of Article 50 and that the absence of the same will amount to the respondents herein violating, denying, threatening, or infringing the interested party's right to a fair trial during his impeachment. H, a declaration that time is an important resource for any judicial or quasi-judicial tribunal contemplated under the Constitution, and that the 7 days period for impeachment provided for under Standing Order 64(2)(b) of the National Assembly Standing Orders and the Senate Standing Order 73(1) amounts to conducting a sham trial and the same will amount to a violation of Article 50. I, a declaration that Standing Order 64(2)(b) of the National Assembly Standing Orders and the Senate Standing Order number 73(1) does not provide for the sufficient and adequate time for carrying out a qualitative, quantitative, meritorious, accurate, and secure public participation, the hearing and determination of the impeachment trial before Parliament that will result into a fair, just, impartial, and judicious determination of the impeachment trial as contemplated under Article 47 and 50 of the Constitution. J, a declaration that for purposes of authenticating and verifying the results of the participants taking part in the public participation, confirming all the requisite legal thresholds like that of citizenship, the total number of participants, public participation ought to be undertaken by an impartial state organ separate from Parliament. Looking at the 44th to 48th petitioners' submissions, led by learned counsel Mr. Njiro Ndegwa, the petitioners focused on the constitutional architecture governing impeachment of a deputy president, submitting that the process was fundamentally flawed because impeachment is a measure of last resort, not a primary accountability tool, and that the Senate failed to apply the mandatory modification rule under Article 152, which requires that Articles 144 and 145 be applied in court with necessary modifications to the deputy president. Mr. Ndegwa submitted that the proceedings violated fair hearing rights under Article 50, including the refusal to adjourn when the deputy president fell ill, that the process was infected with bias, irrelevant considerations, and procedural violations of the Standing Order 75, 78, and 80, and that the cumulative defects render the entire impeachment null and void. The petitioners adopted and relied on H.E. Gachaguas submissions and the Wambora principles on quasi-judicial impeachment proceedings and identified the following issues for determination: whether the impeachment of the deputy president met the constitutional threshold of a measure of last resort in light of the availability of alternative constitutional and statutory mechanisms, whether the constitutional framework governing the impeachment of a deputy president under Article 150, Sub-Article 2 was properly invoked, applied, and distinguished from the regime governing the impeachment of a president under Article 145. Whether the Senate complied with the mandatory requirement to apply Articles 144 and 145 with necessary modifications as contemplated under Article 152 and Standing Order 79. Whether the failure to apply the modification rule undermined the constitutional principles of sovereignty of the people, national values, and political rights, including the legitimate expectation of tenure. Whether the impeachment process satisfied the constitutional and jurisprudential standards applicable to quasi-judicial proceedings as articulated in the Wambora decisions. Whether the Senate's failure to comply with constitutional requirements renders the impeachment process null and void. Whether the impeachment process violated the deputy president's right to equality and equal protection of the law under Article 27. Whether Parliament, in conducting the impeachment proceedings, acted as an impartial and unbiased quasi-judicial body as required by law. Whether the debates and proceedings in both the Senate and the National Assembly were confined to the substantiation of the charges or were contaminated by irrelevant, extraneous, and prejudicial considerations. Whether the refusal to grant an adjournment upon the deputy president falling ill violated his right to a fair hearing under Article 50, including the right to be present and to be adequately present, to adequately present his defense. Whether the Senate misapplied Standing Order 78 by proceeding under a plenary hearing without affording procedural safeguards and by improperly treating the proceedings as time-bound. Whether The impeachment proceedings violated the Deputy President's right to adequate time and facilities to prepare a defense under Article 50, Subarticle 2A, and the right to be heard under Standing Order 80. Whether the Senate acted in violation of its own standing orders, including Standing Orders 75, 78, and 80, and the legal effect of such violations. Whether sufficient time existed within the constitutional and procedural framework to accommodate adjournment and ensure a fair hearing, and whether failure to utilize such time rendered the process unconstitutional. Whether the continuation of proceedings in light of the Deputy President's illness violated his fundamental rights to life, dignity, health, and access to justice under Articles 26, 28, 48, and the state obligations under Articles 10, 19, 20, and 21. And finally, what reliefs are available where a constitutional process is found to be procedurally and substantively defective. Learned Counsel submitted that impeachment is not intended to be a primary or convenient mechanism for addressing alleged misconduct, but rather an extraordinary remedy reserved for the clearest and most compelling cases where no other lawful avenue exists. They argued that the Constitution establishes a graduated hierarchy of accountability, beginning with civil liability, criminal prosecution, and administrative action, and only thereafter impeachment. It was emphasized that Article 143 expressly removes immunity from civil and criminal proceedings for the Deputy President, unlike the President. According to Mr. Ndegwa, this signals that allegations against a Deputy President should, in the first instance, be addressed through ordinary legal processes. Parliament, however, bypassed these mechanisms and resorted to impeachment as a first recourse, which Council contended offends the principles of proportionality, rationality, and legality. They further submitted that no evidence exists that Parliament considered whether the allegations could have been addressed through criminal investigation or civil proceedings before invoking impeachment. Council also drew attention to Article 152, which provides that Articles 144 and 145 apply to the Deputy President with the necessary modification. Council argued that this phrase is not ornamental, but a deliberate constitutional command requiring contextual adaptation of the presidential impeachment framework to the distinct office of the Deputy President. In their view, the requirement imposes an active obligation on the Senate to interrogate, adjust, and tailor the procedure rather than merely transplant it without reflection. Standing Order 79, they submitted, operationalizes this obligation by requiring the Senate to consciously and expressly apply the modification principle. Mr. Ndegwa submitted that nowhere in the Senate Hansard is the Speaker recorded as guiding the House on the necessity, the scope or content of the required modifications as the Senate proceeded, as though Article 145 applied mutatis mutandis and in toto without any modification. He stated that this failure is not merely procedural, but a substantive and jurisdictional issue which renders the entire process unconstitutionally defective ab initio. The petitioners submitted that this modification requirement ensures that impeachment is not invoked where alternative legal mechanisms, such as the courts, EACC or DCI are adequate. It was their case that the failure to modify denied the Deputy President the procedural safeguards that would have arisen from a properly tailored process, including consideration of alternative accountability mechanisms, flexibility in procedure to ensure fairness, and enhanced scrutiny of the necessary and proportionality of the impeachment. It was their submission that the office of Deputy President derives its legitimacy from the sovereign will of the people expressed at the ballot under Article 1, and impeachment without proper modification undermines this sovereign will and defeats the legitimate expectation of tenure for both the office holder and the electorate. That Article 38 guarantees citizens the right to elect leaders and to have them serve their full term, subject only to lawful and constitutionally compliant removal process, and that the failure to modify the process resulted in an unjustified interruption of the people's sovereign mandate. Mr. Ndegwa submitted that the Deputy President fell ill during the proceedings while actively engaged in his defense, and that this is not disputed and is recorded in the Senate Hansard. That the Senate refused to grant an adjournment, proceeding instead to a conclusion in his absence, and he submitted that this violated Article 52 on the right to adequate time and facilities to prepare a defense, and Article 52F on the right to be present when being tried, and Standing Order 80 on the right to be heard within Senate proceedings. That a hearing conducted in the absence of the principal defense participant due to verified illness cannot satisfy the conditional threshold of fairness. He stated that the Senate had sufficient procedural latitude under Standing Order 75 to adjourn without violating any constitutional timeline, but the refusal was not dictated by lack of time, but by a failure to exercise discretion fairly. The petitioner submitted that under Article 26 on the right to life, the state must refrain from actions that undermine physical well-being or exacerbate medical vulnerability, and that proceeding with impeachment during illness reduce the Deputy President to a procedural object rather than a rights-bearing participant. They stated that Article 48 on the access to justice extends to all adjudicative processes, including parliamentary impeachment, and that meaningful participation requires reasonable accommodation and denial of adjournment rendered access to justice illusory. They also submitted that the test for bias is objective, and whether a reasonable and informed observer would apprehend bias, and that senators acknowledged imperfections in the case but still voted to impeach, which demonstrated bias. They urged the court to address the impeachment process as a whole, not in fragments, noting that the petitioners have defects, including failure to apply the modification rule under 152, absence of impartiality and presence of bias, reliance on irrelevant and extraneous considerations, violations of fair hearing rights, misconstruction of the constitutional and procedural framework, and breach of Standing Order 75, 78, and 80. They submitted that individually, each defect is serious, and collectively, they reveal a process that is constitutionally unsound from inception to conclusion. That Article 165(3)(d) Roman 2 vests the High Court with jurisdiction to determine whether anything done under constitutional authority is inconsistent with or in contravention of the Constitution. They contended that this court is not being invited to to interfere with parliamentary politics, but is being invited to perform its core constitutional function as guardian of legality and fundamental rights, and where Parliament acts within constitutional bounds, the court defers, but where it acts outside those bounds, the court must intervene, not as an intruder, but as a constitutional necessity. As such, the petitioners urge the court to find that impeachment was not a measure of last resort when ordinary legal mechanisms were available and bypassed, that the Senate failed to apply the mandatory modification rule under Article 152, rendering the process unconstitutional ab initio, that the refusal to adjourn during illness violated Articles 50, 26, 28, and 48, that the proceedings were infected with bias and irrelevant considerations, and that the cumulative defects render the impeachment null, void, and of no effect. They then prayed that the petition be allowed in entirety.
I will then take over from the 51st petitioner's case. The 51st petitioner in the consolidated petition filed a petition dated 26th of September 2024 before the High Court of Kenya at Milimani as a public-spirited Kenyan citizen and a defender of the Constitution. Ms. Mwangi contended that the impeachment process was unconstitutional, unlawful, and politically motivated. She relied on public statements allegedly made by Honorable Didmas Baraza and Honorable Gladys Osholei in September 2024, indicating that the impeachment of H.E. Gachagua had already been predetermined, and further referred to a motion by Honorable Danson Mungatana expressing displeasure with the conduct of His Excellency Gachagua. Ms. Mwangi asserted that the allegations leveled against his H.E. Gachagua were vague, unsupported by evidence, and lacking in specificity and peculiarity, contrary to the constitutional requirements of fair hearing and due process under Articles 47 and 50 of the Constitution. She further alleged that the intended impeachment process mounted to a political witch hunt designed to settle political scores rather than a lawful constitutional process, and contended that the respondents had violated the national values and principles under Article 10, including the rule of law, transparency, accountability, equality, and protection of human rights. She maintained that His Excellency Gachagua had not been accorded adequate notice of the charges against him, sufficient particulars of the allegations, nor an opportunity to adduce and challenge evidence in violation of Articles 25C, 35, 47, and 50 of the Constitution. As such, she sought for the following orders. A declaration that within the purview of Articles 25C, 35, 47, and 50 of the Constitution of Kenya, a person facing impeachment proceedings under Article 150 is entitled to be informed substantially with peculiarity and specificity, and supported with evidence the grounds of impeachment before the commencement of the impeachment proceedings by the National Assembly and Senate. B, conservatory orders do issue against the respondents, restraining them from a collection of signatures in support of a motion to impeach His Excellency Rigathi Gachagua, lodging any motion and or carrying on proceedings seeking to impeach the Deputy President of the Republic of Kenya, the interested party herein. C, an order of compensation enshrined provided for under Article 23A of the Constitution of Kenya, made up of damages as shall be assessed and quantified by the petitioner, general damages, cost of the petition, and any other relief. The 51st petitioner neither filed any written submission nor attended the physical highlighting of submissions. In respect to the 54th petitioner's case, Emmanuel Elijah Otieno was the 54th petitioner in the consolidated petitions. He is an advocate of the High Court of Kenya who filed the petition dated 18th of October 2024 together with a supporting affidavit also challenging the constitutionality and legality of the impeachment and removal from office of His Excellency Gachagua as Deputy President. He stated that instituted proceedings in the public interest pursuant to Articles 3 and 258 of the Constitution, and contended that impeachment process undertaken by the National Assembly and the Senate was procedurally unfair, politically motivated, and unconstitutional, and inconsistent with the constitutional principles governing impeachment and Articles 145 and 50 of the Constitution. He maintained that impeachment was a constitutional mechanism intended to promote accountability and good governance, and not a tool for settling political disputes or managing political differences among leaders. He challenged the legality of public participation process and the fairness of the proceedings before the National Assembly and the Senate, and the substantive threshold applied in removing His Excellency Gachagua from office. He contended that the National Assembly failed to conduct meaningful and constitutional compliant public participation as required under Articles 10 and 118 of the Constitution and Section 5 of the Fair Administrative Actions Act. Mr. Otieno stated that the public participation exercise was hurried, inadequate, both quantitatively and qualitatively, and incapable of reflecting the sovereign will of the electorate, given that only about 223,000 persons participated, despite His Excellency Gachagua having been elected together with His Excellency President Ruto by over 7 million voters. He further asserted that the public participation template prepared by the National Assembly was biased because it only contained the allegations against His Excellency Gachagua and failed to include his responses, thereby portraying him to the public as guilt before he had been heard. Mr. Otieno additionally stated that the Speaker, Deputy Speaker, and members of the National Assembly demonstrated bias from the outset, failed to accord His Excellency Gachagua a fair hearing, and debated the impeachment motion before proper public participation and before considering His Excellency Gachagua's defense. He maintained that no impeachable offense meeting the constitutional threshold of gross violation, gross misconduct, or commission of crimes under national or international law had been substantiated either before the National Assembly or the Senate. He further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing by proceeding with impeachment despite his illness and hospitalization, and by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged violations of Articles 25C, 47 and 50 of the Constitution relating to the right of fair hearing and fair administrative action. He sought the following prayers: A declaration, B, and is hereby issued that the public participation organized and conducted by the first respondent did not meet the requirements of Articles 118, 1B of the Constitution quantitatively and qualitatively. B, a declaration be and is hereby issued that the first respondent violated the seventh respondent right to a fair administrative action under Articles 47 of the Constitution and Section 4 of the Fair Administrative Actions Act. C, a declaration be and is hereby issued that the first respondent violated the right of the seventh respondent under Article 50, Sub-Article 1 of the Constitution 2010. D, a declaration be and is hereby issued that the resolution of the first respondent to impeach the seventh respondent was invalid and null and void. And E, respondent shall bear the cost of the petition. Likewise, the 54th petitioner neither filed any submissions nor attended the physical highlighting of the submissions. Next is consideration of the 55th and 56th petitioner's case. Stephen Mbugua Wanjiru and Gladys Nyambura Gituha jointly filed the petition dated 20th of October 2024, together with the supporting affidavit sworn by Wambugu Wanjohi. They stated that they were public interest litigants and defenders of constitutionalism. They challenged the legality, constitutionality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachagua as Deputy President of the Republic of Kenya, as well as the subsequent nomination and approval process relating to His Excellency Kindiki as the Deputy President nominee. The petition petitioners contended that the impeachment process before both the National Assembly and the Senate were marred by procedural irregularities, bias, denial of fair hearing, and unconstitutional conduct, that the Speaker and the Deputy Speaker of the National Assembly had publicly pronounced themselves in favor of the impeachment before presiding over the proceedings, thereby violating the constitutional principles of impartiality, neutrality, and natural justice. The petitioners further challenged the adequacy and constitutionality of the public participation exercise conducted on the 4th and 5th October 2024, asserting that the notice period was too short to permit meaningful participation, that the questionnaires used by the National Assembly only presented the accusations against His Excellency Gachaguas without his responses, and that the Parliament failed to avail documentary and electronic evidence to the public to facilitate informed participation. He further asserted that the Senate proceedings contending he further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachaguas' right to a fair hearing by proceeding with the impeachment despite his illness and hospitalization, and that by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged that Sorry, I had repeated that bit, but I'll proceed from paragraph 133. They additionally alleged that public participation process was chaotic, disorderly, and marred by violence and characterized by low turnout in several constituencies and undertaken on days when many Kenyans were engaged in religious worship, thereby undermining the constitutional threshold for meaningful participation under Articles 10 and 118 of the Constitution. The petitioners also challenged the conduct of the Senate proceedings. They contended that the Senate acted in violation of Articles 25C, 47 and 50 of the Constitution by refusing to adjourn the impeachment hearing despite His Excellency Gachaguas' illness and hospitalization, and thereby denying him an adequate opportunity to personally defend himself. Further, the petitioners alleged bias and conflict of interest arising from participation of Governor James Orengo, Senior Counsel, and Honorable Otieno Omolo, Senior Counsel, in the Senate proceedings, stating that their roles compromise the fairness and impartiality of the impeachment process. The petitioners maintained that the impeachment proceedings before both houses of Parliament were characterized by constitutional violations, procedural inconsistencies, and disregard for due process. The petitioners also challenged the subsequent nomination and approval of His Excellency Kindiki as Deputy President, contending that the nomination was tainted by the same constitutional and procedural violations that affected the impeachment process and was therefore null and void. As such, they sought the following prayers: a declaration that the grounds of impeachment laid in the special motion dated 24th of September 2024 did not meet the constitutional and legal threshold for impeachment of a deputy president. That declaration do issue that public participation exercise conducted on the 4th and 5th of October was flawed and incapable of meeting the constitutional standards required for such processes, and the outcomes of this flawed participation do not reflect the will of the people and cannot be considered a legitimate basis for advancing the impeachment motion. See a declaration that the impeachment process against the Deputy President initiated by the National Assembly and subsequently conducted by the Senate was tainted by substantive and procedural constitutional violations, rendering unconstitutional, illegal, null, and void. D, an order nullifying the impeachment of the Deputy President as the process was marred by procedural irregularities, bias, conflict of interest, and a violation of the right to a fair hearing as guaranteed under Article 50 of the Constitution. A, an order directing the immediate reinstatement of the Deputy President to his duly elected office, having been unconditional and constitutionally and unlawful removed through an impugned process. F, an injunction restraining the President, the National Assembly, and any other state organs from proceeding with or effecting the appointment of any other person to the office of the Deputy President pending the hearing and determination of this petition. G, an order revoking the nomination and subsequent approval of Professor Kithure Kindiki as Deputy President by the National Assembly as it stems from an unconstitutional process and is procedurally flawed and in violation of the Constitution. H, a mandatory injunction directing the National Assembly and the Senate to comply with the Articles 10 and 118 of the Constitution by ensuring meaningful and effective public participation in any future impeachment processes or similar proceedings of national importance. I, declaration that the participation of Governor James Orengo, Senior Counsel, and Honorable Otieno Molo, Senior Counsel, in the impeachment proceedings violated the principles of impartiality and fair hearing and constituted a conflict of interest that compromised the integrity of the impeachment proceedings. J, an order awarding the petitioner cost of this petition, and K, any other orders or reliefs. The 55th and 56th petitioners did not file any written submissions, and they also did not turn up at the hearing. The 57th petitioner was Edwin Gachaguas, and he filed the amended petition dated 23rd of October 2024 before the High Court of Kenya at Mombasa, together with their supporting affidavit on of the same date. He stated that he is a law-abiding citizen, human rights defender, and a public-spirited litigant acting in his own interest and in the interest of citizens of the Republic of Kenya. The petition challenged the constitutionality of the impeachment proceedings undertaken against His Excellency Gachaguas, Deputy President, as well as the subsequent nomination and approval of His Excellency Kindiki as the Deputy President. He stated that the impeachment proceedings before the National Assembly and Senate violated Articles 10, 32, 47, 48, 50, 145, and 150 of the Constitution. He stated that the public participation process conducted on the 4th and 5th of October 2024 fell below the constitutional threshold of effective, meaningful, and inclusive public participation. The petitioner asserted that the notice period for the public participation exercise was too short. The exercise was limited to county officers instead of constituency level, and that the extension of the exercise to 5th of October 2024 was ineffective because the notice was issued on the very day of participation and coincided with a Sabbath day of worship for the Seventh-day Adventists, thereby excluding members of the faith from meaningful participation. He further alleged that the exercise was marred by confusion, violence, inadequate information, early closure of centers, and generally low participation, thus violating Articles 10 and 118 of the Constitution. He also challenged the legality of the Senate proceedings on the ground that His Excellency Gachaguas was denied a fair hearing contrary to Article 50 of the Constitution. He contended that although the first petitioner had fallen ill and was unable to continue participating in the proceedings, the Senate declined to adjourn the hearing and proceeded to vote on the impeachment charges in his absence. Mr. Gachaguas stated that Article 145 of the Constitution did not prescribe rigid timelines that could override the constitutional right to a fair hearing, and that the Senate failed to apply the necessary constitutional modifications contemplated under Article 150 in impeachment proceedings relating to a deputy president. He further maintained that the evidence presented before the Senate did not attain the constitutional threshold required to establish gross violation of the Constitution, gross misconduct, and serious reasons to believe that His Excellency Gachaguas committed crimes under national law. Mr. Gachaguas also challenged the legality and constitutionality of the nomination and approval of His Excellency Kindiki as Deputy President, stating that the constitutional timelines under Article 149 contemplated meaningful public participation and adequate vetting before approval of a Deputy President nominee. He contended that His Excellency Kindiki remained a state officer serving as Cabinet Secretary at the time of nomination and had not formally resigned, thereby rendering him constitutionally disqualified under Article 137 and Sections 23 and 24 of the Elections Act. The petitioner further challenged the role of IEBC, contending that the Commission was not properly constituted and therefore incapable of lawfully confirming the qualifications of the nominee. Mr. Gikonge sought the following orders. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th and 5th October 2024 regarding the special motion fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the public participation process on the 5th of October 2024 was unconstitutional for failure to provide sufficient notice and in violation of the freedom of religion under Article 30, under Article 32. C, a declaration that the impeachment process against the first interested party undertaken by the first and the second respondents was unconstitutional and did not meet the requirements set under Articles 145 and 150 of the Constitution of Kenya. D, a declaration that the impeachment process as against the first interested party undertaken by the first and the third respondents was unconstitutional as it violated Article 50 of the Constitution of Kenya in terms of providing a fair hearing. E, a declaration that the impeachment proceedings of the first interested party taken by the first and third respondent was unconstitutional, void for failing to meet the evidential threshold of the impeachment of a deputy president under Article 150, subarticle 1B. F, a declaration that the nomination of Abraham Kithure Kindiki by the President of Kenya is unconstitutional, null and void, and in contravention of Article 137(1) of the Constitution. G, a declaration that the approval of the nomination of Abraham Kithure Kindiki by the National Assembly is unconstitutional for failure to comply with Articles 10 and 118 of the Constitution. H, a declaration that the approval of the nomination of a deputy president by the National Assembly under Article 149 of the Constitution must include public participation in every constituency. I, a declaration that the approval and nomination of Abraham Kithure Kindiki by the National Assembly is constitutional as Abraham Kithure Kindiki had not resigned as a state officer. J, a declaration that the independent, that IEBC at the time of nomination of Abraham Kithure Kindiki was not properly constituted to approve or confirm the qualification of Abraham Kithure Kindiki under Article 137(1) of the Constitution. K, a declaration that IEBC had violated Article 149 of the Constitution by confirming that Abraham Kithure Kindiki was qualified to stand as a member of Parliament as per Article 137(1) of the Constitution. L, any other orders as the court may deem just. Mr. Gikonge likewise did not file any submissions. In respect of the 50th, the 52nd and the 53rd petitioners, that is John Njomo, Clarence Eboso, and Wanjiru Mwangi, their petitions were withdrawn from the consolidated proceedings on the 7th November 2024, as well as on the 16th of May 2025. On the 7th interested parties case and submission, that is Kituo cha Sheria, it appeared as the 7th interested party in these proceedings and filed a replying affidavit sworn on the 15th of April 2026 by Dr. Wambua Kituku, who is its executive director, as well as written submissions of even debt. Kituo identified 4 issues for court determination, being whether the National Assembly process met the constitutional threshold for meaningful public participation and Articles 110 and 118 of the Constitution. Secondly, whether impeachment proceedings were quasi-judicial to the extent that they meet constitutional and statutory procedural fairness standards. Thirdly, whether the court could review the procedural regularity of impeachment proceedings consistently with the doctrine of separation of powers. And lastly, whether the refusal to adjourn and the decision to proceed with in absentia violated the first respondent's petitioner's right to fair administrative action and fair hearing under Articles 10, 27, 28, 47, and 50 of the Constitution. Kituo cha sheria averred that Article 118 of the Constitution mandated Parliament to facilitate public participation and involvement in legislation and all other business of the Assembly and its committees. They further argued that the removal of a Deputy President from office was one of the most significant constitutional functions assigned to the National Assembly and the Senate, and directly affected the sovereign will of the people. It was their understanding that public participation in such a constitutional process had to be both quantitative to mean that a sufficient number of citizens had to be reached and accorded an opportunity to participate, and qualitative to mean that the participation had to be meaningful and capable of influencing the decision-making process. Kituo further averred that the one-day public participation notice given by the Speaker of the National Assembly and the National Assembly itself was inadequate to reach a substantial portion of the Kenyan population, particularly ordinary citizens who relied on accessible and localized communication channels. They deposed that the said notice did not necessarily reasonably reach rural communities, citizens without access to national media, citizens relying on vernacular radio stations, and those who depended on local public fora for information. He stated that National Assembly reduced 290 potential local hearings to only 47 hubs for public engagement forums, including venues such as Kiambu Social Hall, Gatundu, Nakuru SK Show, and thereby drastically limiting accessibility and diluting representation. Kituo cha sheria averred that the National Assembly and the Senate did not take adequate steps to ensure that sufficient citizens were made aware of the intended impeachment process. In particular, they had failed to disseminate information through churches, mosques, temples, public barazas, community meetings, vernacular radio stations, and county-level public participation forums. They further averred that the alleged public participation conducted by the National Assembly and the Senate lacked adequate structures for public engagement, including ICT-based platforms for the submission of views, decentralized citizens forums, structured mechanisms for receiving memoranda from citizens across counties, and organized town hall meetings. As a result, members of public were largely reduced to observers of the proceedings rather than participants in the process. They deposed that in the impeachment proceedings conducted by the Senate, by the Speaker of the Senate and the Senate on the 16th and 17th of October, His Excellency Gachagua was denied an opportunity to appear and be heard, to be present when being tried, and to challenge the evidence. That during the proceedings on the material day, it was communicated to the Speaker of the Senate and the Senate that His Excellency Gachagua was present, but subsequently fell ill. He was then rushed to hospital for urgent medical attention, and his legal counsel duly communicated his admission to hospital to the Speaker. Notwithstanding the request for adjournment on this ground, the Senate declined the request and proceeded to hear the case in the absence of His Excellency Gachagua and his counsel. The Senate subsequently decided to remove His Excellency Gachagua from office by impeachment for gross misconduct and on grounds of violation of the Constitution. Kituo stated in the proceedings of that the proceedings of the removal from office of the Deputy President before the Senate involved the reception of evidence, evaluation of contested facts, and the making of determinations that directly affected the fundamental rights of His Excellency. Those proceedings, therefore, ought to have been procedurally fair and to have accorded him an opportunity to be present during the trial, to be cross-examined, to be re-examined, and to fully clarify any allegations made. However, the Senate, in disregard of the quasi-judicial nature of the proceedings, reached its determination without affording His Excellency those rights. Kituo cha sheria contended that declining an adjournment request when His Excellency suffered severe and involuntary pain constituting a medical emergency was inhumane and unreasonable. They further averred that the one-day public it was further averred that the Senate, as a state organ, was bound to follow the Constitution and to observe, respect, protect, promote, and fulfill His Excellency Gachagua's rights. That upholding the impeachment as conducted set a dangerous precedent by normalizing procedural shortcuts in constitutional processes and weakened safeguards meant to protect constitutionalism and the respect for the rule of law. The absence of cross-examination in the present case was, in his view, a novel and serious procedural omission that contravened national values and principles of governance, including good governance, integrity, transparency, accountability, fairness, human dignity, equality, social justice, inclusiveness, equality, human rights, non-discrimination, and protection. They expressed their belief that the court had a solemn duty in interpreting the Constitution to adopt a purposive and progressive approach that advanced good governance, constitutionalism, accountability, and the public interest. They further averred that the determination of the petition would provide critical guidance on the constitutional standards applicable to future impeachments of holders of the offices of the Deputy President and the President, and that it must therefore reinforce rather than dilute the public participation threshold and fair hearing protections. Kituo submitted that the standard for public participation envisaged under Article 118 was meaningful participation and not tokenism, and that it had to be assessed on reasonableness and meaningfulness and meaningful opportunity, considering the nature and the impact of the decision. It was submitted that the removal of a deputy president from office was not an ordinary procedural matter, but constitutional event with profound democratic implications. That Article 118 had to be read together with Articles 1 and 10 of the Constitution, and that sovereign power belonged to the people, and Parliament merely exercised that power in a delegated capacity. When Parliament embarked on a process that might remove from office a deputy president who was directly elected by the people, it was obliged to ensure that the people themselves were accorded a meaningful opportunity to be heard. It was further submitted that in such a context, public participation became a constitutional condition precedent to valid impeachment processes. The organization submitted that public participation in a constitutional democracy had to satisfy both quantitative and qualitative standards, and that this dual requirement was particularly important where the process concerned the removal of a nationally elected office holder. In support, they relied on the Mwangaza versus Speaker of National Assembly case, in which the court stated that public participation was a constitutional requirement under Articles 10(2)(a) and 190 sub-Article 1b of the Constitution, mandating inclusive and meaningful citizen engagement in government decision making, including legislative processes such as impeachment. It was further submitted, relying on the case of Wabora, that the Constitution did not intend a scenario where an otherwise popular deputy president could be removed due to political rivalry, malice, vendetta, institutional tough wars, and partisan hostility within government, and that public participation acted as a constitutional safeguard against the abuse of impeachment powers. On the inadequacy of the notice period, the interested party submitted that the one-day Gazette notice and a national radio announcement coupled with two-day public engagement period was grossly inadequate to facilitate meaningful public participation, as such short time could not reasonably reach most Kenyans, particularly ordinary citizens who relied on accessible and localized information channels. On the over-centralization of venues, they submitted that the Speaker of National Assembly and the National Assembly failed to utilize several well-established participatory mechanisms ordinarily available to them, including ICT platforms for structured public inputs, county-based citizen engagement forums, public notice boards, and accessible announcements, town hall meetings, engagements through representation of the people, and decentralized partisan platforms across counties. Instead, the National Assembly adopted a centralized and restrictive mode whereby all 290 constituencies were grouped into only 47 participation centers, one per county. This arrangement overloaded single venues, diluted constitutional high-level representation, and transformed public hearings into mass gatherings where individualized contributions were particularly impossible. The structural barriers disproportionately undermined meaningful engagement, especially for marginalized communities, people with disabilities, workers unable to leave employment on short notice, those without transportation, and citizens living far from county headquarters. It was submitted that a process of this gravity required decentralized, not consolidation of engagement forums. On the rigid and non-deliberative format of engagement, they submitted that the National Assembly employed a highly structured and restrictive model of engagement in which parliamentary clerks read out the charges, provided a general explanation of the processes. Attendees were given limited time to offer their views, and those views were recorded in a pre-designed format for compilation. That format did not allow robust deliberation, did not permit cross-examination of claims, and did not facilitate informed submissions on the constitutionality or factual basis of the impeachment. It was submitted that public participation had to be interactive and not merely a formalistic exercise. On the inadequacy of the online submission mechanism, they submitted that the National Assembly's website provided template forms where citizens could tick boxes indicating support or opposition to the impeachment, but those forms offered only binary choices, allowed no uploading or supporting documentation, and permitted no opportunity for dialogue or nuanced analysis. This reduced public participation to checkbook voting rather than substantive constitutional engagement. They acknowledged in their submissions that the standard required was not perfection but reasonableness. However, reasonableness is in a matter of this magnitude required the Speaker of the National Assembly and the National Assembly to have actively mobilize public awareness through non-public convergency points such as churches, mosques, temples, public barazas, national radio stations, vernacular broadcasting stations, and other accessible civil forums. The failure to which those avenues significantly restricted the reach of the notice and consequently diminished participation. The process was submitted to have been conducted on an extremely short notice, centralized into two venues, and structured in a rigid and non-deliberative manner, and procedurally shallow through form-based engagement, all of which demonstrated a failure to meet constitutional standards and called into question the validity of the impeachment of His Excellency Gachaguas. It was further submitted that the removal of a deputy president from office was not merely an internal matter of parliament, but a matter of national constitutional significance affecting the democratic will of the electorate, the integrity of the executive structure, the political stability of the Republic of Kenya, and the sovereignty of the people, and that accordingly the electorate had to be accorded an opportunity to participate in a process that sought to overturn their democratic choice. Kituo cha Sheria submitted that even where Parliament acted within its constitutional mandate, when it undertook a process that received and evaluated evidence and reached determinations adverse to rights, reputations, and the tenure of office, it was obliged to meet minimum content on procedural fairness. It was submitted that the Senate proceedings bore all the hallmarks of a quasi-judicial trial form: pleadings, evidence, contested facts, and adverse finding to a grave sanction in the form of removal from office, and that Articles 47 and 50 of the Constitution and the Fair Administrative Actions Act 2015 therefore applied with full force. Impeachment of a national executive was not a mere political debate, but a structured constitutional trial with legal standards burdened with reputational, civil, and democratic consequences, which made the rights to be present, to cross-examine, and to be re-examined all the more imperative. It was submitted that Article 50, read together with Article 25C of the Constitution, and scored that fair trial rights were non-derogable in substance, relying on Stephen Odede versus Court Maxwell, in which the court confirmed that the right of fair hearing and right and fair trial ought not to be unduly impeded, and that a trial body had to be circumspect in purporting to limit and take away such crucial right, since Article 25C specifically provided that there was never to be any derogation from the right to a fair hearing. It was further submitted that while impeachment was sui generis, the logic of adversarial testing of allegations applied with equal, if not greater force. His Excellency Gachaguas fell ill, was admitted for urgent medical care, and his counsel sought an adjournment, which was refused. The Senate proceeded in absentia without counsel, received and assessed evidence, and removed him from office, thereby extinguishing his ability to be present, to be cross-examined, and to be re-examined, and to participate meaningfully. It was submitted that a fair process entailed reasonable accommodation, including adjournment, where good cause was shown and no prejudice would be suffered that could not be compensated by way of cost or by way of time. Kituo cha Sheria relied on Githiga and 5 others versus Kiruti Factory Company Limited, in which the Supreme Court confirmed that the right to a fair trial indicated that the right of fair hearing indicated that an individual shall not be penalized by a decision affecting his rights or legitimate expectation unless he had been given prior notice of the case against him, a fair opportunity to answer, and the opportunity to present his case. It was submitted that this was precisely what was not accorded to His Excellency Gachaguas. It was further submitted that if the Senate could adjourn an entire sitting over quorum issues as per Standing Order 40, then refusing to adjourn to accommodate a hospitalized party where fairness and due process rights were under Articles 47 and 50 were at stake was unreasonable, disproportionate, and constitutionally infirm. They argued that the right to be heard required a real and effective opportunity to participate, not a mere formality, and included the right to attend and to answer the case one first, as well as the right to correct and contradict the allegations made against one. Further, that an adjournment was a recognized incident of a fair hearing where unavoidable circumstances prevented attendance or effective participation, and accordingly the denial of a reasonable adjournment amounted to a denial of the right to be heard. The Senate could have proceeded in His Excellency Gachaguas' absence if his conduct had made it impossible to continue the hearing, or if after due notice, his notice was unjustified. In the present case, they submitted that that absence was explained as a medical emergency, and counsel had sought an adjournment. Proceeding to receive and evaluate adverse material in those circumstances, His Excellency Gachaguas' ability to participate meaningfully was impugned. It was further submitted that in impeachment, the public interest was best served by accuracy and fairness, not speed for its own sake, and that where adverse oral evidence was received and weighed, cross-examination was then crucial for testing credibility, the denial of which hollowed out fairness and tainted the decision. It was submitted that expedition could not cannibalize fairness, and that Articles 10, 47, and 50 demanded reasonable accommodation, especially where a short adjournment would have cured the prejudice occasioned by a medical emergency. Kituo cha Sheria submitted that courts had emphasized committee and institutional respect, and that impeachment was principally a political and constitutional accountability process, but that Parliament had not been insulated from judicial scrutiny where constitutional requirements were breached. Relying on the Mwangaza case, Kituo cha Sheria recalled the court's pronouncement that impeachment was an invaluable safeguard against impunity and an abuse of office that had to be jealously protected and must not be allowed to become an avenue for fighting political proxy wars or resurrecting ballot box contestations. The court further stated that the court further stated therein that watering down impeachment, lowering its bar too low, or allowing it to become a facade, masking hidden political interests, run the risk of Kenyans losing confidence in the process, and that the intervention of courts came far down the impeachment path, making it the duty of the primary duty bearers to ensure that impeachment remained a constitutionally envisaged. Kituo cha Sheria submitted that constitutional review was therefore available to term procedural propriety in the exercise of public power, even in political charged arenas. Further reliance on the Wambora case, Kituo cha Sheria recalled the Court of Appeal statement that the process of removal lay entirely in the County Assembly, wherein it was initiated, and the Senate, wherein it was concluded, but that the court might only come in when necessary to confirm that the process had been properly followed as laid down in the Constitution and the statute. Accordingly, they submitted that the question before the court was not how the Senate should have voted, but whether it had obeyed the Constitution in getting there. It was submitted that Article 10 of the Constitution bound all state organs whenever they applied or interpreted the Constitution or enacted, applied or interpreted any law or made or implemented policy, public policy decisions, and required good governance, integrity, transparency, accountability, human dignity, equality, social justice, inclusiveness, equality, human rights, and non-discrimination. An impeachment that shut out the subject's presence, cross-examination and re-examination, especially in a medical emergency, subverted dignity, equality of arms, and accountability, and was thus unconstitutionally infirm. Kituo cha Sheria was not asking the court to supervise the National Assembly and the Senate debate or to substitute their judgment, but only to ensure that in reaching their determination, the constitutional procedures were observed. They sought a declaration that the impeachment proceedings conducted on the 16th October 2024 by the Senate were procedurally unfair, unconstitutional, and ultra-vires. A declaration that the Senate, acting as a quasi-judicial body, violated Articles 47 and 50 of the Constitution by denying cross-examination, re-examination, and a reasonable adjournment in the alternative. A reasonable adjournment. In the alternative, if the court was minded to preserve the proceedings, an order of remit directing the de novo hearing before the Senate in strict conformity with constitutional and statutory fair hearing requirements, including presence, representation, examination, disclosure, and reasonable determination, and such other orders as the court may deem fit to vindicate the Constitution and the public interest in a lawful, rational, and fair impeachment process. Kituo cha Sheria concluded its submissions by urging the Constitution that the Constitution erected procedural safeguards precisely because impeachment was a constitutional earthquake, where the Senate refused a short adjournment despite His Excellency Gachaguas' hospitalization, proceeded in absentia, and delivered the ultimate sanction without the presence, cross-examination, and re-examination of the accused. The process failed the constitutional test. It was submitted that this court ought to intervene not to rewrite politics, but to enforce procedure, and in so doing, preserve Kenya's commitment to the rule of law, constitutionality, accountability, and human dignity. We will now proceed to responses and submissions to the consolidated petitions. We'll start with the second and the seventh respondents' cases. The National Assembly and the clerk to the National Assembly were the second and the seventh respondent in the consolidated petitions. They jointly responded to the petitions through a blank affidavit sworn by its clerk, Samuel Joroge, on the 9th of October 2024 and the 21st of October 2024, and the grounds of opposition dated 4th of October 2024. They asserted that the impeachment process was entirely constitutional, lawful, and procedural fair, and that all actions were taken. All actions taken complied with Articles 145, 150, and 118 of the Constitution, as well as the National Assembly standing orders, as well as the court directives. They further posited that the impeachment of the Deputy President followed Article 150, Sub-Article 2 of the Constitution, which applies Articles 144 and 145 of the for the President with necessary modification, and that Standing Order 65-2 of the National Assembly explicitly states that Standing Order 64 applies to the Deputy President with necessary modifications as well. They deposed that the Speaker validly confirmed that the motion met the required legal form and the signature threshold of at least 117 MPs, or 1/3 of all members, that public participation was adequate, inclusive, and compliant with court orders, as the National Assembly placed in all 3 national dailies on the 2nd, 3rd, and 4th of October 2024. Public hearings were held on the 4th of October 2024 across the country, and that the public will submit views by way of email, post, hand delivery. A dedicated template in English and Kiswahili was provided, and they were also able to visit the constituency offices. The respondents contended that upon being served with a court order on the 3rd of October 2024, they extended public participation to the constituency level until 5th of October 2025, and that a public participation report was published. They asserted that the process was real and not illusory, that public participation was not part of the Deputy President defense, as it was meant to gather general public views to inform the Assembly, and that holding it first preserved the integrity and the independence of public input, preventing it from being influenced by the Deputy President's defense or parliamentary debate. The respondents maintained that the Deputy President still received his full right to be heard during the debate on the 8th of October 2024, where he appeared in person with his legal team. The respondent further claimed that one of the petitioners, Honorable Jane Jeremiah, closed her Kirinyaga County Women Representative Office during public participation exercise, despite parliamentary officers being deployed there. Further, they reliably learned that the closure was directed by the woman representative herself, since she was vehemently opposed to the impeachment. The respondents averred that she cannot then benefit from her own actions that obstructed the public participation exercise. The respondents deposed further that after debate on the 8th of October 2024, the motion was put to a vote, and 282 members voted in support of the impeachment and 44 voted against, which exceeded the required 2/3 majority under Article 145(2) of the Constitution. That on the 9th of October 2024, the Speaker of the National Assembly formally notified the Speaker of the Senate of the resolution by transmittal. The respondents denied any constitutional or otherwise wrongdoing and prayed that the constituted petitions against the National Assembly and the clerk be dismissed with cause. In respect to their submissions, the National Assembly and its clerk's onslaught on the constitutional petition was led by learned counsel Mr. Eric Gumbo, Mr. Paul Nyamodi, and Honorable Gitonga Murugara. They identified the following issues for this court's determination. A, what is the extent of this court's jurisdiction to hear and determine the constituted petitions relating to the impeachment of His Excellency Gachaguas? B, whether the sub judice rule under Standing Orders 89 and 103 of the National Assembly and the Senate Standing Orders bars parliamentary proceedings on impeachment where judicial proceedings are pending. C, whether the impeachment proceedings before the National Assembly were valid. D, whether the petitioners have demonstrated any valid grounds for challenging the impeachment proceedings conducted before the Senate. E, whether the impeachment unconstitutionally subverted the sovereign will of the electorate expressed in the 2022 general elections contrary to Articles 1, 2, and 38 of the Constitution. F, whether the nomination, approval, and appointment of Honorable Kindiki as the Deputy President was invalid, and whether the petitioners are entitled to any of the reliefs sought. The National Assembly and clerk submitted that the impeachment of His Excellency Gachaguas as Deputy President was constitutionally valid, procedurally proper, and politically necessary to uphold accountability and the rule of law. They also defended the subsequent nomination, approval, and appointment of Honorable Kindiki as Deputy President as fully compliant with the Constitution. Their positions remain that an impeachment is a political process, not a judicial one, and that the Constitution, the sovereign power in the people exercised through their elected members under Article 1, that the Constitution mandates public participation, strict timelines, and bicameral supermajority representation requirements of the 2/3 in both houses, making the impeachment framework rigorous and transparent. They submitted that the comparative analysis with the United States, Philippines, Brazil, South Korea, and Nigeria shows that Kenya's process aligns with global presidential systems where impeachment is a constitutional safeguard against abuse of office. On the High Court jurisdiction under Article 165 of impeachment proceedings, they submitted that such power is only residual and supervisory, not appellate, that impeachment is a political process entrusted to Parliament, and courts should not interrogate the substantive merits of impeachment charges. They added that the court's role is limited to ensuring procedural compliance and protection of individual constitutional rights, and citing the cases in Wambora and Sonko. They asserted that the court must show deference to Parliament in matters where the Constitution grants Parliament discretion. Learned Counsel also cited the decision of the Supreme Court of Philippines in Re Sara Duterte, which similarly held that courts will not encroach on co-equal branches on political questions. It was their further submission that Standing Order 89 of the National Assembly and 103 of the Senate do not absolutely bar discussion on matters pending in court, and a matter is sub judice only if discussion is likely to prejudice fair determination of active proceedings. They stated that the petitioners did not raise any sub judice objection during their parliamentary proceedings, and they cannot raise it now. The National Assembly and clerk submitted that the Constitution itself imposes tight timelines under Article 145, that is 2 days to notify Senate, 7 days to convene Senate, and 10 days for the committee investigation. They contended that impeachment is urgent, as prolonged proceedings will cause political uncertainty and undermine governance. The standing order were a legitimate exercise of parliamentaries' power under Article 124 to regulate its internal affairs, and that timelines are constitutionally anchored and not subject to judicial invalidation, as was held in Barack Issa Kombo's case. It was their further submission that public participation was adequate, as the National Assembly issued notices in the Kenya Gazette, national newspapers, news website, and social media on the 2nd, 3rd, and 4th of October 2024. Public hearings were held at county and constituency levels, including compliance with Justice Mwongo's order on constituency level participation, and 223,083 citizens submitted views, which they stated was an unprecedented level of civic engagement. Further, that the public views the public views template was provided in English and Kiswahili. Submissions were received orally, in writing, and electronically. They also submitted that the constitutional standard is reasonableness, not perfection, and that the Supreme Court in Cabinet Secretary for National Treasury and Planning and 4 others, that was Kuwait and 52 others, held that timelines must be considered when assessing public participation adequacy. They submitted that His Excellency Gachaguas' response was not required to be circulated, was not required to be circulated simultaneously, as the public role is to express views, not adjudicate, and that allegations of violence, intimidation, and poor organization were unsubstantiated, and that isolated incidents do not vitiate an entire process. They also submitted that public participation report was submitted in Parliament and recorded in the Hansard, which is a valid parliamentary record. They stated that the impeachment motion was properly particularized and set out 11 detailed grounds with specific particulars, and that these grounds met the threshold set in the Wambora's case of being serious, substantial, weighty, with clear nexus and precise constitutional provisions. That the motion was supported by 282 MPs, which was well above the 2/3 requirement of 233 MPs, and that the Deputy President was accorded a fair hearing as he received prior notice of the charges. He filed his written response and appeared in person with counsel, and he was given 2 hours to address the National Assembly. The National Assembly and the clerk also submitted that His Excellency Gachagua's defense was considered and debated before the vote, and that the 2/3 gender principle does not invalidate Parliament, as Articles 97 and 98 on the composition of Parliament have been fully complied with. On the 2/3 gender principle under Article 81B, it was submitted that this was an aspirational provision to be achieved progressively, not a condition precedent to Parliament's validity, and that Article 261 provides a mechanism for addressing legislative delays, and that no advice from the Chief Justice or action by the President has occurred to resolve Parliament. They contended that accepting the petitioner's argument would void all legislation and action since 2013 and will be an absurd and constitutionally impermissible outcome. On the allegation of bias against the Deputy Speaker, they submitted that allegations were unproven, and further that the Deputy Speaker only performed administrative and procedural functions and that she did not vote. Further, no recusal motion was raised during the proceedings. They stated that the test for bias is objective, as stated in the Supreme Court in Rawal and others, and that the threshold had not been met in this matter. Council added their voice to the position that the Senate handled the impeachment hearings by hearing the charges in plenary, since Article 145, sub-article 3A, mandates the Senate to convene and hear such charges. That Article 145, sub-article 3B, uses the word may, and therefore the appointment of a special committee was discretionary and not mandatory, and they said semicolon and in Article 145, sub-article 3, do not convert the discretionary power into a mandatory obligation. They reiterated that the Senate motion to appoint a special committee on the 9th of October failed as it was not seconded, and the Senate then properly proceeded in plenary. They relied on the Supreme Court court and Sonko case that confirmed that for governors, the Senate may proceed in plenary or by a committee, and that the same applies to the Deputy President. It was also their submission that the 10-day timeline for plenary proceedings was constitutional, as where the Constitution is silent, the Senate may regulate its own procedures, and Article 124, sub-article 1, and the 10-day deadline was a reasonable exercise of procedural autonomy to ensure expedition. Council submitted that impeachment must be concluded without undue delay, and the timeline reinforced accountability and good governance. It was their father's position that His Excellency Gachagua received a fair hearing in the Senate, as he was represented by counsel throughout. He was cross-examined at the National Assembly, and he cross-examined National Assembly witnesses, and he filed witness affidavits on the 12th and 13th of October 2024. They contended that the Senate did not refuse an adjournment, and reasonably, as senior counsel Muite was given from 2:30 p.m. to 5 p.m. to contact His Excellency Gachagua, that no medical evidence of either doctor of either a doctor's report or prescription was provided to the Senate, and that the Senate offered to adjourn until Saturday 19th, 20, and opted out after cross-examining the National Assembly's witnesses. That no new evidence was introduced. All material before the Senate had already been placed before the National Assembly and forwarded to the Speaker, and time allocation was not disproportionate, as both parties were accorded equal time. The National Assembly submitted that it also could not call all its witnesses due to time constraints, and that this was a consequence of expedition and not bias. They further submitted that the Senate had no independent duty to conduct public participation, which under Articles 10 and 118 applies primarily to legislative functions. The Senate, when hearing impeachment, acts as a quasi-judicial capacity, not a legislative one, and that public participation occurs at the National Assembly during the initiation stage, not at the Senate at the trial stage. Council submitted that comparative practice in South Africa, US, and in the USA, Nigeria, and Brazil confirms that the upper house role is adjudicatory, not participatory, and that the court in Mwangaza versus Speaker of the Senate held that public participation in gubernatorial impeachment occurs at the country assembly level, and the same applies in equal measure in this matter. The respondents contended that allegations of bias against the Senate Speaker remained unproven, as a Speaker's role is presiding and procedural, and he has no deliberative vote. That mere coalition membership does not establish bias, and that the petitioners have not pointed to any specific or act or omission showing a real possibility of bias. They restated that the test for bias is objective, and the petitioners failed to meet it, as well as in respect of the Senate Speaker. It was the submission of the National Assembly and the clerk that the participation of Honorable Orengo and Honorable Amolo as counsel did not invalidate the proceedings, in that Article 77(1) restricts gainful employment that is inherently incompatible with state office, and that representing a party in proceedings is not such an employment. That any alleged illegality would affect the advocates personally and not the validity of the impeachment process, and that no actual bias or procedural fairness has been shown. And Wabora cases. The Senate found 5 charges substantiated, including gross constitutional violations, attacks on judicial independence, ethnic incitement, gross misconduct, and that the evidence was substantial and credible, including His Excellency Gachaguas' own public admissions. Learned Counsel submitted and urged that the court should not undertake a merit review of the Senate findings. Counsel reiterated that impeachment does not subvert the sovereign will of the people, as it is not an affront to democracy, but an affirmation of accountability. That the Constitution provides for removal of elected officials for gross misconduct, constitutional violations, and crimes, and that the joint ticket of the President and the Deputy President does not create legal inseparability, as they are separate constitutional offices with distinct and accountability mechanisms, and Counsel gave comparative analysis of the U.S. Vice President resignations while President Nixon remained, and Brazil's President Rostov's impeachment while Vice President Tema assumed office. When they submitted that removal of deputy does not require removal of the principal. They contended that Article 150 of the applies Article 145 necessary modifications, and that this acknowledges that distinct offices are not a merger. On the validity of His Excellency Kindiki's nomination, approval, and appointment, the National Assembly and the clerk submitted that a lawful vacancy arose by operation of law under Article 145(7) as the impeachment was valid. They stated that IBC clearance was not constitutionally required for a deputy president nomination under Article 149, and that the president merely sought information of the voter registration status and MP qualifications from IBC as a matter of prudence. Council submitted that IBC's secretariat acted within administrative mandate by providing information which is not commission-led constitutional function. Council referred this court to the Supreme Court advisory opinion in IBC versus AG 2025, where it drew a distinction between commission-led functions such as boundary delimitation and secretariat administrative functions, including the day-to-day operations. They submitted that providing information falls within the latter. It was their submission that His Excellency Kindiki met constitutional qualifications for appointment as is a Kenyan citizen by birth, qualified to be an MP and nominated by a political party, UDA, thus satisfying Article 137 as read with Article 148, and that his party membership was properly documented with the register of political parties. They contended that allegations of misconduct during His Excellency Kindiki's tenure as Cabinet Secretary were mere allegations, and that no judicial or quasi-judicial finding of culpability exists, and that the court in International Center for Policy and Conflict and 5 others versus AG, reported 2013, held that unproven allegations cannot disqualify a candidate. That holding a cabinet secretary position did not disqualify him under Article 77, as this provision prohibits gainful employment that creates a conflict of interest, but does not bar a state officer from seeking elective office. The Council submitted that disqualification for holding state office is governed by Article 137, sub-Article 2b, that requires resignation 6 months before a general election, but it is not applicable to a midterm vacancy, which process under Article 149 is sui generis. The National Assembly submitted that the voting process complied with Article 149(1), which requires the National Assembly to vote on the nomination, which is an electoral determination by plenary, not an approval process requiring committee vetting. That the Speaker correctly distinguished between appointive officers subject to committee approval and the elective process of Deputy President and Article 149(1). It was argued that the Public Appointments and Public Appointments in brackets Parliamentary Approval Act and the Standing Order 45(3) do not apply to this sui generis constitutional process, and that the Supreme Court entrusted a Society for Human Rights Alliance versus Matemo and 3 others held that where the Constitution provides a specific procedure, statute cannot add to or amend it. It was also the position that no public participation was required for the nomination under Article 149, sub-Article 1, does not prescribe public participation, and that the nomination and approval is an executive-led elective process, not legislative business, under Article 118. That it will be incongruous to require more process for a mid-term vacancy than a general election, where the ticket is approved by popular vote without prior public hearings. For the aforementioned reasons, the National Assembly and the clerk urged the court to dismiss all relief sought in the with the council submitting that no constitutional violations had been proved. The impeachment was procedurally regular and substantively justified. Damages are not automatic, as no breach had been established, and awarding damages would punish Parliament for performing its constitutional duty. That pension and retirement benefits are for honorable retirement, not for removal by impeachment, and that quashing the resolution and nullifying His Excellency Kindeki's appointment will create a leadership vacuum and constitutional chaos. Council thus urged this court to dismiss the constitutional petitions with cost to them, find that the impeachment of His Excellency Gachaguas was lawful, constitutional and procedurally proper, and that the nomination, approval, and appointment of His Excellency Kindeki as Deputy President was valid and constitutional, and that the court should decline to grant any of the relief sought by the petitioners. On the third and fourth respondents' cases, the Speaker of the Senate and the Senate, who are the third and fourth respondents respectively, challenged the consolidated petitions through the affidavit sworn by Jeremiah Nyegenye, who is the clerk of the Senate and secretary to the Parliamentary Service Commission. The affidavit was deposed on the 21st of October 2024. From the outset, it was their case that under Articles 93(1), 96, sub-article 4, and 145 and 150 of the Constitution, the Senate is mandated by with the role of considering the impeachment of a deputy president. They asserted that processes guided by the National Assembly's Standing Order 64 and 5, which dictates the procedure for introducing and supporting an impeachment motion. To that end, it deposed that on the 1st of October 2024, Honorable Mutuse introduced a motion in the National Assembly seeking the removal of His Excellency Gachaguas on the basis of 11 grounds, including gross violations of the Constitution, undermining, devolution, attacking independence of judges, committing economic crimes, and publicly subordinating the president. It was their position that the National Assembly conducted extensive public participation from 2nd to 5th of October 2024 and formally approved the motion on the 8th of October 2024. Following the approval, the Speaker of the National Assembly notified the Speaker of the Senate of the resolution in a letter received on the 9th of October 2024, which included the motion, electronic evidence, relevant Hansard reports, public participation, advertisement, and reports, and court orders. He asserted that the Senate Speaker convened a sitting on the 9th of October 2024 through Gazette Notice number 13170, during which a motion to establish a special committee to investigate the matter was defeated. As such, the proceedings had to be held in plenary, and it was deposed that the Speaker designated 16th and 17th of October 2024 for the plenary hearings formalized in Gazette Notice number 13178. Speaking to the fairness in the process, the clerk deposed that on the 9th of October 2024, the Senate served an invitation to His Excellency Gachaguas and the National Assembly to appear to submit witness details and evidence. It was the case that on the 14th of October 2024, His Excellency Gachaguas indicated his presentation by Mrs. Swanya and company advocates and filed his response to the allegations alongside supporting evidence. They stated that the plenary hearings commenced on the 16th and 17th October 2024, and after the National Assembly concluded its case on the 17th of October 2024 at 1:15 p.m. His Excellency Gachaguas lead counsel, Mr. Paul Muite, senior counsel, informed the Senate at 2:30 p.m. that his client was missing and had been taken ill. It was pointed out that after suspending the proceedings until 5 p.m., counsel requested an adjournment to 22nd October. He stated that a substantive, subsequent procedural motion to sit on Saturday, 19 October 2024, to meet the constitutional deadlines was defeated, prompting His Excellency Gachaguas' counsel to exit the proceedings. They maintained that the Senate, across the judicial body, exercised discretion in granting adjournments, and His Excellency Gachaguas' counsel failed to provide cogent material evidence of his illness. As regards the constitutional timelines, it was their case that impeachment could not be posed without violating the Constitution. They refuted the claim that the trial occurred in absentia since His Excellency Gachagua had actively participated through his advocate's opening statements, cross-examination, and the National Assembly's witness and filing of the respective witness affidavits. In challenging the claim that the public participation was not conducted, the Senate and the Speaker stated that an order of the High Court in Kerugoya did not mandate the Senate to conduct public participation, as the Senate functions exclusively as a trial chamber akin to a court. In conclusion, it was disposed that the Senate voted on the impeachment charges, where 5 charges comprising ground 1 on gross violation of the Constitution, ground 4 on undermining the independence of judges, ground 5 fidelity to the oath of office, ground 6 on crimes under national cohesion, and ground 9 on gross misconduct and ground 9 on gross misconduct concerning NAS were substantiated by the required majority. The clerk deposed that the Senate resolved to impeach His Excellency Gachagua, a decision officially gazetted on 17th of October through Gazette Notice number 13400. On the foregoing, this court was urged to find that the impeachment power is inherently political and vests solely in Parliament, which triggered the political question doctrine, thereby inviting this court to exercise judicial restraint. Ultimately, the Speaker of the Senate and the Senate prayed that the petitions be dismissed with cause. The third and fourth respondents filed submissions dated for 24th of April 2026, and they were highlighted by their legal team led by Professor Tom of Gender Senior Counsel, Mr. Edwin Mukele, Ms. Mercy Thanji, Ms. Opola, and Honorable Hilary Sigei. They maintained that the entire impeachment process meticulously complied with all constitutional timelines, including standing orders and the principles of natural justice. On the question whether His Excellency Gachagua was accorded a fair and reasonable opportunity to be heard, they submitted that the hearing aligned with the due process and the Audi Alteram Partem rule. To define the threshold of a fair trial, they relied on the Black's Law Dictionary 7th edition at page number 725 and the Halsbury's Laws of England 5th edition, the 2010 volume 61 at paragraph 639. The dictionary defines the right to be heard as follows, and they quote: the rule that no person is to be condemned unless that person has been given prior notice of the allegations against him and a fair opportunity to be heard is a fundamental principle of justice. This rule has been refined and adapted to govern the proceedings of bodies other than judicial tribunals, and a duty to act in conformity with the rule has been imposed by the common law on administrative bodies not required by statute or contract to conduct themselves in a manner analogous to a court. And of course, to bolster their case, the Senate and the Speaker referred to the President in Evans and it must be reasonable. Council drew further support from the Uganda Supreme the opposing evidence and given a full venue to present their case, comment, or call witnesses. As regards the sufficiency of written evidence and constructive waiver, they stated that His Excellency Gachagua fully participated in the initial phases of the trial by filing comprehensive responses, witness statements, and documentary of video exhibits, which legally constituted his defense in chief under Rule 6 of the second schedule to the Senate standing orders. They submitted that an oral hearing is not an absolute prerequisite for natural justice, and they fortified their position opposition through the decision in Economic Freedom Fighters and 3 others versus Speaker of National Assembly. This is a South African case, and the Kenya Revenue Authority and Menginya versus Menginya Salim Magara's case. They also relate to Swalwerjan versus Race Relations Board Limited. This is a foreign case, as well as R versus Immigration Appeal Tribunal. They also referred to representations. The Speaker and the Senate faulted His Excellency Gachaguas, stating that because he chose to walk out of the proceedings after the Senate had voted down an adjournment, it was deliberate boycott. They implored the court to find that voluntary absence constituted a constructive waiver of the right to be heard orally. Support to that end was drawn from various authorities, among them Regina versus Jones, R versus Governor of Brixton Prison, and the Ghanaian Supreme Court case in the Republic versus High Court of Accra. They affirmed that the Senate acted within its lawful discretion when it denied His Excellency Gachaguas' request to adjourn the proceedings due to his sudden hospitalization. In reference to the decision of the Supreme Court in Sonko and the Mate, the Senate and the Speaker emphasized that courts must be slow to interfere with the internal affairs and the procedural discretion of Parliament. Further support was drawn from the decision of the Supreme Court in the famous Cycle Agencies case and 4 others versus Masukulal, Ramji Kuria, where it was observed that an adjournment requires sufficient cause based on proper materials. They argued that without formal medical proof of total incapacitation, the Senate was not required to stop its proceedings. To further credence to the foregoing position, they found support from the decision in Serem versus Republic, Court of Appeal decision, and Okaka and another versus Odundo, High Court decision, and it was their case that the strict approach was dictated by the mandatory 14-day timeline to dispose of special motions under Senate Standing Order number 74-2A. On the question whether investigation of charges met the requisite standard of proof, the Senate asserted that it thoroughly investigated and voted on each individual charge according to the established intermediate standard of proof, which is above a balance of probability but below reasonable doubt threshold. It was their case that the standard was set by the Supreme Court in the Sonko case, which declared that proving even a single charge is legally sufficient to sustain an impeachment. Consequently, they submitted that the court must decline to re-evaluate the evidence or substitute its own finding for the political question decided by the Senate under Article 96, Sub-Article 4 and Article 145, Sub-Article 3 of the Constitution. On the question challenging His Excellency Gachaguas' claim that the Senate acted unprocedurally by failing to form an 11-member special committee under Article 143, Sub-Article 3B, the Speaker and the Senate submitted that the word may in the Constitution and Rule 2 of Part 1 of the second schedule to the Senate standing orders grant the Senate absolute discretion to choose between a committee or full plenary. They submitted that such interpretation is anchored in the Supreme Court case in the matter of the Speaker of Senate rendering or referencing the matter of interim independent electoral commission and the Court of Appeal decision of Cooperative Bank of Kenya Limited and versus Banking Insurance Finance Union, which is a Court of Appeal decision. They contrasted Article 135 Article 3B with Article 152, Sub-Article 7 of the Constitution, which uses the mandate properly proceeded in plenary. meticulously satisfying the oversight parameters affirmed in the by the Supreme Court decision in the Sonko case. As regards the contentious issue of public participation, they contended that there was no legal basis for the Senate to conduct a secondary round of public participation because the National Assembly had already completed a rigorous national public participation drive between the 2nd and the 5th of October 2024 through extensive media notices and public feedback templates. They submitted that to demand a repetitive exercise from the Senate will be an imprudent waste of state resources. Separately, the Speaker and the Senate submitted that during an impeachment trial under Article 145(3)(a), the Senate acts exclusively as a quasi-judicial body evaluating specific charges rather than performing a standard legislative function, exempting it from public participation requirements of Articles 10 and 118. They dismissed the argument that Parliament was illegally constituted due to a threshold failure to implement the two-third gender rule. They further submitted that although the former Chief Justice David Maraga issued a dissolution advisory to the 4th President, the 12th Parliament dissolved by operation of law and the 13th Parliament was lawfully established following the general elections of the 9th August 2022. Seeking to rely on Article 261, Sub-Article 5 running to 7, the Senate and the Speaker submitted that the ground that the gender rule mechanism is intended to compel future compliance and not to retroactively invalidate state operations. They warned that declaring Parliament unlawful would cause an absurd constitutional They urge the court to practice judicial restraint as the gender dispute is actively pending before a 5-judge bench in Chela and others as the Chief Justice and President of the Supreme Court in Kenya and others. The Speaker and the Senate rejected the allegation that the Senate was mandated to conduct a approval hearing for filling the subsequent vacancy of the office of the Deputy President. They pointed out that Article 149, Sub-Article 1 of the Constitution expressly grants the exclusive mandate to vote on and approve a nominated Deputy President to the National Assembly, entirely omitting the Senate. It was their case that by applying the statutory construction principle established in the case of Federation of Women Lawyers Kenya, FIDA, the explicit text of the Constitution. On the strength of the foregoing submissions, the Speaker and the Senate urged the court to dismiss all the consolidated petitions with costs.
I will take over from the fifth respondent's case. The Attorney General, that is the fifth respondent, challenged the petition through grounds of opposition dated the 7th of November 2024. She argued that the court should not elevate Parliament's factual assessments since its role is strictly to ensure that reasonable inferences were drawn from the available evidence. It was her case that the proceedings against Gachaguas were purely legislative, neither entirely administrative nor judicial, and therefore were not subject to standard administrative or judicial review as suggested under Article 47(3)(a) of the Constitution. Further, the Attorney General asserted that the court could not substitute the legislature's discretionary decision with its own, as doing so would constitute a usurpation of the constitutional functions of an independent branch of government. She maintained that the proceedings before the legislature were lawful, efficient, expeditious, and procedurally fair, since the adopted procedure successfully balanced the need to protect Gachaguas' constitutional rights, safeguard the process from abuse, and prevented unnecessary disruptions to public administration. Regarding public participation, the AG clarified that the Constitution did not permit members of the public to vote on an impeachment motion, as that discretion was expressly reserved for legislators who constitutionally represent the sovereign will of the people. It was explained that the National Assembly's role in the impeachment process was strictly preliminary and did not bind the Senate, which acted as a distinct state organ responsible for substantive proceedings, the impeachment of a deputy president, since it is ill-equipped and constitutionally not designed to review or reevaluate the socio-economic and political utilitarian calculations made by elected officials. Finally, the Attorney General defended the subsequent nomination and voting into office of His Excellency Kindiki, and it was her case that the replacement process under Article 149(1) of the Constitution was sui generis, qualifying neither as an election nor an appointment, which meant that the provisions of Article 137 did not apply. The Attorney General concluded that there were no procedural infractions that affected the outcome, that the transition process was conducted within constitutional timelines by the proper constitutional repositories, and that the consolidated petitions lacked merit. The fifth respondent submissions are dated 4th March 2026. They were orally highlighted by a team of counsel led by Professor Githu Senior Counsel, alongside the Solicitor General, Mr. Shadrach Mose, Mr. Emmanuel Bita, now a judge of the High Court, is of exercising oversight and facilitating accountability. He relied on the Supreme Court decision in Sonko, where the Apex Court stated that its purpose was to ensure integrity in leadership and prevent abuse of public office. It was the Attorney General's submission that the removal of proceedings for a deputy president was textually committed by the Constitution to the National Assembly and Senate, and that both institutions were vested with exclusive power to remove the deputy president, subject only to procedural requirements set out in the Constitution and in the standing orders, that both houses were free to determine the procedures for receiving and considering the evidence necessary to discharge their duty to conduct impeachment hearing. With regard to the constitutional basis for impeachment, the Attorney General cited Articles 150, 144, and 145 of the Constitution, which she submitted established a sequential two-stage process. In the first stage, a member of the National Assembly initiated the process by filing a notice of motions supported by at least a third of all the members, which motion, if passed by at least 2/3 of all the members, was then transmitted to the Senate for substantive hearing. On the substance of the charges, the Attorney General submitted that the charges against H.E. Gachagua were substantiated to the prescribed standard to warrant his impeachment. She identified the specific charges upon which H.E. Gachagua was found culpable. On the standard of proof applicable to impeachment proceedings, the Attorney General relied on Sonko and the Court of Appeal decision in Wambora, both of which we have already referred to, which had held that the standard was above a balance of probability but below reasonable doubt, and that the allegations must be serious, substantial, and weighty, and must disclose with a degree of precision the constitutional provisions alleged to have been grossly violated. The Attorney General submitted that this court should not sit on appeal over Parliament's evaluation of facts and should not substantiate the discretion of the members of the legislature with its own. The Attorney General further relied on the advisory opinions of the Supreme Court in the Speaker of Senate and another, as well as the matter of the IEBC 2011 Supreme Court decision for the proposition that governmental powers were distributed among different organs, each exercising distinct functions under the Constitution, and that courts were required to respect the institutional mandate of Parliament. The doctrine of presumption of regularity was equally invoked, encapsulated the doctrine of presumption of regularity, and it was submitted that government action enjoyed a presumption of legality and that the burden lay on the challengers to demonstrate unlawfulness. The Attorney General relied on the Supreme Court's decision in Odinga and another versus RABC, our court and another, as well as, sorry, it's the same decision, Odinga and another versus the IEBC, including our court and another, the Attorney General and another as interested parties, and the power is vested in the legislature, thereby warranting judicial deference to the merits of legislative decisions. The Attorney General relied on the case of Nixon versus the United States, where the United States Supreme Court held that challenges to Senate impeachment procedures were non-justiciable under the political question doctrine, as well as the Duterte decision that we have already cited. On the part of the petitions relating to the nomination and approval of H.E. Kindiki, the Attorney General submitted that the provisions of Article 149 envisaged a sui generis procedure for the nomination and assumption into office of a deputy president. It was the Attorney General's submission that the process under Article 149(1) was neither an election in the traditional sense nor an appointment, as the text of the Constitution employed neither of those terms. In support of the sui generis nature of the process, the Attorney General drew on comparative constitutional provisions from the USA, Ghana, and Nigeria, each of which provided for a distinct mechanism of filling a vacancy in the office of Vice President through presidential nomination and legislative confirmation. The Attorney General submitted that as H.E. Kindiki was nominated by the President within 14 days after the vacancy arose, and the National Assembly voted on the nomination within 60 days, there had been no infringement of either the text or the spirit of the Constitution. Moving to the 9th respondent's case, the Honorable Mutuse responded to the consolidated petitions through a replying affidavit sworn on 22nd October 2024. He deposed that on 1st October 2024, pursuant to Article 150B, read with 145 of the Constitution and the Standing Order 64 and 65, he gave a notice of a special motion for the removal from office by impeachment
speak loudly, Dr. Nikonyo, so that their lordships can hear you easily.
With the permission of the court, perhaps you could place something under the microphone to just lift it up.
Work is a pain in the apps. My files are in this app. My chat's in this app. Projects in that app. Oh!
Wow. You're really working your apps off, Daniel. You need ClickUp. ClickUp is the AI-powered work platform that unifies your entire team and all your tools together in one place. No, not like that. No. It's a single place for your projects and docs, whiteboards and dashboards, calendars and chat, so your work goes from scattered to seamless. Plus, you get a fleet of AI agents to help you move at warp speed to get more done. This is the future of work. With ClickUp, it's like having your own assistant.
ClickUp, what should I focus on today? Okay, schedule time to work on these tasks.
I want an assistant. We've been over this, Greg. Before ClickUp, your work apps couldn't talk to each other. With ClickUp, a project can go from a whiteboard to a doc to a task to your team's chat. That's because all your work tools speak the same language. Unlike you and the night cleaner.
Thanks, I've been working out.
ClickUp turns your projects on autopilot with AI agents that assign and prioritize your team's tasks. So the work is visible and everyone knows what to do, even Randy. ClickUp is like your work bestie who always has your back.
The intern is taking all of that on?
Good for her.
ClickUp, what did I just agree to in that meeting? And how do I do that? Okay, send it to my team for review.
ClickUp streamlines work. From fast-moving teams to multi-billion-dollar companies. See how the future works. Get ClickUp for free today. I mean, look at Keith. He's using it. He loves it, right? He can't hear me. It's all right.
Wait, how old is the new hire?
I don't know, but he literally uses Excel.
You must be the new analyst.
Yes, first day.
6th floor. The team is quite dynamic. You're the new hire?
10 years in the industry, different company.
Which tools do you use?
Excel, PowerPoint, the usual.
Right. Welcome.
Henderson analysis. Full deck, client ready by Friday. Michael, what's your approach to client analysis?
I start with the data, build the model, cross-reference.
How long does that take you?
3 days for something thorough.
Diana, how long for you?
4 hours.
We'll talk after the meeting. I'm going to be honest with you.
Please.
Your experience is real, but the way you work is 10 years behind. AI tools, this team operates differently. Automation, speed.
I can learn.
You have 2 weeks to show me. I'd hate to let someone with your background go, but I will.
First week? That obvious?
I've seen that look before. Caroline gave you the 2-week speech.
Was I that loud?
Walls are thin.
10 years of experience and I'm 3 times slower than a 30-year-old.
Not slower. Different tools.
Same thing.
No, it's not. I was exactly where you are 2 years ago. Same speech from Caroline, same feeling.
What did you do?
Found this app. Coursive. AI tools, right tool for each task. 28 days, 15 minutes a day. My output tripled. Caroline hasn't mentioned the 2-week speech since.
You're still here.
I'm still here. You have 10 years they don't have. Add the right tools, nobody in that room touches you.
This is the Henderson analysis. Who built this?
I did.
When?
Yesterday. 3 hours.
This is the best client deck I've seen this quarter. Stay after the meeting. 3 days became 3 hours.
Right tool for each task. AI certificate program. 28 days.
You taught yourself.
15 minutes a day.
10 years of experience. And now the right tools.
Exactly.
Whitfield account. Senior lead. Starting Monday. I almost made a mistake letting you go.
I know.
Whitford account. Senior lead.
Yes.
How?
AI certificate program. 28 days, 15 minutes a day. You want the link?
Send it.
I get an order for 5 million Kenya shillings. This is 1992, and I travel to Japan. I arrive in Tokyo, and I go to the place called the Osaka by Shinkansen. I arrive 8 minutes late. And getting there on 8 minutes late, the departmental store president asks the team that I got there to be upstanding and to leave the room. And I wonder what happened. And he tells me, thank you very much. You and me, good friends, okay. Business, dame. When a Japanese shows you dame, it means not possible. It comes this way, or this way, or this way. And they say, it's over. And kwa reception, napata ai bill ya 12 pages. What is this? Naniambia where? I say, you drinking, okay? Chapa zote zenye umemake yote kwisha. Kimeumana. There are times that your supplier will meet with the institution that you're supplying goods, and they find that you bought an item for 50,000 and you're selling to them at 850 because umeongeza maneno juu ya supplier product, and you cannot lose because you're selling for 800,000 and you bought it for 50,000 or 100,000. You must be able to justify that this is the real product. Sio kudanganyana, useme ukweli. Kwani Janjes unajaribu mpaka Afrika. Kuna ujanja nishawahi kujaribu. Kwanza wamekutana wote wawili na umepatikana umelalia miguu ya mmoja, yes, na wa pili amekuja. Na sasa lazima uintroduce huyu ni nani na huyu ni nani. So mmoja namuita Her Majesty na huyu mwingine kimeumana. You must be able to sober up when things are bad. And that is what life calls us to be.
Awesome is for everyone. Awesome performance. Awesome upgrade. Awesome upgrade. Awesome upgrade. Upgrade. Level up. Awesome performance.
How does an online vision exam work? First, you're going to want to make sure that you're in a quiet, well-lit room. And then you're going to need at least 10 feet of space. You'll take the exam on your phone, tablet, or your computer. The exam will use audio prompts to let you know how far away you are from the device. An eye chart will then be displayed, and when you're 10 feet away, you'll be prompted to cover one eye, read the chart, cover the other eye, read the chart, and then uncover both eyes and read the chart. This vision test is then uploaded and sent to a board-certified ophthalmologist who is licensed to practice in the state that you live in. This doctor will then review the results and determine if it is okay for you to have a contact lens renewal prescription. In addition to the eye vision test, you'll also upload a video of the front part of your eyes. The doctor will review this as well to make sure that you're not having any eye redness or eye irritation. If everything looks good, you'll be sent a brand new prescription via email.
Conversation moto sana wadau, lakini kabla tuzame ndani, I wonder what someone your age or mine living in the year 1900 would say if they experienced the kind of convenience we have today. I would think about it, from transport, communication, and even movement of money. Life may change dramatically. Nilikuwa na check out how much time it took on average to send money from one person to another in the year 1900. And depending on where the sender and the receiver were located, it could take anywhere from a few hours to several weeks. Kitu kama kutuma pesa ilikuwa process manzi. In today's world umeipromise mtu utamtumia kakitu alafu mwambie chill kiasi. Squeeze chill kiasi kuna grace period ya kama 20 minutes mazi, depending on a few factors of course. Lakini mwaka kama 1900, imagine chill kiasi ingekuwa hata miezi kadhaa. What if ni emergency? Now technology has made it possible for us to send money across borders fast. Thanks to a platform like the SendWave wallet, you not only get to hold your money, you also get to send money to over 111 countries safely, securely, and fast. Alafu currency hapa ni USDC. USDC ni digital dollars. That is, 1 USDC is equal to $1 US. And now that you're alive in 2026, live like you're actually in 2026. Move na speed ya pesa by getting yourself a SendWave wallet. Kupata SendWave wallet ni rahisi sana. Use the link tumekuwekea kwa description ya hii video, na procedure ni easy sana. Verification ya documents za identification kama ID ama passport na biometrics and you're in. Alafu remember, kuna bonus ya new signing. During this promo period, utapata $3 cash reward on your first $10 deposit ukisign up using our promo code WADAU. Na bado the SendWave wallet iko na refer a friend feature that allows you to earn a bonus if you invite your friend using your own promo code. Now that nisha kuplug, tunaweza zama kwa conversation. Asante sana wadau. This is we'll open this episode with very strong words. Just before to start, this is possibly one of the best episodes we've ever done, and this conversation will prove me right. So now we start with a book, Green for Life. Kitabu kubwa sana, but I'll say something about this book. If you've ever struggled to get recruited into the reading culture, you should start with this book. The size may scare some people, but the content in this book, this is one of the best movies yet to be written. Ni kitabu ya our guest for this episode, Dr. Isaac Kalua Green. Na ukisoma hii kitabu, iko themes very, very interesting that complement some of the conversations we've ever done on this episode and some that we've not yet done. And I'll start also by making another bold claim, and it's a disclaimer. Unfortunately, we do not have enough time to cover the content that I feel that we should actually share with you on this episode. So I apologize in advance kwa sababu ni good vibes on good vibes. So without further ado, Dr. Isaac Kalua Green. Karibu sana.
Dr. Kingori, thank you for having me.
Karibu sana.
I say, wewe na wadau wako ni wale wase.
Asante.
Thank you so much.
Imefika straight.
Ndio hiyo sasa, asante.
Asante sana. Unajua, nimesoma hii kitabu, and I have to say, I mean it, we don't have enough time, because one of the struggles I've had ni tutaanzia wapi. Most people in this country wanasemanga umefika mwisho. Oh, maisha ni up and down. I don't think I've seen a better example ya ups and downs. Imeandikwa from brokenness to boldness. Ni ukweli, from brokenness to boldness, okay? And there are certain things, so I decided to segment it in ways that will help us go through it pole pole, because kama ni umaskini, you have seen it. Kwanza, before we get on set, you described poverty. Ukasema, umeiona umaskini yenye unaweza shika na mkono hivi. Just give us a highlight.
It can never get worse. I think I have seen it. Ukisema umaskini unashika kwa hewa.
Yes.
Mimi na my dad.
Yes.
Tunapika chakula Githurai. Hapo 45 kuangala mwendo wa hiyo area.
Yes.
Na mkebe ya cowboy ya 2 kgs.
Yes.
Umeshika na ile waya ya sijui inaitwaje, kamata.
Yes.
Mnapika na kuni.
Yes.
Na ndio unafundishwa skills zingine you can never learn them from any school. That's how I got to know that unapika kwanza mboga ndio upike ugali, sababu sufuria ni moja.
Yes.
Na ukianza na ugali huwezi kuosha mpaka ikuwe safi na upike mboga.
So fuate procedure.
Life has got so many challenges. So I have passed through that.
Okay.
And yes, it is possible to move from brokenness to boldness, because it's a matter of principle.
Yes,
and
yes,
how
yes.
you can attach this.
100%. And I think your dad is a good place to start. And you open with a very interesting principle, and that I observed. Your dad was a prison warden. Okay. And before I know the weight of what that means, he never interacted with prisoners because he was assigned to gardening.
Yes.
All right?
Yes.
In his assignment to gardening, hiyo ya gardening, through the ups and downs, like he could have complained, angesema, like nili sign up kuchunga wafungwa, sio kuchunga mimea. But somehow, hiyo mimea,
yes, somehow
hiyo mimea ilimpeleka State House. Just to give context, kwa hierarchy ya people who serve in the disciplined forces, the president is the commander-in-chief.
Yes.
Right? Your father was a constable, no promotion, years on end, tending to plants. But in the area of assignment, ya plants, he gets to work directly for the commander-in-chief.
So this is, my dad, God rests his soul in peace, exemplified consistency. And actually you realize, and you come to appreciate looking at his life, Daktari Kingori, later, you realize if you're consistent in doing something, doing it right in the best way possible, to get you places. Yes, he did interact with inmates because he was working with them, but his business was was to tender plants, was to deal with everything to do with gardening in the prison service. He was so efficient, he would be required from one prison to another. And you realize that as he did that, he moved us. He moved me and my brother John, because those were the ones who were born at different times and places. He moved from Nairobi West Prison to Prison Staff Training College in Langata. He moved to Kamiti Prison. He moved to Nakuru Prison. He moved to Kitui Prison. He came back to Nairobi. Different places across the country. And what did that mean? Every year, because of his efficiency in serving and gardening and making presentations of what every prison's service would want, we had to move to different schools. I moved to 7 different schools for my primary school, which meant a year for each school, for each class, as I did. Because of his focus on everything else, it did not matter what he wanted to do. He then would move into preparing the National Agricultural Society of Kenya show, and Prison's Service stand was the best ever in terms of the beauty, presentation of what everything was being, how it was being done, and it is there. Out of one place, just one time that he left and he did not work at the showground, the president noticed that there is something that is amiss. And that was the president then, President Moi. And he asked, where is the Mukamba ule alikuwa akifanya kazi ya maua hapa? And he was actually promoted time and again. By the time he was leaving prisons, he was a senior sergeant. And he's told, he left, he retired. And his reasons for retire was to go and start business, to be able to sell plants and be able to advance so that his children can be able to advance in life. I remember at one stage we were staggered, so that when I finished Form 4, my brother would come into Form 1, and the rest would follow in that order, because he could not sustain at that time to get to school. But he was very consistent in as far as his work was concerned. And eventually the president is told the guy left, and he is now retired, he's at home. He was sent for, and called to come and work to tender flowers inside State House. The then controller of State House, Abraham Kiptanui, was referred to whom they had worked with him in prisons before, said that he was available, he could be found, and a gentleman called Gershon Mwiti, God rest his soul in peace, the husband to Dr. Gladys Mwiti, is the one who was told, go and get the old man who used to tender flowers here. Why he did the best job ever, and now he's not here. So he was called back. And this time, and that is the time, the period that, remember, the period that he left prisons and the period he was called to State House, that's the period that we were now cooking in the tin. Trouble. Shida iko kwa hewa, unaweza shika hivi, unaisikia hivi.
Yes, yes.
And he was called back to come and work in State House, and he was now the superintendent of gardens, state houses and lodges. He used to do the flower for the famous rose flower for the president that was on his lapel. And it talks about consistency of doing what is right, being committed, because we lose it in life. And we fail to make money and to do business in the best way possible because we are inconsistent. So it's a good lesson that I learned during that time, and I have always applied it, and I thank God for his life. So from the level that he was just an askari and retired, but keeping on focusing on the right thing that he is focused to do, and eventually he ends up in State House to tender flowers. And when he got into State House, he referred himself as a shamba boy. It did not matter that he was working in State House. He still did a lot and focusing on what he was. State House never got into his head. He was still the same guy, preacher man, and doing what he needed to do. Again, all about consistency.
Fun fact, he actually opened the first church at State House.
Yes.
Your father built the first church.
Yes, he did.
In State House.
Very controversial process. You can only read in the book.
Yes,
and,
yes.
See how difficult it was, because he found that there was no budget to build a church.
Yeah.
And his question was, why would an institution like State House fail to have a church? And driven by the spirit of wanting to do what God would love to do, he built a church using what was easily available. And that was mud and sticks. And he put it together. And the following Sunday, it was full to capacity. People coming to pray together. The small church, of course, full is relative to the people who are working in State House. And he did that. So today, and it had to be brought down, because how would you go building a church here and yet it's not supposed to be there, and you wonder what is all these people around the president that believe that maybe this is not what is required, and therefore it had to be brought down. But his spirit kept going on. Today there is a church in State House. It doesn't matter what it is that people will talk about, but it's about prayer, it's about committing. Whenever you are doing anything and you don't put God first, you're headed nowhere. That is a fact. So I thank God that even though the church was demolished then, another church was put up. And this time he planted the seed. And the next one was done with iron sheets. And today
you're talking billions.
Church.
Yes,
so
yes.
It's and it's not about the money. It is about having a place of worship. It brings you down to humility, to appreciate that there is a superpower. There is God in heaven. There is where you subject yourself to in life. And therefore, the moment a nation fails to get down to appreciate that there is God, that there is a bigger power that you need to subject yourself to, then you start failing. It doesn't matter what you believe in. There is God in heaven. And therefore, we must be able to do that. And doing good for common good. I think that is what must drive us. And in business, in everything that you must be able to do, is not just things that you concoct in your mind and imagine that you are going somewhere. There must be a principle that sets your compass and direction towards the right thing.
Okay. And when your father retires, he enters into a partnership with someone for a landscaping business, and this person finesses him, right? What lesson do you learn from him as far as the concept of holding on or not giving up is concerned? Because can you imagine that all the years, and it's interesting that you say that, all the years that he had worked on the plans, the president knew that there is someone who is working on these plans. It is until it was not worked on that he notices that something is amiss, right? So this speaks to a very interesting concept here, that if he had continued, he would never have, I love hypothesis, maybe he may not have unlocked the higher potential, right? Does it sometimes call for stopping doing what you do to move to something else so that maybe your work can speak for itself? Because if he had continued, angeendelea na hiyo roho, okay? So the question here, when to stop, na when not to give up, because when he ventures out to business, ndio mnapika na makimbo. Hapo tuko happy hapo kwa like not giving up. What do you learn from him hapo?
I take us back to consistency, because it's about what you plan to do and where you're planning to go. In life, you must have a direction. You must have a principle. You must have a philosophy. What drives you? Like I have a green philosophy, which is simple, and you must clarify it so that you see it as it is. Then when I say a green principle, a green philosophy, for me it's simple. It's about kindness. Being kind to one another, being kind to life, being kind to human beings and the environment is beyond else. Second thing is working towards sustainability, so that you're working about sustainable livelihoods. And the third one is the passionate environmental conservation. Whatever you do to me, I will always bring things to that. And I believe that my father in this principle, how many partnerships do you try, Dr. Kingori, with what you do, the people that you reach, the people who are so passionate with what you do? I dare say that I see a CNN, I see a bigger institution in what you lead. I see we are on the 9th floor of a building. I see a situation where you will have a whole total building with more than 20 floors because of the spirit that is in you.
Thank you.
And when I mention this, I'm saying this also as a prayer to God, because you deserve our best. You deserve God's best.
Thank you.
Why? People get into partnerships, and partnerships that are not well anchored, because people do not have principles. People do not have a life philosophy. They're just driven by having money. By the way, the moment you are driven by making a lot of money, and that is your goal, you end up getting nothing, or you get it and it gets lost on the other side. Because there must be a bigger principle that drives you. You cannot do this program because you want to do a 20-floor building or even a higher. You do it because of the livelihoods that you are transforming. The people are listening to me. You are putting billions into their minds. I started business at age 19. And today now we are talking of my father, who had nothing that I would carry to my time and age and everything that I do. What I carried is goodwill. His good principles, that when I say that I am a son of so and so, oh, the preacher man, you are trusted immediately to that level. So any business, any opportunity to do transformation of livelihoods, my father took it very seriously. It did not matter that the partner who came in to work with him did not believe in what he wanted to do. Maybe they believed in making money, and they would go to the showground and they make a lot of money. They end up not having the money that they planned. There are opportunities. Yani unafanya na mtu job alafu unarushwa tu, inakuwa ndio hivyo. Na ulibelieve mtafanya nini, kadil kamoja, something else doesn't happen. What must keep driving us in principle is the bare minimum simple opportunity, which is about doing good for common good and being consistency. We know Kingori, you've been on it. Why you not the same guy who used to host a program that we used to shock you to joke around with, and it was suckers on its and its best, and I remember the audience.
Yes.
10 years later, you're still the same guy doing what you do. What would make you not the richest and the biggest and the most influential person in the continent of Africa if you are not doing this? If you started what you did and you end up selling nails and cement, that would not be your space. You'd find other companies working out there. So for my dad, to answer your question, it was about consistency and believing in what you do. In life, you get wrong people, good people, fair people, and many other people that you never imagined that they would cross your life. But you must be driven by what makes you better every moment. It doesn't matter, your spirit must keep going so that you can succeed in your mission, and money will follow your mission as you deal with this.
Okay. And probably before we proceed to because your journey in business is, like I said, a movie in itself. The obsession with making your first million and being a millionaire should also be a book by itself. But there's something you touch on about your father, though lightly, but let me make a bold statement on it in my observation. Your father, in his own way, as the Shamba boy, as he would call himself, I would dare say that the topic you passed by lightly to, one of the most prominent leaders from Eastern Kenya is Kalonzo Musyoka. Without a good word from your dad, in his capacity tending to the plants, this country probably may not have had Kalonzo Musyoka. I'll support this bold statement because it is him that makes the introduction of Kalonzo Musyoka to President Moi. And this introduction in itself is, it signifies, there is no separating the career progression of the former vice president. You cannot separate his career progression from that introduction. All right? And I think this is the first place I interact with the concept of social capital, right? The idea of, like, you may say, like, in his small way, at his time, he did not have something big for you to inherit, for example, but his word carried weight and you cannot separate that. And that brings us to the idea of social capital, your relationships. What, before tuingie kwa story yako ya biashara na the journey ya number one salesman 001. And again, another fun fact, our guest for this episode, Dr. Isaac, is among the first Kenyans who started importing Japanese vehicles into Kenya. That's again another movie, but hiyo lazima tufikie. What comes to mind when we talk of the concept of social capital?
appreciate who you are. There is, in this world, don't try to be Dr. Kingori. Be who you are. Dr. Kingori will come for you, and you will go for Dr. Kingori. People fail. You see, I'm proudly a son of a Shamba boy. I'm so proud. In his Shamba boy status that he has been and was in life, my father would tend flowers. He would, remember, he's the same guy in prisons. He's now in State House. He's preaching his word, the word of God, and doing all these things. The president, he created the first ever in State House, a place called the Retreat. After the pressure of everything that he was out with, the president would turn to that place called the Retreat. That was the creation of my father. He would sit there. It was in between the garden, and it would be a place that he would have discussions, talking to his friends, or just retreating by himself. He would go out there, and they would just be the two of them. One of those sessions, a Shamba boy and a president. It is the president. He tells the president there is a gentleman called Kalonzo Musyoka, and I would like you to meet with him because he is a man from my place, and he's a good guy. He's God-fearing, and he needs to be known to be doing these things. And I'm talking about this because it is a historical fact. And then eventually he makes an appointment because Kalonzo would come to his little office of superintendent of gardens, and this specific time he said, okay, I will try to get a space for you with the big boss. And he was given an appointment from the Shamba, and he met with him, and the rest are details. Today he is what he is and who he is. And I believe the lesson here is having a name, being consistent in what you do. In life, I believe for you to succeed, again, whether in business or anything else, you must tailor your life. And I have coined some words, TLR, which is trust, trust, loyalty, and responsibility. You must trust yourself. You must trust your God. You must trust the people that you are with. You must be loyal to God, loyal to yourself, and to the people that are around you. You must be responsible enough to understand that life calls for you to be responsible to all that are around you. Once you appreciate that, the rest becomes easy. You stop being a sycophant. You become the person that you believe that if I speak to Kingori, I'm not talking about myself, because there is nothing that I want about myself here. I want to impact the future. I want to, whoever is listening to me, that there is something that I have added in their life because I started business at 19. Today, I am the age that I am at right now, going to 57. I want anybody who listens to this should never go through what I went through. Only a fool can repeat a mistake you may have done yourself or others. Take advantage of that and be able to change your life. And therefore, that time, it's an opportunity that happened because of a Shamba boy, and the Shamba boy gets up there and introduce someone that he did not know, taking a risk. Again, life is about taking risks, to introduce somebody so that you can be able to move on. And that is a principle that I have seen, that just do good. I love the Muslims. They believe in one thing, tenda wema nenda zako. And it's not just the Muslims. You just do good. Imeandikwa, imeandikwa. The same thing as Christians. We should just do good. Love your neighbor as yourself. And that is a principle that he applied then. And today, as to whether they know or not, it happened. It's a historical fact.
Very nice. So people should learn from the mistakes, and Lord, have you made them? Mistakes. Tunakuja kwa mistakes, but before we go to the mistakes, let me put at par 2 people at State House, I would like to believe around the same time. We had
Dr. Kingori, you seem to have read this book completely. I thought the discussion was different, but here we
advanced to discuss the mistakes, and we leave some of it for people to read the book, because we can't even scratch the surface, but the surface is enough to learn.
Yes.
Let me juxtapose 2 people in terms of principles at State House around the same time. We had Linjiro on our podcast. He's a former PA to President Moi, PA or pressman. He has a book in it on the president's pressman. And he writes about a bodyguard of Mzee Jomo Kenyatta, who Kenyatta's most trusted man. And Linjiro writes that he was the only man the president could give money. The only man, Mzee Jomo Kenyatta. And he was retained by President Moi because he couldn't retire. And he was retained until he was too frail to work anymore. And then he was retired. And then Linjiro writes that he went to the village, he had nothing. And when he passed on, not even a single person from State House even attended his funeral. And he was so close to Mzee Jomo Kenyatta. And the thing that comes to mind haraka ni the thing that Kenyans say, you had that much access and you did not enrich yourself. So they would view you as someone who wasted an opportunity. Okay? One person. Then your dad in Moi's time comes and has the same access to the president. You and the president. What stops him from enriching himself?
You have answered the question right there.
Mm-hmm.
During the time of my father,
yes,
apart from that kind of introduction, many other kinds of introductions that he did one at a time, he never had one single, those lands that were written that you have been given land here, you have been given this, you have been given none. There is only one in around Masinga that was given out, which was lost in a different way, as I've written in the book. He never amassed the wealth that people would associate with power at that time, becoming multi-billionaires in many ways.
My work is easy because I use ClickUp. Here's how AI saves me hours every day. It automatically prioritizes my tasks so I can focus on what's important without wasting time trying to figure out what to do next. I can ask Brain about any list to quickly get up to speed. When I need to draft documents, ClickUp Brain helps me get ideas on paper. And questions in our team channel now get automatically answered by an AI agent with expert company knowledge. ClickUp makes work easy, from personal projects to running a multi-billion-dollar company. Click the link below to create your workspace for free.
Today, he left us. But what is it that I cannot thank God for what he has given me? It is his blessing, his good deeds that follow. I assure you, I do not know that officer that Linjiro talked about. And by the way, Linjiro was a very good friend of my father. And when it was time for him to leave State House, I remember our father coming home to tell us that Linjiro told him, enda usimame pale nje ya State House, utaona Mercedes zinapita. Hawajui ndani ya State House inakaa namna gani. Meaning there is a lot beyond where your short-eye-sightedness is seeing and imagining, and that there are many opportunities. I hold a very good name And I pray for Linjiro and his family to succeed forever because of the base and foundation that he kept and the principles that he kept even as in writing in his book. Look out for that old man, whether today or future generations, because some of these things we tend to imagine that we are doing to one another, but God is recording. That family will never lack out of what they did, the trust that the former President Mzee Jomo Kenyatta had for him, that will return to him in many ways. And please search, go deeper. Don't leave that discussion at that point. Look out for that guy. He is blessed wherever he is. His children are going to be blessed because you never go wrong by doing what is right. We tend to have a move in life that you just want to support, you want to get rich quickly to be able to succeed in many ways. That is not the way. There is a secret in just doing good for common good, for God's glory, and you end up doing what is right. And in business, it is also the same principle. We want to get rich very quick and forget what needs to be done, the dream, the vision. We during Kenyatta's time and slightly earlier, we had 10 million people. Today we have 67 million. The need that was there is 6 times more today because of the number of people. What business am I doing and where is it going to go? How many people? The fact that fewer people, you are selling 200 motorcycles. Today, I am the chairperson of Honda in Kenya. We started by doing 20 motorcycles or even 10 motorcycles. Our dealers would sit there and wait for a buyer and fail to get any buyer. But are we not the same institution that has sold 1 million units plus today? Are we not part of that economy that has changed and transformed this nation? Why? Patience. The idea of getting rich quick has messed many people's lives. They have broken dreams that were going to be so humongous in the way that they are. But we fail to have that patience, which is a virtue that we must be able to apply in many ways. People want to copy the others because Kingori is doing a podcast. You find every other person in the media industry. They don't know that there was a show. What was the name of this show?
The Wicked Edition.
The Wicked Edition. And it sounds so funny that even Kingori is wicked. How can he be thinking about this thing? But see where the wickedness has taken him today. I'm seated here. I have driven very many kilometers to be here with you in this show because it's a great honor to be here. And because you're touching many people's lives. And therefore, that is what we need to apply. And it's a principle in business that must work for us.
Thank you for saying that. And thank you for the kind words and the compliments.
You deserve them.
Asante. Yes. So now, there's something my friend and I arrived at as a conclusion. My friend, an advocate, people know him, anaitwa Senior Counsel Otieno Mukaya. We arrived at a conclusion that possibly getting money, too much money at a young age, could be some sort of a curse. And that theme also popped up somewhere in this book, because I remember the first time you board a plane. You boarded there and you find this lady, old lady amekaa hapo. You already identify as a businessman. Now there's a blanket on the seat and you're like, yo, bana. Take your blanket, nini, nini. And there is that aura, I'm a businessman. In fact, when I think she either signaled you ama alikuongelesha kidogo and when he was, I'm a businessman, I'm going to Japan bara. Nini akakwambia okay sawa pole, the blanket is yours, it is for you during the flight. And you can see there's something money does to someone, a lot of it at a certain age. Is that true?
It is very true. And again, that is why I write the book. It is actually a life manual. Because it brings out what is most transformative in life. And I will go back to the main thing before I now answer your question. One, it talks about MPR. Make as many mistakes. M stands for mistakes. Make as many mistakes as you can. Enjoy making mistakes. Pay if you have to pay to make a mistake, but never repeat one. In the same trip that you're talking about in life, when I was traveling to Japan, I made so many mistakes. The first one was that one. I'm now rich. I had a business card that was written Managing Director, Carl Investments. And therefore, I wanted to behave like Managing Director. The way Titus Naikuni then would look like tall and, a guy that you really want. I want to behave the same manner, not knowing that there is a bit of experience that is always needed for this. I get on plane, find it's the first time I'm getting on a plane, and I'm here headed to Japan. Then I think I was 21 years old, and I'm headed to Japan. I get to Japan, get into a hotel, nimepata closet kama kakanoma. Kakona drinks, I said, na unajua nilikuwa napiga Masmanoff, vitu zingine, Johnny Walker, hizo vitu za aina hiyo, but sasa nimeenda nimepata ma 18-year-old, ma 23-year-old, 25, vitu. Vitu. The inside vitu, but ndio hiyo sasa. Nararua bwana. Nobody had told me that these things, ukipata huko kuna vitu zenye unapasa kusoma. And then I rushed to the room and finished business mapema sana. Ndio nikimbie kwa room because I found that they already replenished. So I do that for 7 good days. 7.
Yes.
Naenda kwa reception, napata bill ya 12 pages. What is this? Naniambia where? You drinking, okay? Chapa zote zenye umemake yote kwisha. Because of naivety. Because of not knowing how things are done. My mistake was not drinking, because drinking, there are people who drink and they are careful and they are responsible.
Yes.
That is not necessarily the issue. The issue is not reading instructions. Not reading instructions is the lesson. And therefore, when you're doing business, when you're doing things, you must ask yourself, what is the lesson that I must learn in this? And therefore, the MPR tool that I talk about in this book is something that every single day, Kingori, you make a minimum of 5 mistakes. Minimum. Whether it is the alarm that you set in the morning and you're the same one that is putting it off, that's a mistake. Whether it is arriving late, yet in 1992, I got late for 8 minutes. 8. 1, 2, 3, 4, 8. And I found that the biggest departmental store, even my 8 with my 5 million order that I was going to get as the sample order, and therefore the following order was going to be in terms of containers in the entire Japan. I got late for 8 minutes. Today I value a watch so much. There is nothing I cannot pay for a watch, not because I want to show off, but just to remind myself about time.
Please give us a background of that, because someone watching is wondering, tunaenda na gaps. That's a very important lesson. Like,
yes.
What happens is siku ya 8 minutes?
So I get an order, and I'm still answering your question, because life is interconnected with so many things that you must be able to understand, but you must have an anchoring tool that drives you. So I'm now talking about mistakes, making as many but never repeating one. And therefore, I get an order for 5 million Kenya shillings. This is 1992, and I travel to Japan. I arrive in Tokyo, and I go to the place called Osaka by Shinkansen. I arrive 8 minutes late. And getting there on 8 minutes late, the departmental store president asked the team that I got there to be upstanding and to leave the room. And I wonder what happened. And he tells me, thank you very much. You and me, good friends, okay. Business, dame. When a Japanese shows you dame, it means not possible. It comes this way, or this way, or this way. And they say it's over. I thought it was a joke, Dr. Kingori. And 5 million out of the window in a foreign country, gone, lost, because of 8 minutes. I was telling you about the watch. If any business person, anyone doing, whether you are selling gouache or you are selling Ruma or you are selling cars and anything, the moment you do not respect time, you're gone. I learned it the hard way. You don't have to lose an order for 5 million. Then today we are talking of hundreds of millions of Kenya shillings. If you don't respect time, don't wait for anyone to tell you that you are cursed or umerogwa ama umefanya nini, wewe mwenyewe umejiroga. Just because you love the sleep and you did not know what to do as at that time. In life there are 5 mistakes. Every single day you must have a mental torture, a mental note. You must have a notebook. What mistake did I do today? And that becomes the answer to you advancing to the next level. Every day must be a route towards your dream in the way that you have planned it. And therefore, letting you know and letting our people understand that life is making mistakes, avoiding mistakes. We talked about the P, and feel free to ask this. P is being a problem solver. And I'm sure we are going to discuss some of these things as we continue. Every single day, you have problems that you are solving. And in the book, and I have always found it to be a principle that must be applied every day, problem solving has got 4 different categories. And I use the example of a wedding party or a place where you are in a garden party. In a garden, snakes are normal. A snake appears. And 50% of the people in that gathering ran away so fast, not because they saw the snake, but just the screams and the imagination. Why are people? And you ask them 300 meters away, kwa nini unakimbia? The person doesn't have shoes, they don't have handbags, they don't have anything. Nafikiri dunia imeisha. Mimi nimekimbia. They only had the commotion and they ran. 50%.
Yes.
So that you don't ask the principles why I'm not making money, why I'm not succeeding. You just ran because you are told, hii kazi ni ngumu. Siwezi nikadili nayo, inakaa ngumu bala sana. Ajeje, unasoma gazeti ama social media, ati huyu alichoma shilingi sijui ngapi, huyu alikutana na auctioneer, huyu alifanya nini. Unakimbia, unasema, woi, wacha niwachane nayo. You ran away like the person in a garden wedding. 50%. The second lot is a very interesting lot. They actually see the snake and then they just run 50 meters away and they start talking. Akia nani hiyo kitu niliona ikitoka kwa mfuko wa Kingori. Akia nani niliona. Mimi nakuambianga hii kitu ni majini, hakuna kitu kingine inakuanga huko. Wanaongeanga tu hizo vitu. And they are talking until the cows come home. They are solving the problem by talking. The first one ran away. At least these ones are better. They are talking about. They are 25% of these people. What is this that in business that you see, you don't analyze, you don't getting to know the details, you do not have people in friends, in Facebook, in social media that are doing the same business that you're doing. And therefore, when you just hear about it, you start talking about your things without referring to what they are talking about, and therefore you lose the opportunity, the vision that you had by just talking about it without any basis. The third one is a 10% group. They see the snake and they rush to the phone immediately. Snake at a garden party. What can I do? Wameenda kwa ChatGPT ama cloud ama wameenda kwa Google, wanatafuta what to do. They are better because they are researching, but they are only 10% of this. So imagine sasa umebakisha percentage gani ya watu wenye wamebaki, which is the final one that I talk about being a problem solver, because we are talking about the P. They use whatever is there. If it is a bottle like this, they will use it to hit the snake on the head. Or if they turn to be as crazy as I am, they will tie it up or put it inside a bag and take it to KWS. Not just because I'm a honorary warden, but because that is the right thing to do. How many people in life choose to deal with issues head on? For you to be here today, Kingori, Daktari, you must have gone through so many challenges. You are told, oh, unalipa hiyo rent, unaanza na hiyo kwanza, umelipa ya nini ndio ukatoboa. Wewe usare hiyo. Anzia huko nyumbani sijui Geshagi wapi. There are places that you can't call some people to come and listen to what. There are people who can't take you seriously just because of having this kind of a mic or another one because it can do. There reaches a time when problem solving must be very practical. This is what takes your business to the next level. If so and so did it and managed, why not me? If this, meeting it head on. And that is what makes a business successful. Every single day, you have 5 problems to solve. 5 minimum. That mental note, what is it that I have noted and I have solved? There are things that you get into a room and you find that there is no AC and the air circulation is not right. Na mtu mmoja tu akiingia unaona anaenda kufungua dirisha anafungua. That's a problem solved. A cable that's not working and anaenda anatengeneza anafanya nini? What is it that you are doing for your business, for your life, for your family, for anything? 5 every single day. Everyone has that. Do you take note? The R, which is being a respecter of persons. And there are many opportunities that you have. I give an example of a stinking guy who was doing construction in our home, and he had a history of the house that we had bought that we needed to correct. And he tells me, hii nyumba ilikuwa ya mtu ambaye alikuwa na shortcuts, alikuwa jamaa anafanya na jeshi or something, and he did not do it right. And if you continue the way it is, itakuja kuangukia watoto wako. And the question is, okay, how is that possible? That a stinking guy, people wenye hawajawahi kuogangi, akona wiki 3 hajaoga, akifanya hivi tu kidogo hivi, inzi zinachomoka. And he's the guy who's giving us a solution, because a very close friend of mine that you will see in the book helped me to get the house. His name is David Langat, and he brings it out in a way that bring out the engineer, come and check what is all this. And he says, yes, the structural process of this house fell. Who told me this? A stinking guy. Every single day, Kingori, you have an opportunity to be so kind and respect other people. 5 people. Just the askari that you smile with at the entrance, your accountant, your employees, your team members. That smile will solve out your problems. There are times that even the Google doesn't know where you are going. They tell you you have arrived and there is nothing arrival like. And a guy comes smoking everything that can ever be smoked, and he tells you the direction is this one and you could be killed from here. 5 people. In the same way God has blessed you, Kingori, he has also blessed others. Never despise anyone. These principles in life, I find them so practical that you can take them on in every application and at its best. Having a principle of knowing what is it that I want to achieve in life. I wear something green every single day of my life. Why? Just to remind me. You think you are going to be reminded, you're going to see me. I've not worn it for you. It's my principle. okay, you love it, and I can see you have a green shirt on you. And maybe it's just a color, but for me, I put it on to remind myself about kindness, about sustainable livelihoods, about passionate environmental conservation, consistency, that people can be able, and anything that I see, I apply MPR, because I want to be able to take on anything head on to solve the problem. And our life is green. How is it that everything that you can bring it forward to get into that principle? These are the principles that I believe can help us to achieve. I don't know whether I answer your question, because a lot of young people today, they want to get rich very quickly. I have demonstrated in life that you can make money. You can buy a Mercedes Benz, as I bought one, KAS 988J E200, out of planting and growing seedlings, just because I was serious. And I told my wife that this is what we are doing. It's not because I want a Mercedes, because I want to show the youth how you can be able to do this kind of a thing, and that you can make money out of where you don't expect people to make. That little business can buy Mercedes, can build a house, can do something extraordinary if you focus and you be consistent about it. I have done it umpteenth times. I no longer drive the big cars that were there. I drive little doodles, and they take me where I'm going. And I use 2 shillings per kilometer when it is electric. And you're spending 2,000 because you want to be seen a big guy and a big car, or you're competing with the big car when other people are buying the big car to save money on tax, and you're going to borrow to buy a big car so that you can be seen with a car. What drives you?
Other people are buying the big car to save money on tax.
Yes.
But you're buying the big car
to be seen.
And because you think the big person has bought the big car,
yes,
because of money or to show money.
Yes.
It's actually to save money.
To save money. And you're buying for the opposite reason. You must be driven by something. What is it that is making you do the things? Because in life you must ask yourself the why, the big question. Why am I doing this?
Just to put this into perspective, when someone goes and buys, just so that people get this clearly.
Yes.
When someone has 10 million,
yes,
to buy a car,
yes,
they go buy the Prado, yes, for 10 million.
Yes.
All right.
Yes.
The duty is almost 40%.
Yes.
Say, or more taxes. Let's say 50%. 5 million goes to taxes. When they are doing their books, they claim back the 5 million.
Yes.
That's how they save money.
Yes.
So you go borrow from a bank to buy, pay interest on taxes.
Yes. And not only that, you have done your very good business of this business of media, and your profit is 100 million at the end of the year, or much, much more, or even less. When you go and buy a car, it is an expense that is allowable in the laws and tax procedure, and therefore it is an expense for the business. And therefore, you save your money. Instead of paying tax of so much, you buy a car and you reduce your money, and you already have a car because your business needs a car. There are people in this country who have planes because they were saving expenses to move from one place to another to inspect their business. They bought a plane to save money from taxes. And you're borrowing a car so that you can pay out of the processes instead of saving taxes. It's simple. You're declaring what
different worlds, different
worlds. Just because, and it's all in the green for life. You can be able to understand this.
Manual for life. Grab yourself a copy. Tunasemanga. We leave a link in the description of this video that takes you directly to the Nudia store, to this book. You can order it and they will deliver to any part of the country. So this thread starts from getting a certain amount of money at a young age is some form of a curse. And now I'll put it in context again. If you had, by whatever reason, arrived 10 minutes early for the meeting in Japan, and you got the gig for 5 million at the time when this was happening, you are very young. I believe this is in your early 20s, right?
Yes.
So there's a phrase, because Mimi, having read this story, I know who you are in those ages, man. So now there's a phrase that says, sometimes God withholds some blessings from you because he knows what they will do to you. Do you think this is what's happening in your life then? Because you at that age, in your early 20s, I don't think, kama unafikiria wewe ni mwild enda usome kitabu, you with 5 million, kama ni 250,000 ndio Nairobi ilikuwa inasimama, what would have happened to you with 5 million?
There's a lot of drama in the book, and the book is about red. It's called Green for Life, and the principle is RED, R-E-D. Responsibility, efficiency, and discipline. These are 3 principles in life that must be able to drive you, and it brings out all this together. Many young people, they would want to buy the best car, they would like to race, they would like to have the best girls. Well, the book talks about girls that I had, many of them, different times, multiple, did everything that a young man can ever do. So if you're trying to do something today, tushafanya. Okay? It talks about it in the best way possible. And lessons that I have learned, that it's all vanity, that you can be able to chase after. It's like chasing after the wind. You can never get to where you need to get to. Life treats you in readiness of where you are headed to and what you want to achieve. And it reaches the time when the 3 come together. The responsibility, you have to be really responsible on what you do and understand that what you are doing is not just, you are not your own. You belong to others and others are depending on you. At least your mother and your father or your uncle, whoever your guardian is depending on you. Efficiency, how you do your things and why, the way you do it, and the discipline to handle. Then that attracts money. That attracts the responsibility. I started business because I wanted to be a blessing to the people of my community. I would see the women weave bags. I would see young people in Wamunyu create images of the wood carvings, and I wanted to be a blessing to them. That is what drove me to do business. And I did everything, as you will see in the book, the chain of how I got to do that. Takes you to a point that you realize, enyewe, amengojee pesa, wacha yangu ningoje, wacha huyu apate yake, because if I don't get it, it might delay yours. But you have 57, now going to 57 years that you can say, I learned from Lua Green and I would like to apply and avoid the mistakes that he made so that I can move forward. When your character is being developed, now my friend, my character has been developed proper. I can talk and you may be able to listen because I am talking of real life issues. If you have not gone through that, if you're just imagining in the theoretical way of how life plays, it's different. You just have to go through life in the best way possible.
Our guest, Dr. Isaac, was a bad man upon bad man. There's a place where two girlfriends, let me say, because in context of this time, have met in your house. And I cannot believe the audacity that you left. You go to your girlfriend mwenye ako kwa gari outside and you negotiate with her to just let you spend the night there that day because it is your last day. Like, that is is audacity on audacity. Like, Malia, as in, it's unimaginable. Like, the comedy of that scene, like, it's not, you see, I'm not apologizing. You just let me spend the night here today. Just this is the last day. This is our last day together. We will break up. We will catch up.
Bas. Ujanjezi. Unajaribu mpaka inafika. Kuna ujanja nishawahi kujaribu. Kwanza wamekutana wote wawili na umepatikana umelalia miguu ya mmoja, na wa pili amekuja. Na sasa lazima uintroduce huyu ni nani na huyu ni nani. So mmoja namuita Her Majesty na huyu mwingine kimeumana. You must be able to sober up when things are bad. And that is what life calls us to be. Situation umepatana nayo utajikojolea ama deal na situation. You must be able to deal with the situation. And I write this so that people can understand some things are real. You know, in life we keep hiding. That iko maisha inakuanga hivi na kilipatikana hivi. When we don't tell our children that this happened, when will they ever know? When you don't bring a guest like me who is talking about real stuff, how life has treated me, how will they get better in doing business in the way that they should do business? Kimeumana. There are times that your supplier will meet with the institution that you're supplying goods, and they find that you bought an item for 50,000 and you are selling to them at 850 because umeongeza maneno juu ya supplier product, and you cannot lose because you are selling for 800,000 and you bought it for 50,000 or 100,000. You must be able to justify that this is the real product. Sio kudanganyana, useme ukweli. Kwani na unakaza macho ikiwa wazi, because this is a situation and you've been found. Being found by two women in real life is the same way you are found doing business with the right principles, and that teaches you. Don't move from 50,000 to 850 because that scenario will be terrible. Bring it down to a manageable level so that you can become friends with this other person and be serious about it.
Justify the value you're offering.
The value that you're offering. Business is like that. Do you think that everyone who is out there doing business, they just walked into an opportunity and they made a kill? It's a process of consistency. Life, business, and every way you manage life must be managed in a manner that you can stand and explain. I was in a relationship and I was in a different relationship, and I was a young man and I was trying to make life and ends meet. How do I bring myself out? There are 4 situations: run away and leave them in the house to fight, let them talk, deal with the situation and they sort themselves out, they become friends, or look out in the cloud or in chat GPT how I can solve the problem.
Yes.
I had to solve the problem, and the problem was to say, guys, here I am, and this is the situation. Life calls for that action.
Yes. Yeah. So now, so much to unpack from what you just said. Kuna principles of business hapo ya justifying value. That's solid. But again, kuna around this period, you also learn something very interesting. You could travel abroad. And it's, I'm also curious about your eye for opportunity at that age. Like you see the basket weavers and how it becomes an opportunity to export. That's very eye-opening in terms of identification of opportunity. But in this same period, you learn something very deep, that you can go and sell products, make 300,000 Kenya shillings. You spend all that money because you've not, you spend all that money because you've paid the suppliers, yes. But you come back and do the mathematics and find out how unsustainable it is because you break the money down and spread it across the year, and you find that it's actually less than your salary. What do people need to learn from HAPA in terms of lump sums and how to deal with money? Now, as we qualify money at a certain age can be a disaster.
Numbers are very important for any business. Numbers, Dr. Kingori. You must appreciate how many people watch my program. How do people spend time? When they are not watching my program, what is it that they are doing in any other place? In my case, a basket. And you remember that I was part of the team that fought plastics in Kenya because of number of bags. Why? It's not just because of the environment. It is because it is also an opportunity for the people to make money. Because baskets that are sustainable will be able to replace the livelihoods of many people in the way they produce, as opposed to a machine that has been brought from overseas to come and do business that can be done by our people. How do you create that? There is no business that can ever succeed if you do not deal with numbers in the best way possible. How much, when you hold this water, is how much people, or how much water does a human being need in life? Where do they get the water from? There are some that get it from the pond directly. There are some that can afford to buy a bottle. There are some that can buy sparkling water and water that is distilled or natural, pure natural water. And there are some that can even survive with any kind of water because they can get it even from the rain and all that. What is my market share that I'm working on? Business is about market share. If the number is 1 million liters per day, you must be able to calculate what is the target of my business, because otherwise every business will be business. You must be able to understand, where can I get, do I pack it in glass? How many people will need glass water? Because every other person, any business they are thinking about is packaging water. What would be the business that I can get if I targeted a specific number? What is it that I can do if I changed the brand of the water to become such water? What treatment do I need in the machine, in my distilling plant, that would add the taste of the water? What is the story that I can give about the water so that somebody touching the bottle like this is Dr. Kingori. This is not water. This is water from Dr. Kingori. For that Dr. Kingori story, I will pay an additional 20 shillings because you targeted. And you keep marketing, you keep looking at your market share. It doesn't matter that it is 0.0000001%, but that is your start. What is the difference? And how am I getting to these people? Am I marketing my water in weddings? And therefore, it must become my process to understand who is about to marry. Where is the wedding? Not by looking online, that could be one. But can I check what is the system to get these people? What is the network that I can use that will be able to take me to where people are buying water? For what purpose? Why, which hotel can I go? Do I go to Mercury? Do I go to this hotel? Are they making water? Why do they make water? What is the unreliable processes? What is the government tax in all this? Numbers. How many people can I have so that I can sell a story? Because water is life, and life is my business, and my business is to transform people's lives. You must be able to take life at a level that everything you must watch critically. That is what green is about. There is no business. I mean, I went in 2000 and in 1991, I was in Japan. I made all the money. I squandered it because I did not know about staying in the hotel and not knowing that the drinks would be paid. I lost the money. What lesson did I learn out of that? The following year, I was in Taichung, Korea. I made money. I took it to a different level. I trusted people. There was mistrust. I lost money. The following year, I was back in Japan. I lost 5 million order in 1992 because I did not calculate what needed to be done, including time. There are many aspects. How much risk are you dealing with? You could do your good water. You have not done your insurance in transporting this. The truck gets an accident, it gets into a flood, and you have lost the business. How are we managing the risk of our business? Waking up, finding money in the account is not enough. Which bank are you working with? Does it understand your vision? The bank is not just to receive money and to keep money or to give you money because you have written a check. It is their responsibility as a financial advisor on how you can grow your business. Are you engaging your bank to tell them that the money you see in my account needs to be supportive of what I want to do? How can I do? They will tell you, put this in fixed deposit here. We will guide you. There is something that is called Know Your Customer, KYC. What is it that you're there? They're not just coming to confirm your residence or your office where it is. No, it is understanding the need of your customer. How much time are you taking so seriously to make the institution in the bank to understand what you're doing so that they can be of help? You need so many people to support your business. Just doing business will take you very far, and you may not need any other business because the water will take you where you wanted to be, because that is what life takes you. So numbers, and that is what you learn out of my story, that I made a mistake here and I can be able to correct it here, and I can be able, there may be a line that you don't need a glass bottle, because this is for the Kingoris in their big space. I need water in plastic, paper, as cheapest as possible, because your market is different, your segment is different. There are people who just want the water because the bottle is shining, and then you pay more about that. What is it the world is doing? Today there is the AI. How are you using it to advance the opportunities? What is in the name of the business that you're doing? What project are you attached with in life? I'm just talking about that. So it's about numbers. Everything, the importance of numbers, even when they don't make sense. How much water is lost? Why is it lost? Just talk about water. By talking about that lost water that is there, you're talking about selling your thing because your passion is in business. Many people fail to succeed in business because they failed to focus on the numbers around their business, the opportunities that they have. Because that, when you wake up, when you sleep, when you're talking, when you're walking, directs you to what you need to achieve in life. So to answer your question, is about numbers, is about being focused on what you want to achieve, and make sure that your goal is well defined, so that when people are seeing you, they see Kingori is that media guy, from the wicked edition to what it is today, so that they can be able to succeed. That if I want to get 1 million people, I will not go to start my podcast. I will partner with Kingori, because I will get my 1 million people, and they will get to know my story. And I will support Kingori because that is the right thing, because I can be able to do that. Many businesses fail today because people want to start what somebody else started, instead of conjoining and dealing in the best way possible that you can be able to do in business.
Solid. You also have an ironclad, if I can describe it as that, an ironclad self-esteem. Your relationship with rejection is special. And you write about it in very many contexts and very many ways. But when I look at your story and how you deal with rejection and confidence, one of my highlights is where you talk about, you don't know where the next gig is coming from. You have dealt with disappointment and you have a special relationship with disappointment in your earlier years. You've almost given up, and I think the statement that pokes you kabisa is when your wife asked, compared you to other men, what other men are doing. But you see, at some point, you'll just chill and you'll wake up, go to your office, but you look nice. As if you upige look. Eh? And when I read that, I was like, sasa into Nairobi. Like,
I said Nairobi inaweza kukuchonga. Nairobi.
Nairobi inakuchonga.
Nairobi inakuchonga. Unajua Nairobi ni wapi wewe? Nairobi ni mahali wale wasee wanaingia. Au unafika kwa nyumba unapata mlango ilichomolewa. Unajua you are talking about notice. In this city kuna wasee wanaingia kwa nyumba daktari. Wanapata mlango ilingolewa ikakelewa juu ya nyumba hapo. I had this story. I could not believe it. A guy told me that, you know, my landlord, he used to live in Mukuru kwa Njenga. And he tells me that, I say, mimi huenda kuoga, tunaogeanga nje. Unaogeanga kwanza kichwa ndani ya nyumba. Alafu namuuliza, why? Sababu ukijaribu kuogea nje, saa ile umejipaka sabuni kwa macho, karai imehama na maji imehama, because both are very important commodities. Hiyo ndio Nairo kanachonganga wase.
Yes.
Unapita unakuta saa zile hiyo hakuna matope umemwagiwa, hakuna nyumba hujalipa, hao boss amechelewesha mshahara, nini imefanyika? Yani unachongeka. But one thing that I believe, and I have always believed, and I have demonstrated in the book, just be yourself. Appreciate that the situation that you are in today is your situation and it's not going to be permanent. In Kikao, we say they now wake kwiliti andoa. Trouble only makes you muddy and, you know, in a situation that is unmanageable, but it doesn't kill you. The moment you appreciate that, you become very easy to deal with. And it's not about what other people are telling you about. It is about you yourself. Okay. How you believe yourself from internally. So kungara, unapiga luku. Mimi nilikuwa nainua mpaka briefcase bwana, nainua unatembea na mguu kilomita 6 kutoka Doni, kutoka mali inaitwa sehemu za Islands.
Yes.
Kutoka huko unaingia mpaka Tao, hauna kitu, na unarudi kwa bibi yako unamwambia umerudi. Na unajua ni kubaya. Na hakuna vile, you know, my father told me, kuna kitu yenye huwezi fanya kama ukiwa mwanaume. Usiwahi kusema kitu haiwezekani. Usiwahi kujipata. Because you can make a mistake of saying that this is not possible in front of your wife. Na yeye anajua wewe ndio mwisho wa dunia. Alafu useme utapata umededi. Because you are the hope of the family. So you must keep hope alive at any moment. Piga suti yangu na beba briefcase yangu na ingia Tao. Na cheki tu naangalia tu opportunities zinaweza kuchomoka tu mahali, lakini hakuna wana umerudi. Wiki nzima umerudi. Lakini bado uko pale. So that is one of the lowest things that I always laugh with my wife.
When I uko na moments zote. Uko na low moments zote. But then it begs the question, una sink, and then something pops up.
Yes.
Which begs the question, when you, for the opportunities that you burned, let's say for example, you go to South Korea, you make money. You go to Japan, you make money the first time. And if, for example, could you have had the relationship you have with money today if it was not for the mistakes you made? Like, is there an alternative rather than the sinkings and the ups and downs? Like, was there another way you could have learned other than from the experiences you had?
I don't think so, because right now I'm cleverer. The moment you find that you're making money and you don't know where you're taking it for and why you're making the money, then you imagine that you have a lot of money, because then it will be the cash in my hands, in my belt, in wherever, in my money bag or in my account. And therefore, it would make sense because I have it and I don't have the plan. Today, when you have all this experience, whether you make 100 million or 100 billion dollars or whatever it is in billions of dollars, the moment you understand why you are making the money and you have a plan of where it needs to go, you never have enough money. Because it is about what you're doing. One thing, you just must be satisfied with what you have. As long as you have money for your food and you can be able to drive or get to work, that first of all is minimum that you must have.
But if you have money
beyond that, yes,
if you have money beyond that, there's a problem somewhere.
It should never enter into your house meaning into your mind, because you know that you are in this business of being a blessing to your people, and therefore you have this business that is waiting today. Why do we have the Green Africa Economic Zones? Because I still have space that I want to put money there whenever I have it. Why do we have the Green Institute of Pragmatic Knowledge? It's because I want as many people to learn. Why do we have more than 10, 14, 18 different companies in the Green Africa Group? Because each institution is growing at different levels. Is what is giving and feeding the other and financing
no idle money. No,
never.
I have
Never.
100 million.
Never. And this applies as a principle that applies whether you are doing one single business that is worth 10,000 or you are doing 100 billion business, because there is what you have planned to be able to do, and therefore you never have money that you can think about.
What about the emergency fund?
That must be there as a principle, that you must have a certain percentage and a good percentage that you can access in cash whenever you can be able to access. But being there and that you have been able to do that means that it is stuck at that level, and as you increase, that kitty increases, because you already know that minimum of 30% of my wealth must be in cash, and you must be able to have it accessible, liquid, not just having properties, because you will have a big problem of what you will need to have in future. And therefore there are principles that are there, tools that you must be able to learn, and they're there in the Green Africa, in the Green for Life book, and many other training institutions that you must have. These are things that must be there, and therefore it means that you must liquid some of the items to be able to put in this, whether in stocks, whether in different areas that you must be able to apply. But the essential thing is having the numbers right, is employing what is depending on what you want to achieve, the goals, and you know where to put your money, when, how, and when to shift, because you want to increase your 30% if you have to do that at different levels, so that you can be able to grow. And therefore, you don't have idle money, because why would it be idle?